All right, guys, I think I found the problem. Please tell me if you can hear me. And if you heard any sound from the intro at all. Okay. To me, the bars are going off and it looks like actually the sound might be going through. But I just need to see if you heard the intro at all. Oh, you can. Thank you, Crazy. Did anyone hear the intro? Okay. Karen, can you tell me, did you hear the intro when it played? Okay, the intro, you did hear it. There was music and all. Did it have sound? Oh, now for the trial, I'm probably not going to put the banner up, Liam. But I will in between. How's that? Like a compromise. But once we go live, I don't know about the banner. If it interferes with the trial, we'll see. If it's in the way, intro just a bit. So you did hear some of the music? Okay. Yeah, Leo. I know, I'm just playing around with it. I'm not sure. I'm not sure what I want to do with it yet. But for now, I'm going to keep that up to wait for them to actually go live. And then, as you guys know, those of you that come to watch with me, I like to record these for prosperity, so we have a lot to talk about, what actually happened, what actually got said. We've got it all documented. Also, ask questions during breaks and during the lunch. I do believe this is a full day hearing. It is scheduled for 3 full days. Rumor has it that Becky Hill may be testifying. It's supposed to be in the afternoon. That she may be questioned in the afternoon. The judge will be pulling questions. But I also wanted to let you know that already, after Friday's closed session for a juror who could not make it Monday, the juror needed to be seen without all the other jurors, at the same time. So it had to be done on a different day. So they closed that session because they didn't want all of the other jurors to hear the questions and to, have advance notice, or anyone else, or to have any information out there. They want, because the jury's been sequestered, against each other. So they can't confer, whatever. They're going to get asked their questions straight. And that seems the fairest, most reasonable thing to do. But anyway, Dick Harpudulian has already sent a letter to the judge complaining about the questions that were asked to the first juror, because of course they were in the private session. I'm going to give you guys the copy of that letter. Hold on one second, and we'll put it here in the chat. Basically, he didn't like the idea that the first question, which to me seemed reasonable. I'd like to know what you guys think. Well, it seemed quite reasonable. That the first question that was asked was that was that would they was the verdict that they rendered still the verdict that they agree with? I don't know why that switched to this. Okay, they were looking at the okay. I'm just going to keep an eye on the other one too. Just in case. I've got my eye on two different streams just in case, so we do catch it at the beginning. Um, but anyway, the first question that they asked was, "It was your verdict that you rendered back in whatever date it was." I don't want to give the wrong date, so I'm not going to say. Is that still the verdict that you agree with? Like, have you changed your mind? Did something happen? Like they didn't say, did you change your mind, or did anything happen? They're just saying, is the verdict that was rendered the verdict that you want to say, you know? And I think that's a reasonable question, because that kind of knocks a lot of the doubt right out of the box. If the jurors takes the stand and says, I gave the best verdict, I just say they said guilty. Like, okay, I gave the best verdict that I could. I said guilty. I have not changed my mind. I still say guilty. You know, if they do say they changed their mind, is it because of something Becky Hill said, or all the coverage that there's been? Hey, look at the trees. Welcome. And to everyone else I didn't say hi to personally, welcome, Commander, Liam, Karen, um, Crazy Cats. It's nice to have some company, so I'm not talking to myself. Thank you very much. Okay. All right, then they're bringing Alex into the room. There we go. Now this one, I have the sound all the way up, but they don't have their sound on yet. Let me just check the other one. I have the sound all the way up. Okay, this one. Okay. Yeah, there's no sound yet on this one. Hold on, let me just check the other one. No, there's no sound on the other feed either. Okay, just double checking. Sorry, I'm talking to myself as I work things out. Sorry, guys. Mm. Yeah. So anyway, so Alex is being brought in. This is Richland County. It's not the same courthouse that we had before in Ada County. This is Richland County. This will be Judge Toal. Okay. And in the description, I've listed the wiki for Judge Toal and her Supreme Court um leanings and advocacy that she was doing. She came out of retirement for this. She was assigned. She was on the list of taking special assignments, which a lot of retired judges will do. I know. The skylight on the other field. I don't know why they did that, Karen. Like that's why I changed the feed. At least we could see him coming into the room now. You know. And we see Dick Harpootlian and Jim Griffin, of course, and there's Philip Barber, our defense team. I will make it bigger once the process starts. But like I said, I'm just waiting for the sound to come up. They do keep the sound off. Yeah, I don't hear anything from either feed. When it first comes through, it's probably going to come through very loud because I have both feeds up, but I'll try to catch it immediately and just bring the one up that matters. Hopefully, there won't be a lot of reverb. Yeah. Mhm. He does seem to be in a good mood, doesn't he? Yeah. Mm. But anyway, the link that I dropped you to the Google document, which is the objection actually of the defense team to some of the questions that were asked of the juror on Friday. I don't know what's going to happen in the beginning. I mean, there might be some motions in regards to that. Okay. Mm, yeah, I don't know. He does look a little, but he's very fair. And being a fair person myself, I'm often tinged pink. We just flush. We just flush easy with the heat, with just about anything actually. You do like to see him in the orange jumpsuit, Liam? I know. Yeah, that's not going to go away. No, because remember, even if they do get a new trial for the murder, he still has actually confessed and pled guilty to all of the financial crimes that he's been sentenced to, and he's going to be away for quite a long time with those. Yeah. So I mean, he's not getting out. All right. There's AG. There's the AG Wilson. Okay. All right. And let me just pull up my other. The other thing that I wanted to give you is that there is an actual link to all the documents in regards to the retrial hearing. Okay. No, I'm not going to because it is actually resources. I'll have to, or it is down below. linked in the video description. You can grab it there, but it will give you all of the filings that have been done back and forth between the state and the defense, just so that you know that what the original complaint said, what they're actually trying to address here, how they feel that it was improper, what Becky Hill said, all of the evidence for it, and then there will be the answer from the state back and forth with their evidence, with all of the juror questionnaires and the response from multiple jurors. It's also important to note that several of the jurors are represented by counsel, that they feel that they've been pushed, and they don't want any trouble. You know what I mean? When Dick Harpootlian and Jim Griffin took to the mic, and made these complaints, and they actually said that jurors should maybe perhaps consult with a lawyer. They actually kind of made people a little nervous, I do believe. And don't know if that was intentional or not, but quite a few of them have learned now. And unfortunately for Dick Harpootlian, the lawyer that some of them have is Eric Brandt, and he's not very fond of Eric Brandt, and Eric Brandt isn't very fond of him. There's a lot of back and forth going on Twitter and stuff with the two of them, next stuff, back and forth. But I don't think there's anything really much to it. It just seems like personal differences on the two of them. They're both very public relations oriented. They both like the limelight. They both like to be the biggest dog in the room. It's probably that. It's probably a bone issue, something. Oh, okay. Still no sound. There's a very big close up of Alex. Oh, he doesn't look so pleased. That I'm gonna pull him up a little bit bigger. Um, it's not looking very pleased. Like you can see a furrow in his that first shot there. Oh my gosh, there is the man who was just touching all the evidence and making me so crazy. That gentleman, I constantly am forgetting his name, but he is actually the lead on this case, not Crichton Waters. There's Jimmy James, okay, John James, okay, Jr., who did a lot of the financial, and of course Samuel Crichton Waters. There we go, Crichton Waters, who did the prosecution in court. However, that guy they called the older gentleman to the other side was the lead prosecutor at the time, or getting everything together under A.G. Wilson in regards to this case. They've all made quite a team. Mm. I'm thinking, is that his sister? Who is that they're focusing on there? No, I don't think it is. I'm trying to remember who that is. Hmm. And no one's talking. Okay. Oh. Hmm. Okay, I do hope that they come up with some sound soon. Even if I could just hear the mullings in the background, the whispers, or like not to hear what they're saying, whatever, but I want to make sure the sound is okay. Hmm. It's a little frustrating if you're waiting for a feed to come up. Hmm. We're just waiting. Hmm. It's like court is packed. County seal. Well, I don't see the county seal up. Like this is actually the courtroom. Like I'm going by, this feed from the news organization that I've used before. And I'm checking with several other feeds and they all have the same picture, you know. I'm just waiting for the sound to come up. Yeah, the county seal, usually the state county seal. I think it has both like together. Like it was on before. Yeah. An albino gingerbread man. Look at the trees. Listen, I don't know. Yeah, an albino gingerbread man. I don't know. Gingerbread men are a lovely color though. They're like a real toasty brown. An albino one, like he's too pink. He'd be like a strawberry tinted gingerbread man. Yeah, they well actually in the beginning of this stream, Liam, they did have the seal up. Yeah, they did. But this all stuff it is coming out of Richland County. Okay, it does look like the judges like coming in. Like they're moving around. Hmm. I wish hmm, I wish some sound would come in. I'll never feel confident until the sound actually comes in. Then I know everything's gonna be okay. Um, but anyway, court was starting at 9:30. Remember, they won't like there will not be a camera on the juror members. I believe they're go. This is all confidential. We will hear what he said, but we will not be able to identify anyone. The privacy of the jurors is being considered. One of the reasons for having this sealed court on Friday was for that purpose also. Mm. I did not. I did get a recording of Friday. Well, not Friday of Kohlberger's. Did a actual hearing that I was gonna go live with, but I actually my throat. I couldn't speak. I couldn't speak at all. So it just was killing me. So I did record it though for prosperity. I'm going to put it up with some comment on it. Hi, Tsunami. Yeah, they don't have sound there either, do they yet for the hearing? Like every feed I check doesn't have sound yet coming through. In yeah, Live Luna has Luna Shock actually has a good feed going too. So does Fitz News. Court TV is the actual main producer of the feed. Um, but I think Emily Baker's going live too at 9. She was going supposedly at 9:30. Mhm. Well, it's nice to see you here. It must really annoy him that he can't wear regular clothes to court. But he's already convicted now, so it's not an option. Now, these are the attorneys for the jurors. Okay, the man with the white hair, he represents a couple of the jurors. Eric Brand represents a few jurors. Okay, prosecution is talking to him about something. John, there. There's no evidence for him to mess up, to touch, without his gloves. How annoying that was during the trial. Hope everything goes okay there, Commander. Hmm. Okay, the court reporter is in place. Hopefully soon. The big difference in this court hearing and in the Shawnee Lynn crawl, there's only one guard sitting near Alex Murdaugh, which is like standard. Like they have to have an escort with them the whole time. In the Shawnee Lynn crawl case, there's been so much threatening of the attorneys and witnesses and stuff like that. He has two guards with him at all times, plus two extra in the courtroom in case anything from the family members or friends act up. I should have sound now. Hold on. Let me just check. I don't see why. Which feed that you checked had sound there? Because I don't have any coming through on either of these two feeds yet. Why is there no sound? There is no sound coming through. I should have sound from which feed did you hear sound, Karen? Because neither of these two. Is there another one I need to go to? I just pulled up Law and Crime. They don't have sound coming through either.
Rise.
Hold on, there it goes. Okay. Can you guys hear it? They just said rise.
Taken to their jury room, and I will one by one call the jurors and address them, and I will address them by a letter that I have developed rather than their number. Now, I realize full well that many of you who attended this trial for many, many weeks probably know these jurors, and I'm not making any further statement about what you do or don't do in terms of identifying the jurors. But I don't want any photographs. I don't want any photographs taken of the jurors by the media. With respect to the rest of the audience, if you have devices, cell phones, iPads, or anything of that nature, please silence them. Please do not use them. The press is allowed to use their devices in order to make notes, but the press is not making any photographs either. I have a pool photographer as well as a pool court TV arrangement, and that's what will be used to photograph, and that those materials will of course be fed and available to the press. I think if there's anything else. All right. All right. The jurors are in place in the jury room, Mr. Bailiff.
Yes, Your Honor.
Very good. Bring me the jurors.
Please, Court, Your Honor, prior to bringing that jury, that has something on the record.
Sure. Hold for a minute. Yes, sir.
Your Honor, you have a list of questions you distributed to us. And
Yes, sir.
of course, you went through those with Juror
Z or X.
X. I knew it was one of those
Yeah.
last letters. Juror X. The third question, you say, did you hear Ms. Becky Hill make any comments about the merits of this case before your verdict?
Yes, sir.
And clearly the juror didn't understand what the word merits meant.
I disagree with that, but you may make your record about that. I think the juror understood what was being asked. And frankly, in some of the materials that we exchanged back and forth about questions, you yourself have used the word merit. So I don't think she was confused.
Well, Your Honor, occasionally I make a mistake. I think in this case, perhaps you made a mistake. And if you would just respectfully use the words, did make any comment about the case before your verdict, just leaves out their judgment about merits. They don't know if merits is a legal word.
I will take what you say into account, but I have already examined one juror using that term, and you now say that that term confused the juror. You have that on the record, and certainly would be able to argue that to any of the appellate courts that review what I do here. But my intention is to use the language that I used with the juror I've already interviewed.
But Your Honor, you went and did a follow-up question, our request, which elaborated on what that meant. And certainly after you asked that question, we think that clarified it, and you could use merits or anything else about the case and deal with both issues. I just think it's going to require us, based on statements that these jurors have given to SLED, to ask very specific questions.
Okay, I understand what you're asking. Let me ask you this, Mr. Harpootlian. Do you happen to have the transcript of Friday's proceedings? No, State, do you all happen to have a transcript of Friday's proceedings?
Your Honor, we're looking right now.
Belay that. I've got a copy. Let me look at it for a minute to see what I did in clarification. And so just pause for a minute. Let me look at that.
Okay, the reason merit is such a big word is because they have to prove that anything said by Becky Hill had merit enough to sway them one way or another. Words, merit is the legal term, meaning it weighed in, and he doesn't like it because they actually have to think about what she said. It's not just a yes or no. Yes, she talked to them. So he doesn't have any wiggle room. And I think that's what his objections are clearly about, the wiggle room to prove their case, because it's on the defense to prove that the verdict was altered in some way based on Becky Hill's actions. He would like it to be any communications, but they have to show improper communications and communications with merit.
Yes, Your Honor.
I'll look at this transcript, and the only thing I note.
Wait, there's
Yeah.
Okay. Okay, these were the follow-up questions.
Okay, all right. I said this, I asked the attorneys for any further commentary about the questions I asked, and I have been asked to ask one more question, and I'm going to do that. I'm going to read you a memorandum by the state to counsel for the defense and then ask you about it, all right?
You got the- mhm.
And then here's what I read. Per Chief Attorney Waters, please be advised that the attorney for Juror X has told us that his client says that prior to the defendant's testimony, his client did hear Clerk Hill say words to the effect of, quote, looks like the defendant is going to testify. This is an important day, close quote. Or, quote, this is an epic day, close quote. And that there was some statement that it was rare for a defendant to testify. And then I said, Juror X, can you verify that what I've read is something you heard and told your attorney? And she says, yes, ma'am. Very good. Do these statements have any impact on your verdict? No, ma'am. Very good. I will ask that question. I didn't change well, I've read you what I asked. I will be glad to do that again.
Your Honor, different jurors say different things based on the memorandums we've received.
I won't say you told your attorney or anything like that, but I will ask about that statement having been made.
Your Honor, just for the record, we believe the term merits is a term of art, just as if you asked him, was there probable cause? Again, or anything else, we're not asking you to open Pandora's box.
I hear what you say, and I will take it into account.
Okay, thank you, Your Honor.
Mr. Waters, anything on your behalf?
I do not have anything further, Your Honor. We believe the term is self-explanatory.
Thank you, sir. Just so you know, Mr. Harpootlian, I'll have to go to my screen to do this other, but the third question will read, did you hear Ms. Becky Hill make any comment about this case before the verdict?
Yes, Your Honor.
Okay, that's what I'll ask. All right. All right, Mr. Bailiff, bring me the jury.
This is-
And that's on my sheet. Yeah, yeah. Yes.
mhm. It's the same thing except without.
Yeah.
Basically.
Jury is seated, Your Honor.
Thank you very much. Good morning, ladies and gentlemen of the State versus Murdaugh jury. I wanted to make a few opening remarks to you before I question each of you about the matter. You have done absolutely nothing wrong. None of you, not any of you. You didn't ask to serve, but you served and did your duty. This was an unusually difficult trial because of its length. 6 weeks is almost unheard of in South Carolina as the length of a case. It was difficult because of the intense publicity and public interest in the case. It was difficult because of the complexity of testimony and exhibits in the case. And you acquitted yourself honorably. So this question today is not about anything you did wrong. Please be assured of that. I respect you and I respect your service. Today, I'm going to ask you to do something that's difficult. This case is unique. Most of the time, if there's some issue about improper conduct or contact with a juror, it comes up immediately. The judge puts questions to the juror and perhaps to the person who may have made a improper comment, and then you go on to verdict. Or sometimes it's very shortly after the verdict is rendered. And again, the judge questions the affected jurors and the supposed interference and makes a ruling right then and there on either a new trial or a mistrial. Now here, we are almost a year after your beginning of service on this case. And that makes it mighty difficult for you to do something I'm going to ask you to do, and it's this. Today, I ask you to focus your attention. What is that? Mr. Bailiff, what is that noise?
I'm not sure.
Is that the sound system doing
I
that?
believe it's the court sound system.
This is the funkiest sound system in the world, so you just have to keep up with it. I've had trouble in every case I've ever tried with the sound system. So, jurors, if something happens and the sound system goes haywire, we'll stop for a minute until it stops. Now, as I was saying, I want you to focus your attention as you answer the questions I'm going to ask you on your 6 weeks of experience as a juror in this case, and on the point in the trial where the judge charged you, and on your verdict as you rendered it on March the 2nd, 2023. That's what I want the focus to be. Again, I know I'm asking a lot to have you cast yourself back into that time, but that's what the questions I'm asking are about that time and not about this time. There has been so much drama about this matter since the verdict was rendered. And my heart goes out to everyone, the lawyers and you who are in this trial. That I can't help. But I've been asked by the Supreme Court to take a look at this issue. The appeal is on pause until I do, and I've got to do my duty as I see it. And you do yours as I know you see it. So I thank you very much in advance for, again, the terrible inconvenience of calling you all back together now. But it's very essential to completing the record about this case and placing it before the appellate authorities as it needs to be. So in advance, I thank you. What I'm going to do now is dismiss you to the jury room, and one by one, I will call you, and I will refer to you by a letter that I have just assigned you that isn't your jury number and certainly isn't your name. You know, these people in the media saw y'all all through the trial. They probably know who you are, but I'm trying to do my duty as I see it when I make your appearance here anonymous to the record. And only the clerk, the court reporter will have a sealed document by me indicating what the key means in terms of your juror number and your name. So I'm doing everything I can do about this matter. But it goes without saying that your business is your own business. You don't have to interview with a soul, not lawyers, not media, not anyone after this matter. That choice is purely yours. And I will respect that. and protect that to the best I can if anything comes up afterwards. All right, you may go to the jury room. All right, Mr. Bailiff, bring me Juror Z.
One other matter.
Yes, sir.
One of the individuals sitting in the jury box had called this, the next jury, liar publicly. I'd ask that that'd be Mr. Bland and his partner, cohort, not sit behind her or near her while she's testifying.
I object.
Well, just a minute.
Your Honor, I object to him speaking.
One moment. We're not gonna have a big colloquy about this. Keep your seat for a moment, Mr. Hartford.
Yes, Your Honor.
Bland, you do the same. Mr. Bender, is there a seat over next to you?
There is.
Mr. Bland, will you go over and sit next to Mr. Bender, please? Thank you.
Thank you, Your Honor.
For the record, I have some people in the jury box. Two of them are SLED agents. One of them is the media consultant, and one of them is attorney for several of the jurors, Mr. Bland. And that's being done at my direction.
Hey, Justice Toal, you have Scott Mongillo, Blaine Richter, also in the jury box.
Very good. Yes, sir. That's fine. All right. Bring me Juror Z. Juror Z, you may take the witness box after you are sworn. Step over here to the clerk and she will administer the oath.
Do you swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you. Please raise your hand.
Juror Z, I will ask you some questions, and there are no right or wrong answers. The truth is what I seek, and that is the truth of what you experienced in relation to these questions at the State versus Murdaugh trial. You rendered a verdict on March the 2nd, 2023. That verdict was read in open court by the foreperson of the jury. And then the court said this: Madam Forelady and members of the jury, if that is your verdict of each and every juror, let it be known by raising your hand. The transcript then indicates that the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate statement about your verdict at that time?
Yes, ma'am.
Right. Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes, ma'am.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
Yes, ma'am.
If yes, what did Ms. Hill say?
To watch his actions.
To watch his actions. What else?
To watch him closely.
To watch him closely. Anything else you remember?
There it is, but I can't remember.
Okay, that's fine. And was your verdict on March the 2nd, 2023 in any way with any, influenced in any way with any communications by the clerk of court, Becky Hill, in this case? Want me to
Yes,
read it
ma'am.
again?
Yes, please.
All right. Was your verdict influenced in any way by the communications of the clerk of court in this case?
Yes, ma'am.
And how was it influenced?
To me, it felt like she made it seem like he was already guilty.
All right. And I understand that, that's the tenor of the remarks she made. Did that affect your finding of guilty in this case?
Yes, ma'am.
All right. Be at ease. Those are my questions are submitted to the juror. Are there any reactions, further questions, and so forth? If there are, and you would like to voice them, I can ask the juror to retire to the jury room. Just tell me whether I need to do that. All right, sir.
Your Honor, can we ask the juror to, we need to put some things on the record.
All right. Take the juror to the jury room, please. Yeah, that's fine. Mr. Waters.
Yes, ma'am. Your Honor, in the affidavit that was given by this particular juror, paragraph 10 said, I have questions about Mr. Murdaugh's guilt, but I vote guilty because I felt pressured by the other jurors. We would request an inquiry as to that, which is how, when this motion was filed, she expressed the basis for her verdict, which obviously this answer is a little different now. So we would request a brief inquiry from the court as to that specific issue.
All right.
Thank you, Your
All
Honor.
right. Mr.
Your Honor, as to two things. The first thing is, he is correct. She gave an affidavit. We would ask Your Honor to let her read her affidavit to refresh her memory of, she said other things. They're very detailed in here. We'd ask you to, and let me hand up to the court a copy of her affidavit and ask you to have her read it before she's asked any other.
What I have here, Mr. Waters, for the record, Mr. Waters, what I've been handed for the record is something now referred to as Z. It was taken August the 14th, 2023. It was sworn before Holly Miller, paralegal for Mr. Harpootlian, and he would like for me to give that to the juror and ask her to read it and then ask her about it. I'm inclined to do that, but I want to hear from you first.
Your Honor, again, if they want to refresh the recollection, that's fine with the state. So we have no objection to that.
Very good. All right, it will be done.
Your Honor, also, we would ask that you not ask the question that, that Mr. Waters asked you to ask because it violates Rule 606B, which provides upon an inquiry into the validity of a verdict or indictment, a juror may not testify to the effect of anything upon that or any other juror's mind or emotions.
What was the question he asked?
If you look at that affidavit,
It's paragraph 10, Your Honor.
paragraph 10,
It's in the very affidavit.
she said she was influenced by other jurors.
Yeah, I'm gonna ask her about that. I'm gonna give her the affidavit and then I'm gonna question her about it.
And we would, for the record, indicate that we object to that under 606B.
Your Honor, from our perspective, she's put an
And
issue.
you're the one that asked me to have her look at this affidavit, but you telling me I can't question about it? I deny that objection.
Your Honor, if it's something that's inadmissible, you should not ask her about it. and that's
Well, you want me
inadmissible.
to admit it and have her examined
No, I
on it.
want you to have her read it to refresh her memory.
We're quibbling, Mr. Harper, we're quibbling about things that I'm not gonna take time to quibble about. My ruling is pursuant to your request, I am going to allow the juror to examine her affidavit, and then I'm going to question her about it. That's my ruling. Your objection is overruled.
For the record, I just want to note, Your Honor, just for the record,
You noted 606. I hear you noted.
in no way waiving anything or opening any door by asking you to let her
That's
examine.
for a higher court than me to decide.
Well, I understand that, and that's why I want to make sure when they read this transcript, there's no confusion. I'm not asking you to put that into evidence. I'm asking you to
Well,
let
I don't
the
see
jury.
how in the world I can question the juror about something and not put it into evidence. You can't have your cake and eat it too, Mr. Harpootlian. You could have been very satisfied with the answers that were already given, but you have chosen to ask about this.
Withdraw the request.
Denied.
Your Honor, all the time we ask witnesses to examine a prior statement.
Mr. Harpootlian, I made my ruling. Please take your seat. All right, bring me Juror Z. Get me another copy.
It's
there.
in here.
Yeah.
It's in here.
Mhm. Yeah. Madam Juror, you gave an affidavit to a representative of Mr. Harpootlian on August the 14th, 2023. And I have this in my hand at the present time. And I'm going to hand it to you. And I'm going to ask that you read it. Tell me when you completed reading it. And then I'm going to ask you some questions. You're going to see 4 little boxes on this affidavit. They are your name and the names of 2 of the jurors. I will strike that out before it appears in the record, just so you understand. Mr. Baird, please pass this to the juror. Take a moment to read this and tell me when you have completed reading it. Yes, ma'am.
I do really like how this judge holds the courtroom. She is not playing with anybody. I don't think she's particularly picking on the defense. I mean, she's also being quite clear with the prosecution, but then again, the prosecution isn't trying to pull no sideshow. She's all business. She's been around a while. She was on the Supreme Court for the state. She retired, coming forward for this, and she's all business. He does look like a manager. I see that. Like he does, but he is the bodyguard there. I mean, the actual deputy.
Very good. The first paragraph, of course, is a statement that you are a juror in the case. Second paragraph says, toward the end of the trial after the President's Day break, but before Mr. Murdaugh testified, the clerk of court, Rebecca Hill, told the jury, quote, not to be fooled, unquote, by the evidence presented by Mr. Murdaugh's attorneys, which I understood to mean that Mr. Murdaugh would lie when he testifies. Is that what your recollection is of that statement?
Yes, ma'am.
Is there anything in the statement that on reflection you think is not correct?
No, ma'am.
All right. Number 3, she also instructed the jury to, quote, watch him closely, quote, immediately before he testified, including, quote, look at his actions, quote, and, quote, look at his movements, quote, which I understood to mean he was guilty. Is that an accurate recitation of your view of the matter?
Yes, ma'am.
Number 4, paragraph 4. Immediately after he testified, the foreperson said Mr. Murdaugh was crying on cue. Is that an accurate statement of what you saw and heard?
Yes, ma'am.
5, the foreperson criticized the former foreperson for handing Mr. Murdaugh a box of tissues when he was crying on the stand while testifying about his murdered son. She told the jury, we cannot interact with Mr. Murdaugh because that's what the defense wants us to do. Do you still stand by that recitation of that conversation?
Yes, ma'am.
All right. Number 6, the jury frequently discussed the case during breaks before deliberation. Is that correct?
Yes, ma'am.
All right. Number 7, toward the end of the trial, Ms. Hill came into the jury room a lot. Is that your recollection?
Yes, ma'am.
Ms. Hill and the foreperson had private conversations on multiple occasions. The foreperson would tell the bailiff that she needed to speak with Ms. Hill. Ms. Hill would arrive, and then she and the foreperson would go to another room for a private conversation. The conversations typically lasted 5 to 10 minutes. The foreperson never said anything about the content of the conversation. For example, she never communicated logistical information after these conversations. This happened 2 or more times, more frequently towards the end of the trial. Is that still your recollection of the interaction?
Yes, ma'am.
9, when we began deliberations, Ms. Hill told us this shouldn't take us long, quote. And if we deliberated past 11 p.m., we would be taken directly to a hotel. We had driven from our homes that morning and were not prepared to stay overnight. Additionally, smokers on the jury asked to be allowed to take smoke breaks, but they were told they could not smoke until after the deliberations were complete. Did you hear that?
Yes, ma'am.
Including the business about the smokers?
Yes, ma'am.
All right. Number 10, I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors. Is that an accurate statement about your verdict?
Yes, ma'am.
After the verdict and immediately before sentencing, Ms. Hill pressured the jury to speak as a group to reporters from a television show. Is that an accurate statement of what she said?
Yes, ma'am.
And did some jurors decline to do that?
Yes, ma'am.
Uh, yeah, let me get back. Where are my questions? Juror Z, I asked you previously, was your verdict on March the 2nd, 2023 influenced in any way by communications from Becky Hill, the clerk of court? You answered that question, yes. In light of what you said in the affidavit, which is I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors. Is that answer that I just read a more accurate statement of how you felt?
Yes.
Overruled.
Yes, ma'am.
All right. So you do stand by the affidavit?
Yes, ma'am.
Very good. Thank you. All right. You may go to the jury room. And let me just explain to you what the procedure will be. I'm calling the rest of the jurors, of course, one by one. When I'm finished with that, I will bring you out as a group one more time, and then you're free to leave. You don't have to stay. Okay? Very good. You may go to the jury room. What's that?
Before this juror is excused, but after she steps out, I'd like to address
All
the
right.
court.
All right. You may be excused.
Your Honor, just very quickly, I do have a redacted copy I can hand up to the court if you want to make that use of the court's exhibit, please.
That's good. What I'm going to try to do is redact as I did in the as you did in the document that you sent me. The identifying thing redacted now.
He has an extra copy of the redacted.
I have it
Oh,
right here.
oh, good. That's great. That would be wonderful. Show it to Mr. Harpootlian.
I've seen it.
Very good. Thank you. That's the one I will give to the court reporter, but I think you can see that I asked off of it. This is a court's exhibit.
3.
Court's exhibit 3.
Your Honor, just to be clear, that does still have the juror numbers in it. It does not have the letters.
All right. What I'd ask you to do, Elizabeth, is take off the juror numbers, just strike them through, and then where it says affidavit of juror and gives a number, just strike that out and you can put in pen Z. Thank you. Yes, sir. Mr. Harper.
Your Honor, we objected to the questioning because this juror gave 2 statements under oath, one in an affidavit and one here to you today. The one here today was Becky Hill influenced her verdict.
Yes.
The one she gave in an affidavit 6 months ago was based on jurors. It could be both. Your Honor picked out the one in the affidavit from 6 months ago and said, is that a more accurate statement? That presupposes and suggests to her what she should say. And we believe that this juror's testimony, and Your Honor, I'm afraid what you're going to say is, well, she said the affidavit was more accurate than what she testified under oath here today, and therefore I'm not going to consider her testimony. And I think that's where we're heading here. I'd ask you to bring her back in, explain to her there's nothing wrong with it both being true.
I decline to do that and overrule the objection. All right.
Okay, like I don't understand why he's arguing that. Maybe one of you guys could give me a little hint. He's actually arguing the point that we should take the affidavits that she gave, which were not signed, that she gave to a third party, the law clerk from his form, as the record instead of what she's testifying to in front of a judge under oath as a matter of record and law. Why? Why would he make that distinction? Because he doesn't have control over what the jurors are saying, that they're going to tell the truth. They're under oath now in front of a judge without influence. That just made him look bad. I think that just made Harpo and the defense look really, really bad. Good morning, Charlie. But I want to know what you guys think.
Counsel, I have to report this to you, and I'm very, very unhappy about it, but there's nothing to do but put it on the record, and then I will proceed with questioning the rest of the jurors. The jurors' cell phones were not confiscated or taken from them, and they tuned this thing in on court TV and listened to all of what just went on. So you may make whatever statement you like to make, and then I'm going to go on and question the jurors. I will tell you in advance, I am not going to stop the proceedings or do anything to interrupt them. I'm going to get the rest of this on the record. You might imagine that they no longer have their cell phones with them.
Your Honor, we have a 5-minute recess to discuss what we need to put on the record. I mean, this is.
I'm not going to take all day on this thing. I report things as they come to me. I will give you a couple of minutes, and then we're going to. They were late getting here. I didn't get to start on time like I wanted to, so I need to just calm down a little bit. But I tell you, don't take any long period of time. Court will be in recess for 5 minutes.
Okay. Our judge really knows how to hold her courtroom, and she's not having any shenanigans. Okay. I do realize that, Harpootlian wants all of the testimony on record because he made his complaint based on the affidavit and what the jurors said. And he really wants to persuade them. But there's no persuading a jury here or an audience, only the judge. And what he's doing is actually pushing the judge to think that he doesn't, he's just trying to PR this thing, not real question, to actually get rid of questions that were valid. It's I don't understand. What happens in the hearing is that the testimony is entered into the record under oath. Everything that Dick Harpootlian submitted in his complaint that jurors said was not under oath, so it cannot be considered in regards to the retrial hearing until it's entered under oath. And I understand he wants that testimony in there, and that's why it was read. And that's all great. But to say that it doesn't matter, to say that the testimony she gives today doesn't matter as much as what she said prior, just shows he's being prejudicial and biased. He's trying to hide some kind of truth, in my opinion. It makes me very suspicious of what is he trying to hide. What does he not want said? Oh, I'm sorry, Charlie, about the car. Oh, yeah. Are you good with that? Like, can you change a belt and stuff? Yeah. Oh, I kind of think you would be really good at that kind of stuff. Mm. Yeah, Liam, about those phones, like that's going to be an issue. She's really, really upset about juror privacy and stuff like that. Okay, so all right. See, this is the seal. I think this is a. Let me see if I make it bigger if I can tell. It is it is for the whole is the whole state and the county together. Okay, there you go. That answers that question from before. Mm. It's nice to have a few of you here to talk to during the breaks. Um, but really, what do you think about that, guys? Like, I think it's a matter of record and law to have the testimony that appears today be paramount. That's why the judge is doing the questioning and not the prosecution or the defense. This is not a trial of spinning. Like, this is not, going out there with a mic in front of the media. This is a matter of record of law, and they want to make sure that no violation in the jury process happened. Liam, I'm not so sure about her either. She seems a little wishy-washy, but her testimony is that she was influenced. And I think just on that testimony enough, I unfortunately, like Pete, believe that there will be a retrial. And I say unfortunately, but in a way I'm happy because, well, not happy, but I know it's necessary because the jury process is so sacred. We cannot have any innuendo of something being influencing it untowardly or inappropriately. Okay. And even though she does sound wishy-washy and maybe even a little flaky, maybe that's why it was easy for the defense to get this statement from her. Or maybe this are 15 minutes. Who knows what she's thinking? It could just be true that she does feel influenced. That when they said that, she took a second thought and said, "Oh wow, the guy's, is he guilty? Like, I don't really think he's guilty, but everybody seems to think he's guilty." Like maybe she did, you know, maybe she did, you know. But it needs to be that there is just there has to be no doubt in the jury process. Any whiff of inappropriateness needs to be checked out, which is why we're having the hearing, of course. Okay. Not just because Harpootlian did the grandstanding and they did the press conference or whatever, but because an accusation was made that the jury could have been tampered with. That needed to be checked into, and they are. And the accusations were as such that juror members came through and said that they may have been influenced in their decision. This is why we're having the hearing. And just based on this one person's testimony, it only needs one. She clearly just told the judge that she was influenced by the statements, even before they got to jury instruction, that she was influenced by the statements before Alec Murdaugh took the stand. Yeah, the clerk has a lot of issues, okay? Definitely. And a lot of them don't have anything to do with the jury tampering. And of course, she's under a spotlight right now, and everything that she has done is going to come to light. And she's obviously, for such a well-liked clerk, she rubbed people a little bit the wrong way in regards to this book deal and her fame and, the whole being in a trial that was actually, out to the media, one of the biggest high-profile cases of the year, the biggest one in South Carolina, obviously, the media attention, the popularity, of course, it's going to be people targeting her that didn't get the same. I actually think the egg juror has it out for her because she got removed from the jury and she really wanted to be in the jury. I think that basically her affidavit was all sour grapes. All right, here we go.
Just a minute. Now, you about to do something that I've already said I'm not going to allow to happen. And that is, you've got standing next to you a member of the team that represents the juror. And I can tell you, Mr. Harpootlian, I made a ruling early on that when Mr. McCullough was in court, when Mr. Bland was in court, that I was not going to allow the attorneys to participate in formulating the procedure for this hearing. But I have not, I indicated that I would not allow the lawyers for jurors to participate in this hearing. And so I'm not going to do that. I can just tell you that. And if what you want to do is by indirection tell me what the lawyers for the juror would say, I'm not going to accept that.
Your Honor, my understanding is she'd like to approach to ask if the juror can be excused.
No, not yet.
Your Honor, I actually approached,
Now, Mr. McCullough can be excused. There's still plenty of you lawyers and you can do it. I didn't want him to come to begin with, so I love him dearly and he can go anytime. And I speak on behalf of Amy McCullough, his wife, when I tell you that.
Your Honor, I actually was here to let both of them know that I was going to ask to approach to talk about a security issue
All
very
right, well,
quickly.
come up here. Lord knows, I tell you what, Murphy's Law. What can go wrong will go wrong at the worst possible time, and Murphy was an optimist.
Okay. You know what? It's Monday, and everybody knows I hate Mondays. But this Monday, I am so glad I got up. Sore throat, coughing, all of it, congestion, because there's just something that's tickling my funny bone in watching Harpo get schooled repeatedly for his shenanigans. This is great. You know, Judge Newman was so patient with the lawyers. Okay, this judge, she doesn't need to be. She's there to get a job done. And it's not their playhouse. It is not their playhouse today. It is hers. And she's ruling this room. And I'm loving it. No, she not playing with Harpo. And you know what? He just keeps getting that look on his face. If you go back to the beginning of the stream when she asked him, well, do you have it? Do you have an actual transcript of what you're talking about? And he was like, like she just got him right where it hurts. Like, if you're not prepared, don't come for me. Like, and you better have a valid argument, because I'm not playing this what does it look like, what does it sound like game. This isn't PR. This isn't public relations. That's for afterwards when you leave the courtroom and you get your mic and you go to the media. Do all that shit out there. Don't do it in here in my courtroom. And she didn't say that, but that's the vibe I'm getting. Anyone else? That's the vibe I'm getting. And I think she really wants to protect the matter of law that exists here in protecting the sanctity of the jury process. Everyone in the court system should be in regards to that, just protecting that process. And she seems adamant about it. And I think that she's doing a good job. Alex stole my report. No, Pete. It was Bubba. Bubba stole well, maybe Bubba stole it from Alex. Okay, yeah. Bubba forgot to bring the affidavit or the transcript. Bubba forgot to bring the transcript for Harpo to attend court today. Yeah. Bubba does not have Harpo's back. Pete, you just made me happy. I got to say Bubba. It's a Monday. Forgive me. I get a little silly when I don't feel well. Mm-hmm. There's egg yolk on it. Yeah. There's always a Bubba. Hey, Sean. Good morning. Alex stole Bubba. Yeah. I know I miss Bubba. Like all the Bubba jokes and the Bubba memes, there was one of the best trials I covered with a lot of you. Most of you here in the chat right now were with us for that trial coverage. And I have to say, boy, that was like a hell of a good time. Just going over everything with everybody. I can assure you, if they allow the retrial to be recorded, we will definitely be covering that one too. And I would imagine as a high profile case, it will be. I mean, there's a reason that Jim Griffin and Dick Harpootlian are still representing this man. It's a high profile case because it ain't the money. They've already been turned down by the receivership to get more money. You know what? Look at the trees. That's pretty cool. A Boba. Boba was the beautiful yellow lab. Yeah. Anyway, I wonder what this security issue is, but she's taking it serious and she's back. And I'm muting. I ain't messing
Please be
with
seated.
Judge Toal.
Let me place upon the record two things. First of all, I have made certain now that a bailiff will be in the jury room with these jurors. Why that, I announced that many times, that is the way it was to run. Why there wasn't a juror in the jury room is something I don't know, but I have asked that that be followed rigidly. I've also asked, I don't go into jury rooms, never have and never will, but I asked the bailiff to tell the jurors that they are not to discuss any testimony that any of them are giving. I asked Juror Z whether she was comfortable because I would be glad to place her in a separate room so that she's not set upon by the rest of the jurors. She gave me a big smile and said she was perfectly comfortable. And I said, at any time you're not comfortable, you simply tell me and I will have you placed in either my office or another jury room. So that's where I left it with Juror Z. I think she's fine, but I just wanted to make sure of that. And again, on the record, the conversation I had with her was outside the jury room. I don't go into the jury room for any reason. Very good. Mr. Bailey? Yes, sir.
For the record, Your Honor, we would ask as jurors are brought in, we would ask that you ask them if they watched or heard anything this morning from their cell phone or other jurors about what occurred in here this morning with Juror Z. And if so, what was it?
I'm going to say, ask each one of them something about this. Whether it's exactly what you want, I don't know. But I will ask them something about this or make some direction to them about it. I'm not going to get into who shot John about what they said in that jury room today. I'm not going to do that. But I will try to, as best I can, deal with this question of who of them hearing parts of the examination of Juror Z.
Your Honor, this morning, I think you already instructed them not to discuss these matters among themselves. So if they have violated that, again, I think it's important for you to make that inquiry.
I'm going to make it as I see fit.
Thank you, Your Honor.
Yes, sir. All right. Bring me Juror C. C.
I'm taking a risk in unmuting while they bring the jury in. I don't want to get this judge pissed off for sure. I would never talk over her. Yeah. But yeah, Harpo's trying to tell the judge how to do her job, like she needed any instruction on making sure that the testimony didn't get contaminated. She seems to know what she's doing. She was a Supreme Court Justice, Harpootlian. You spoke very highly of her previously. And this is one of the judges you recommended to come forward. I think you should really take a seat and not try to school the judge on her responsibilities. Like she wouldn't do it. Woo.
The testimony you're about to give today, be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
I will address you as Juror C because I've designated from your juror number at Colleton to letters of the alphabet. I'm trying to protect the anonymity of the jurors as best I can. I can't promise you with all the time that they spent seeing you all in the trial of the case that they won't figure out who is who. But on my record here, which is all I can control, I will address you as Juror C.
Yes, ma'am.
And before I begin, I understand that there may have been some cell phones activated in the jury room and the watching of the questioning of Juror Z. Did that take place?
I know people were on cell phones, but I'm not unsure of what they were watching.
Were you on a telephone?
No, ma'am, I was not.
Very good. I don't think I have to go any further then. Thank you, sir. You rendered a verdict on March the 2nd, 2022. The verdict was read in open court, signed by the foreperson of the jury. And the court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your hand. The transcript then indicated that the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes, ma'am.
Was your verdict based entirely on the testimony, evidence, and law presented to you in the case?
Yes, ma'am.
Did you hear Becky Hill, Clerk of Court for Colleton County, make any comment about this case before your verdict?
No, ma'am. I wasn't privy to any of that.
All right, sir. Was your verdict on March the 2nd, 2023 influenced in any way with any communications by the Clerk of Court, Becky Hill, in this case?
No, ma'am, it was not.
Very good. That completes my questions. You may retire to the jury room.
Wow, Harpo jump up. He's got nothing to complain about that one. So far. It is her intention to get through all the jurors this morning and then to bring Becky Hill in the afternoon. This hearing is scheduled for 3 days. Well, we shall see how long it actually takes. It is going quite well. Well, she has to go through all of them.
Bring me Juror F.
Mm-hmm. It's important to note that even if the majority of the jurors come forward to say that they were not influenced by the statements, they only needed one. And unfortunately, we already heard her say that. I believe 9 Sue, because they are not interviewing anyone who was excused or any of the alternates. It's only the jurors that were sitting on the verdict that actually gave the verdict, because they are the ones who could have been influenced, and it was about the verdict. It's about a fair trial for Alec Murdaugh and about not interfering with the jury process in regards to those particular jurors. Yes. You know what, Pete? There's lots to talk about in regards to a retrial. The whole scenario could be different. Remember, there was 404B testimony in regards to the financial crimes, which he's already admitted he's guilty of. It's a different playing field.
Good morning.
Good morning.
I have designated the jurors by a letter, and that's how I will be addressing you this morning, and I will be addressing you as Juror F. Now, I realize that you folks were on the jury for a long time, over 6 weeks, and people may know who you are, despite my efforts to protect this record. But to the extent I can, I will protect this record and your anonymity as a juror in this record. So just wanted you to understand why I'm addressing you as Juror F. This morning, it was brought to my attention that some jurors were perhaps on their phones listening or looking at a broadcast of the questions to the first juror I examined, Juror Z. Is that something that you know anything about or experienced?
Yes, ma'am.
Did you activate your own phone?
Another juror did.
All right. And will what you saw and what you looked at in any way affect your testimony as you're about to give it?
No, ma'am.
Very good. You rendered a verdict on March the 2nd, 2023, in open court and signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your right hand. The transcript that indicates that the juror complied. The jury was individually polled and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? Each juror answered yes. Was your answer an accurate answer about your verdict at that time?
Yes, ma'am.
Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Absolutely.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
No, ma'am.
Was your verdict on March the 2nd, 2023 influenced in any way by any communications by the clerk of court, Becky Hill, in this case?
Absolutely not.
Very good. That's all the questions I have.
I'd like to discuss the matter with you before we finish with this. Judge.
You may go to your jury room and keep yourself ready. I don't know if I'm going to have any further questions, but as far as I'm concerned, the questions that I'm asking are at an end, but I need to consult with the attorneys before I can dismiss you. You may go to your jury room. Yes, sir.
Your Honor, in interviewing the clerk of court for Barnwell County, who worked as an assistant to Ms. Hill during this trial, and interviewing the alternate juror who was not, wasn't needed, wasn't dismissed for any particular reason other than it wasn't needed. Both of them indicate they believe that Ms. Hill transported this juror by her personal vehicle or a bailiff's vehicle at least once during the trial. So I would ask you ask her, during the trial, did Becky Hill either drive or ride with you in a vehicle before or after court? If so, what, if anything, did Becky Hill and you discuss?
All right, what's your position on that, Mr. Waters?
Your Honor, I have no objection to that.
Yes, all right. All right, bring the juror. This is Juror C, returning to the stand.
Your Honor, that jury,
The same juror. Yes. Thank you, ma'am. Of course, you're still under oath. And I have this question for you. During the trial, did Becky Hill either drive or ride with you in a vehicle before or after court? If so, what, if anything, did Becky Hill and you discuss? Do you recall that at all?
Could you please ask that again?
Ma'am?
Could you please ask the question again?
Sure.
Sorry.
During the trial, did Becky Hill either drive or ride with you in a vehicle before or after court?
No, ma'am.
All right, then I don't need to ask the second question. This will conclude your testimony. You are dismissed. I'm going to ask the jurors to stay with me until I've completed this process, and then you are free to go. Thank you so much.
Can we just say womp 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 for Harpo on that one?
All right, Mr. Harpootlian's question, Juror F is court's exhibit number 4. All right, bring me Juror L.
L is in Lima.
L, as in Lima, yes. Mm-hmm.
Place your left hand on the Bible, right hand up, and face closed.
Do you swear or affirm that the testimony you're about to give in this case today to be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you so much. I have redesignated each of the jurors in the record for this case. And so I will be referring to you as Juror L, as in Lima. And, you know, y'all are all on this jury. If these people saw you for 6 weeks, they may know or be able to identify you, but I'm trying to, as best I can, protect your anonymity. You don't have to talk to anybody about this at all. That's purely your prerogative.
Justice.
Oh, yeah. Juror L, before you came to testify and were sworn, you were in the jury room with the other jurors. I understand that some may have looked at their cell phones and looked at pictures of the proceedings as they involved the first juror who was examined. Did you see any of that?
People had their phones out, yes, ma'am.
Did you look at any of it?
No, ma'am.
All right. And I don't need to ask you anything further about that. You rendered a verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury, and the court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your right hand. The transcript then indicates the jurors complied. The jury was then individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes, Madam Justice, yes.
Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes, Justice. Yes, ma'am.
Did you hear Becky Hill, the clerk of court for Colleton County, make any comment about this case before your verdict?
No, ma'am.
Was your verdict on March 2nd, 2023 influenced in any way with any communications by the clerk of court, Becky Hill, in this case?
No, ma'am.
Very good. Juror L, thank you, and you are dismissed. I will send word back by the bailiff if there are any further questions. I always ask the lawyers that before I dismiss the juror completely and go to the next one. Please know that I will keep you in case there's anything I need to have the whole jury for at the end of this proceeding. Then you're free to go and you don't have to speak to a soul about any of this. Thank you, sir. Anything further?
Nothing from the state, Your Honor.
Nothing from the defense, Your Honor.
Very good. All right, Mr. Bailiff. Bring me Juror E.
He is in Edward.
Yes.
Do you swear or affirm that the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Sir, I will be addressing you as Juror E this morning. I've designated the jurors by letter. I realize that you sat on this jury in Colleton County for a lengthy period of time, 6 weeks or better. And people may know who you are, but to the extent I can make this record a record that protects your anonymity, I am doing that. You don't have to speak to a soul about this matter after you're finished, and your service will be complete, as I'm sure you thought it would be when you rendered your verdict. I have these questions. You rendered a verdict. Oh, yes. It was brought to my attention that cell phones of the jurors were accessed in the jury room for a time, and that some were able to examine the broadcast of the testimony of the first juror called Juror Z. Was your cell phone one of those activated to look at the proceedings?
No, ma'am.
Did you look at the proceedings on any other cell phone?
No, ma'am.
Thank you. Now, you rendered your verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury. The jury then said, the court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your hand. The transcript then indicates the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate answer about your verdict at that time?
It was.
Was your verdict based entirely upon the testimony, evidence, and law presented to you in this case?
Yes.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
No.
Was your verdict on March the 2nd, 2023 influenced in any way with any communications by the clerk of court, Becky Hill, in this case?
No.
Thank you, sir. That completes my questions. You may go to the jury room. I always consult with the lawyers to see if there are any further questions. If there are none, stay at the jury until I dismiss all of you. I'm hoping that won't be too much longer. Thank you, sir. All right. Anything from the state? And from the defendant? Very good. Bring me juror P as in Paul. Yeah.
Do you swear or affirm that the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good morning.
Good morning, ma'am.
I will be addressing you as juror P as in Paul. I've tried to redesignate the jurors without their number and of course without their name. Now I realize you spent 6 long weeks hearing this case in open court in Colleton, and many people may know who you are anyway. But to the extent that I can make this record such that it protects your anonymity, I'm gonna do that.
Yes,
And you certainly are not obligated to talk with one soul about this matter after your testimony is complete.
Okay.
Juror E, I understand that before I began to receive your testimony, that at the beginning when Juror Z was being examined, that some jurors may have had cell phones and accessed the proceedings. Did you have your cell phone?
No, ma'am.
Did you examine any cell phone broadcasts?
There was a couple people, but I have no clue what they were viewing.
Yes, sir. Okay. Did any of this activity by other people in viewing this material have any impact on you in terms of your testimony today?
No, ma'am.
All right. You rendered a verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your right hand. The transcript then indicates the jurors complied. The jury was individually polled and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes, ma'am.
Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
It was.
Did you hear Becky Hill, clerk of court for Clarendon County, make any comment about this case before your verdict?
I did. Yes, ma'am.
What did she say?
It was the day that Mr. Murdaugh was taking the stand,
Yes, sir.
and she made a comment about watch his body language.
About watch his
body language.
body language, I see.
Yes, ma'am.
And what else?
That's all I can recall.
All right, sir. Was your verdict on March the 2nd, 2023 influenced in any way with any communications by the clerk of court, Becky Hill, in this case?
No.
All right. That completes my questions, Juror E. Or P, Juror P. You may go to your jury room. You are free to refuse to discuss this with anybody. That's your prerogative. You're not required to talk about this anymore. that's your business. I've tried to do the best I could to confine this thing, but I appreciate your service. Thank you, sir, and you may go to your jury room.
Thank you, ma'am.
Any questions by the state?
Nothing from the state, Your Honor.
All right, by the defendant.
Nothing, Your Honor.
All right. Bring me juror O. O.
Just stand right here. Would you face the clerk? Put your left hand on the Bible, raise your right hand.
Do you swear or affirm that the testimony you're about to give in this case to the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good morning, Juror O. I have designated the jurors by letter in this record so as to try to protect your anonymity as best I can. Now, I realize you sat on this case for 6 weeks in open court in Carlton County, and many may know your identity. But to the extent I can, with the record of this matter, I'm trying to preserve your identity from any disclosure in this court. Juror O, I understand that several jurors may have activated their cell phone during the testimony of the first juror and looked at the proceedings. Are you aware of that?
Yes, ma'am.
Did you activate your cell phone?
No, ma'am, I did not.
Did you watch any of the other cell phones?
No, ma'am, I did not.
Very good. You rendered a verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your right hand. The transcript then indicates the jurors complied. The jury was individually polled and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes, ma'am, it was.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
No, ma'am, I did not.
Was your verdict on March the 2nd, 2023 influenced in any way with any communications by the clerk of court, Becky Hill, in this matter?
No, ma'am, it was not.
Very good. That concludes my questions. You may return to your jury room. I ask that you stay until I've completed the questioning of the jurors. You don't have to talk to a soul about this matter. It's purely your prerogative. And if you have any difficulties in that matter, let me know.
Yes, ma'am.
You are excused.
Very quickly, I think question 2. I don't know that we did question 2.
Resume your seat. Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes, ma'am, it was.
Very good. You're excused. Thank you, Mr. Water. All right, bring me juror Y. Oh, excuse me, sorry. All right, nothing further, Ms. Waters. Thank you.
Do you swear or affirm that the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Good morning, sir. I will be addressing you as Juror Y. I've tried to re-identify the jurors so as to preserve your anonymity in this record. Now, I know that you sat on this case for 6 weeks in open court, and many have seen you. They may know who you are. But as to the extent I can preserve your anonymity in the record of this case, I have tried to do so. You are completely free not to talk to a soul about this matter. That's always your prerogative. I understand that before you came out here, when the first juror to be examined was being examined, that some jurors may have activated their cell phones. Were you one who activated your cell phone?
No, ma'am.
Were you aware that some cell phones might have been activated?
I was aware after that.
All right. So, did you hear anything about the examination of the first juror?
No, ma'am.
Thank you, sir. You rendered a verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your right hand. The transcript then indicates the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes, ma'am.
Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes, ma'am.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
Not to me, ma'am.
Did you hear her make a comment to anybody else?
Not that I'm aware, ma'am.
All right, so you don't remember any details of any conversation?
No, ma'am.
All right, sir. Was your verdict on March the 2nd, 2023 influenced in any way by any communications by the clerk of court, Becky Hill, in this case?
No, ma'am.
Thank you, sir. That completes my questions. I am going to excuse you. Stay together with the other jurors until I've completed my examination, and then you will be free to go. Thank you so much. Anything further from the state? From the
Nothing from the
defense?
defense, Your Honor.
Very good. This one. Bring me juror W.
Do you swear or affirm that the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you.
Good morning. Good morning. I'll address you as Juror W. I have redesignated by letter the identities of the jurors as I question them today.
Yes, ma'am.
And you sat on this jury for 6 long weeks, and I'm sure that those who were there in the trial for a long period of time may know who you are. I'm just doing the very best I can to make your participation in this matter anonymous, and I will preserve that anonymity. You are free to not talk to one single soul about this if you don't want to. That's purely your prerogative.
Yes, ma'am.
I understand that when the first juror was being questioned, some members of the jury, as you were back in the jury room, may have activated their cell phones. Were you one who activated your cell phone?
No, ma'am, I left my phone in the car.
And did you hear any information coming from anybody else's cell phones about that examination?
I did.
All right. Does that have any impact on the testimony you are going to give today?
No, ma'am.
Very good. You rendered a verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your hand. The transcript then indicates the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? Each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes, ma'am.
All right. Was your verdict based entirely on the testimony, evidence, and law presented to you in this matter?
Yes, ma'am.
Did you hear Ms. Becky Hill, the clerk of court for Clarendon County, make any comment about this case before your verdict?
No, ma'am.
Was your verdict on March the 2nd, 2023, influenced in any way with any communications by the clerk of court, Becky Hill, in this matter?
No, ma'am.
Very good. That is the end of my questions, Madam Juror. You may go to the jury room, stay with the jury until I've completed the questioning, and then you're free to go, and you're free not to say anything you don't want to say. And if anybody upsets you or bothers you in any way about that, you just let the court know.
Yes, ma'am.
Thank you. Any further questions from the state? Any further questions?
Nothing
from
for the defense, Your Honor.
Very good. All right. Bring me juror Q.
Do you swear or affirm that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Good morning. I will be referring to you as juror Q. I have redesignated every one of the jurors by a letter. And in that way, I'm trying to protect your anonymity in these proceedings. Now, I realize that you spent 6 long weeks hearing this case in open court in Colleton County, and some folk may know who you are, but I'm trying to protect your anonymity in these proceedings as best I can. You don't have to speak to a soul about these proceedings after you have completed your testimony. That's purely up to you. And if anybody hassles you about anything, the court stands ready to assist. You rendered a verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your hand. The transcript then indicates the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? Each juror answered yes. Was that an accurate answer
Yes, ma'am, it was.
about your verdict at the time?
Yes.
All right. Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes, it was.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
No, ma'am.
Was your verdict on March the 2nd, 2023 influenced in any way with any communication by the clerk of court, Becky Hill, in this case?
No, ma'am, it was not.
Very good. You may be excused, and if you'll just stay in the jury room till we've completed the examination of all the jurors. Thank you, sir.
Thank you.
Your Honor, very briefly, I know we were doing the cell phone inquiry.
Yes.
With various jurors.
Yes.
I don't know if you wanted to have that with this particular juror as well.
Sure. I understand that before I began questioning you or the other jurors, on the questioning of the first jurors, some jurors in the assembly room may have activated their cell phones. Were you one of the jurors that activated your cell phone?
Yes, ma'am.
All right. And was anything that you heard at that time something that has any influence or effect on the testimony you now give under oath?
No, ma'am.
All right. Thank you. Anything further? You may go to the jury room. For the state.
Nothing, Your Honor.
Nothing, Your Honor.
All right. Bring me juror K.
Do you swear or affirm that the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you.
Good morning. I will be addressing you as Juror K. I redesignated each of you jurors and gave you a letter for purposes of this hearing. I'm trying to protect your anonymity as best I can. Now, I realize you sat for 6 long weeks on this case in Carlton County, and many folk may know who you are. But on the record of this matter, as best I can, I'm trying to preserve your anonymity. Please know that you don't have to answer anybody's questions about this matter in any way, shape, or form, purely up to you. And if anything is done that you feel is harassing or makes you uncomfortable, you contact the court. We'll try to do as best I can to help in that situation.
Yes, Your Honor.
All right. I understand that during the testimony of the first juror, some opened their cell phones in the jury room, in our jury assembly room here. Were you one who opened her cell phone?
Yes, ma'am.
Did you listen to the watch the broadcast of that first juror's examination?
We're on Facebook.
Ma'am?
I was on Facebook
It was on Facebook and you watched it.
and we closed it.
All right. Did anything that you heard in that Facebook cell phone access impact or influence your testimony in this matter in any way?
No.
All right. You rendered a verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your right hand. The transcript then indicates the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? Each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes.
Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes.
Did you hear Ms. Becky Hill, the clerk of court for Clarendon County, for Colleton County, make any comment about this case before your verdict?
No.
Was your verdict on March the 2nd, 2023, influenced in any way with any communications by the clerk of court, Becky Hill, in this case?
No.
Thank you, ma'am. That completes my questions. I'll let you go to the jury room now. I'll then ask the attorneys whether there are any further questions. If there are not, please just stay in the jury assembly room until I give you the word that you are all to come out one more time and I dismiss you. Thank you, ma'am. For the state.
Nothing from the state, Your Honor.
Nothing for the defense, Your Honor.
Very good. This then completes the questioning of the jurors. I will ask the jurors to come into the open courtroom again, thank them and dismiss them. Anything further before I do that?
Nothing from the state, Your Honor.
Please support, Your Honor. I would move for the record that I be able to question Juror Z to follow up on what I believe the court is confused about.
Very good. I deny the request. Anything further? All right, bring me the jury.
Jury seated, Your Honor.
Thank you. Ladies and gentlemen of the jury, that completes the court's examination of the jurors in this matter. I can only deeply apologize to you for having to inconvenience you so long after the trial of this case to come here, and I very much appreciate your candor. There are no right or wrong answers to the questions I asked you, but I think each of you, to the best of your ability, answered the questions, and I am deeply grateful for that, as is the state of South Carolina, as is the defendant. You don't have to speak to a soul about this matter if you don't want to. That's purely your prerogative. If there's any difficulty you encounter about this hearing that I can help with, please contact the court, and I'll be happy to do so. You are dismissed this time. You may go. Thank you for your service. Excuse the juror. All right, Mr. Waters, is the clerk of court available?
Yes, ma'am. It's my understanding she is, and state's prepared to call her when court is ready.
All right.
But I believe she's at a location. Mr. Lewis is here just a block or two away. So if we take a brief recess, we'd be prepared to present her after that.
Well, I will entertain going on and taking an early lunch break. I don't know how long Ms. Hill's testimony is going to take, but if that might be a better thing than hanging around here, I think that's what I would prefer to do. Mr. Harpootlian?
Your Honor, I need sustenance.
Okay. Well, good. I think I would join you in that. What I will do is I will recess court until 1:15. Please return at 1:15.
Thank you, Your Honor.
Okay, well, there we go. Court is on break until 1:15. So let me just pull Mio. Okay, which is an hour and a half. Okay. I think we're going to, oh, no, it's 11:45 here, Liam. And I do believe South Carolina, correct me if I am incorrect, Aaron, but I believe South Carolina is on Eastern Standard. It's the same time. So I believe it's an hour and a half. So that's a pretty long time. I've sent out a couple of links for people to join. If anybody in the chat would like to come up and give an opinion, let me know. I will drop the link. But I do believe my friend Kelly from Coverage with the Marilyn Manson case. Hi, Kelly. You're muted right now. I don't know if you see.
Hello.
Hi, it's so good to you. I did not know you were interested in this case. I would have hit you up earlier. This is
Oh my
something
gosh, of
else.
course. Yeah, I did watch the Murdaugh trial last year. Doesn't it
Mhm.
kind of feel a little wild that it was like January, we were getting ready for the trial, and now it's
And here we are, like thinking about a retrial. And
exactly.
and I know that you also get fascinated, like by some of the point. Oops, she dropped. I'm gonna wait for her. I'll ask her that question when she comes back up. Kelly, where'd you go? All right, Kelly. Just in case, I'm gonna put the link down in the chat. If anybody else wants to come up, remember, yes, just no cameras if you could, that'd be great. But you're all welcome to come. That's what part of this is for. And she dropped. Oops. But Kelly and Kelly does a lot of coverage on Marilyn Manson. And she has been wonderful in procuring all the documents and giving opinion. Here she is again. Hi, Kelly. Okay, no problem. But the legal, I know you like to focus on some of the legal twists the way I do. What is
Yes.
fascinating you about this hearing so far?
You know, I find it just really surprising, this Becky Hill situation, because clearly she knows, like, you can't interfere with the jury in any capacity. That's wrong.
Yeah, and there's so many people around, you'd get discovered, right? Like it seems stupid that
Mhm.
she would do it on purpose. Um, yeah. But then again, the jury process is something that has to be protected
It
at all
does.
costs. And so,
Mhm.
unfortunately, I don't know if you were listening to the beginning, but a juror did say they were influenced by
Yeah.
what she said. And I think that just puts
It's
the nail
very
in the coffin right
unfortunate.
there. Yeah.
It's very unfortunate. And I think, obviously nobody wants a retrial ever, especially a trial of this scale that was so much work and preparation going into it. It was a 6-week long trial. And no one wants to start from scratch, but you have to maintain the integrity of the jury.
Yes. And that whole process, it's sacred. In everyone in law enforcement and in the court process guards it, and especially a judge of this caliber, a Supreme Court judge, a retired Supreme Court judge.
Mhm.
Yeah, it's gonna matter. It's unfortunate the costs. I know we were talking about that in the chat, the costs and what this is gonna do, like the precedent it's gonna set. Becky Hill's been the county clerk for a while. She's done a
Mhm.
lot of cases. I wonder what kind of appeals are going to be hitting, whether they get, have
Yeah,
any
that's
merit or
true.
not is one thing, but it does open up a loophole of did Becky Hill influence that jury? Are they going
Right.
to go and start questioning jurors and disrupting the whole process? Like, it's very unfortunate. South Carolina has a lot of problems right now with their legal system. You hear about it like every day on the news, what's going on in their judicial system. The Murdaugh trial alone was a big black mark
Mhm.
on their reputations. Unfortunately, that family, you know, was so integrated into the area.
They
You
were.
know,
Yeah.
yeah. I loved covering that trial. Yeah, I did.
I did.
But
I thought it was a long trial, and when it ended, I was glad because it just was
Mhm.
so. It kind of felt like 3 trials in one.
It was. It
Yeah.
actually, when you think about it, it really was, wasn't it? Because of all the
Mhm.
404B, and that would be the prior acts and personal kinds of stuff that they don't normally get to enter because it's prejudicial. But it just showed motive in their opinion, and they argued before the judge, and he agreed. And so all of his financial crimes came into play.
Mhm. Yeah.
And
Yeah.
that testimony took weeks on its own, and it was
Yeah. It was
quite
like a
gory.
financial
Yeah.
trial for a while.
Yeah. And he
It's.
did plead guilty to all of that eventually. And he actually admitted it on the stand that he was guilty
Mhm.
of it, but it shouldn't come into play as to whether or not he murdered his family. And he's got a point there. It's quite prejudicial. Just because you're a lousy business person or you steal and you're a thief,
Right.
it doesn't make you a murderer. I mean, they're two different things. Unfortunately, there was other evidence against him. They persuade the jury. Um, but I know this is just so unsettling. I mean, as a YouTuber, I'm excited. I've got an interesting trial to cover again, but I'm also disheartened because it puts a blemish again on the jury process in that things can be corrupted that way, and I hate to see it. I love the law so much. I really hate to see it. Mm. But
Sorry,
you
it's
and
all
I
over the
see it
top.
every day. Well, you and I have the same, like, I don't know if you hear me, but it's like frogs are dancing in my throat and they're not being really
I
nice
know.
about it. They're being very aggressive. Why can't they do a damn waltz? But no, these frogs are in here doing a freaking cha-cha-cha and a salsa. Like, oh, like, it's not
Sorry.
good. It's
I
not
know.
good.
It's just that time of year.
Yeah, it's been weeks for me. It's been weeks. But you know what? In regards to like the trial itself, you and I have covered I've looked into quite a few. You look into Nick Carter, you're looking into Marilyn Manson, and absolutely the corruption in both those cases was paramount and obvious. And I
Mhm.
don't know why more people aren't talking about it. You don't have to like Marilyn Manson, the persona, the artist, but
Exactly.
you do need to make that difference that the artist is not the person, is not the man. Okay.
Yeah,
Brian
exactly.
Warner is not Marilyn Manson. Okay. Brian Warner is separate and it
Yeah,
affects
he's
Brian
he's
Warner's
really
life.
not.
You know,
Yeah,
it's
and
not very
actually, like
popular.
I was working on.
Go ahead.
Well, I was working on something to come out later this week because, we're coming up on 3 years since his allegations. And my whole thing is, at this point, you don't have to like the guy, but come on now, this is getting
It is.
ridiculous.
It is.
Yeah.
The actual, allegations are one thing, proof is another. Okay. And I looked into it hard, and I think like from my coverage in the beginning, my very first video was all about February 2nd when everything came forward. It was all about whatever, all the allegations, everyone coming forward and what they were saying from on all media, on all the platforms, and I pulled all that together, and there were like 16 people who came forward with atrocious stories and this, that, and the other thing. It wasn't until later that they decided to file their charges, civil suits. Let's be clear. They're all civil suits.
Not big difference. Yeah.
And even though they've tried since 2016 to do a criminal investigation on Marilyn Manson, nothing has come forward. Nothing. Okay. And that's a long time. I know the wheels of justice are slow. And I know that law enforcement works slow. Well, 6 years is a long time. You think if they had anything, they would have put a charge on them, especially as high profile as these allegations were,
Definitely. And they it's very similar to kind of this Murdaugh situation is you've got public officials kind of partnering up with the different accusers and stuff. So it's like, how do you preserve the integrity of someone's right to due process? And that's such an important thing. And that is actually why, and I bet you probably agree with me that that's kind of why I love watching actual court cases, reading the actual court documents and civil suits, because, it's almost like the last place on earth that is based in, fact and reality, because the media,
black and white.
Yeah, it's hard to get like a very accurate impression of what's happening in these cases by what the media says.
That's why I have such respect for the work that you do. You feel the same way I do. That written documentation and what actually makes it into the courtroom is what matters, not the media coverage of it, not all the evidence that they put out there ahead of time, because we've all known from the coverage, even what I do and everyone else does, everything's out there ahead of time before the trial even starts. When I started with the Johnny Depp coverage, we knew so much more evidence than actually hit the courtroom. And so we were coming at it a very biased opinion, and a lot of it didn't, I was constantly reminding the chat and everyone I spoke to, it only matters what hits the courtroom. Okay. We can watch the legal finagling back and forth, before the trial and everything. But what gets actually admitted into evidence is what the jury is going to actually go by. And that's what we have to focus on when we're covering, live trial. The evidence that's being presented, the arguments that are being presented, not so much what happened 2 years ago on some interview.
Yes.
Which the media loves to keep bringing up and throwing up. They need their hook. They need their angle. And I realize that sounds like a little hypocritical because I'm out here on YouTube, doing true crime every day of the week and reading legal documents. But I try to do it as honestly as possible. I admit my bias. I'm very biased about the Marilyn Manson case. I think he's getting railroaded. I think the LAPD is a bit corrupt in politically. Evan Rachel Woods had some political ties that she used to her advantage. I was a champion of her in getting rape legislation changed. Okay. And I was a champion of her then. I'm not so much a champion of her slamming a man just to make a movie. No.
No, and it's
not so much.
Because there's a benefit to what she did in terms of the law.
There was the statute of limitations, the preserving of DNA, the giving the actual victims time to press their charges and to come forward and not taking that first do you want to go forward with this? All of the evidence gets preserved now until they decide. Okay. And also it keeps the DNA out of the actual larger database. It keeps it just secure in their own. And I was all for that. It helped in the way rape victims were able to report also in how they were treated and what they were entitled to as far as protections and respect and dignity in that process. So I give her great credit for that. She was the face of that. I'm not sure she was an advocate at the time. I'll give her credit for it. Well, what she's doing now, I mean, that FBI letter alone just really turned my stomach. You know, you
Right.
would
Well, today
file five
actually,
papers to go against your baby daddy is like,
I
if
know.
you would break the law to do that, then how can I take whatever you say in under oath as anything? You would break the law to do that. Like, that's crazy. Like,
It's really wild. And today is the hearing on her getting attorney's fees, which yes, you
Mhm.
know, to be fair, she did technically win her anti-SLAPP, so she has been in the tentative ruling been granted at least a portion of the attorney's fees. I
Mhm.
think like maybe close to 300,000, and she wanted 400,000. But you know that judge
Mhm.
in that FBI letter, it's like when the judge wrote in her ruling last spring that she just hadn't seen any undisputed evidence that it's actually illegal to forge a document impersonating
Mhm.
a real federal agent. And you're like, what?
Wait a minute, but you wait a minute. That's because, you know, but here's the legal part of that. No one presented the case that way. Like, she may know it's illegal, but unless it's put into the arguments, she doesn't have to consider it.
Mm-hmm.
And that's unfortunate. You know, there's like a loophole that needs to be, like, you know,
Yeah.
of course it's illegal everywhere to impersonate an officer of any caliber, an FBI agent especially. That's a federal offense. Okay. You got local and state offenses for impersonating officers too. Like, I don't understand. This is, you know,
Mm-hmm.
how she came up with that ruling. But I'm hoping, you know, there is some hope that's coming back in, isn't there?
Well, the FBI letter was not struck for Ilma Gore because she basically wasn't able to strike it because she took ownership of the iPad device that housed the
Her
evidence of
own
that.
statements. Yes, her own statements that it was hers. Indeed, it
Yeah,
was
so
from,
it
it was
has
on her
been like
device.
in
Yeah.
discovery. I don't know too many particulars about discovery, but I know the case obviously has been in discovery since the anti-SLAPP ruling. But Marilyn Manson is supposed to be appealing that this week, so then, or this month, so that would put, of course, a stay on the case. But I think they
Mhm.
wanted to wait to the last minute to file an appeal just to get as much discovery work under their belt before there was, you know,
Mhm.
an actual pause in the case. It's
Yeah.
unfortunate.
Yeah, it is, you know. And but you know what? I think that if they do get it in, and especially if they use it, because it is a joint case with with Ilma also. So if they are able to bring it in, and they can actually, she admits to actually writing it, and then it was used in the court. You know that Evan Rachel Woods actually used that letter in the other court, then it will get in. You know,
Mm-hmm.
you know, she's not going to be able to lie on stand if it goes to court, if it goes to trial, which I can't imagine this. Like, what do you think? Do you think it's really going to go to trial?
I honestly, I have no idea. I'm more confident because I've been much more focused lately on the Nick Carter cases, and I
Mhm.
know, like, at least as of right now, firmly does not want to settle with any of his
Mhm.
false accusers. So
Mhm.
he's, as painful as the process is, he's committed to seeing at least one of the cases all the way to trial. I don't know what Manson's insight is, you know, because,
Mhm.
or even what the women's are. Like, I'm assuming that, I don't know how it would be, like, if you could settle with one of them, like, if Evan wanted to settle, but, or Ilma wanted to settle, but not Evan, or vice versa. I'm not sure how that would work.
I guess they would have to sever the case like they did in Navallo and Daybell when they had different ideas about length of trial time. One wanted to go with speedy trial, the other one wanted like a longer time. And the death penalty was dropped for one and not the other.
Yeah,
So,
and
like, I
like,
guess it would be, but that was a criminal case. I think in civil, I think they can sever the case. I think they
mhm.
can if there comes a part where the parties are not want to take different paths as far as defense and as far as a deal. I don't think anything prevents either one of them from making a deal, or any party. And I was wondering, like, as the right now it suits them because of the publicity and all. But when the publicity starts to get more negative, I wonder if Evan Rachel would be more keen to settle, like the others did, because
I
the others,
honestly, like,
yeah.
if I was a friend of hers, I would advise that, you know, because stuff will continue to come out that will just, like, further tarnish her public
Hmm.
image. So if she's trying to preserve her reputation, I think it's wise to kind of negotiate a settlement. But she also doesn't seem like someone who really backs down easily. So I don't know.
Yeah.
I do not know. It'll be interesting. That trial definitely I don't think would be televised though, because it's in like LA County and I just don't see it being televised.
Yeah. Yeah, I do want to just clarify one comment in the chat, just only for additional information. Like, I don't argue with other people's opinions about anything going on with a case. I just like to give out like the good information. And I would like to say that 17 is not illegal in all states, nor is it illegal everywhere. And so that's like speculative in a way. It depends on the matters of it. And also that hasn't been actually proven in a court of law. If that's when it's stated, that's going by the affidavits and statements by the accuser. Okay. And so it's hard to say. Like, I understand people have moral issues with older men in younger women, and that's just fine. Like, I understand. I totally get that point of it, and I'm not trying to put a spotlight on it or shame anybody in any way for their opinion at all. I just want to keep the facts that we can't throw around words like illegal unless it's been proven to be so. Like, I'm not going to convict him of that unless it's actually been so. We can feel a certain way about it. I get it. I totally
Oh yeah,
understand
absolutely.
it. Yeah.
We can think, oh, okay, well that's kind of like that doesn't necessarily vibe with me.
True.
That
Some of us would say that's just him getting her ready for a relationship. That's just grooming. He's attracted to younger people, and people do not like that. And I agree with you. I'm not very particularly pleased with any of that at all. Okay.
No, and
But
like
a minor,
another
but 17 isn't necessarily a minor in all states. That's what all I'm saying, Sonomi. I'm not really countering what you're saying, except that I want clear information out there that the use of illegal at 17 is not always true. Okay.
right.
Yeah, and that is called grooming by the actual definition of it. I agree with you, Tsunami. Like I said, we are not actually arguing your opinion. You're entitled to it 100%, and I agree with some of it. I'm just saying the term illegal and stuff like that, when somebody has not been convicted of something, is something I stay away from. That's all. You know, that's what I'm saying. And this was her statements on it. Like, we know, like, that's a he said, she said. Yes, he was older. And yes, you tend to believe because an older person was involved with a younger person, you're going to believe, that the younger person is saying that that's what happened. Like, I understand, because we want to protect them. Don't we all want to protect younger people? Like, it's that's in our nature to protect the vulnerable, of course, but I think that Amber and Johnny are a terrible example of that, because he was older too. Well, but she was of full age. Like, she wasn't, that young.
I find it interesting that there are multiple older women dating younger men, and no one concerns about that. I find that interesting. And then another celebrity example is, do you know who Sarah Paulson is?
Yes, Sarah Paulson. Yes.
Yeah,
Oh,
her, I'm blanking on her name, but like her long-term partner is a woman who's also much older than her. So that's like an age difference between women. So I
between
mean,
women, and
it's
no one
technically
ever
not
says
illegal.
anything about that. Yeah, they don't say anything about that. But I do understand when they think it's a minor. Okay, but in here in the United States, the age could be, in every state it could be different. It could be 16. Okay, in the UK it is 16. Okay, in Australia it's 16. Okay. And yet I do understand still that the age difference is there. So I get the point that they're making. But like I said, the term illegal is not one I would throw for the whole situation, based on the
No,
state. Because if it
no.
was illegal, they would have a foot for criminal charges. And here's why I say it probably wasn't illegal where they were, because that would give them a foot for the illegal charges and the allegations that are being said. And law enforcement could move forward on that. You do realize, like, that could be a whole nother thing. We wouldn't be in just a civil lawsuit. Then the criminal charges would actually progress against him, which they haven't,
Well, and I
which they
mean,
have
like
not.
to be very clear, like Manson has not been proven to have any sexual relations with anyone under the age of 18. Evan Rachel Wood
Exactly.
was like 19 once they started dating, which, yeah, he was
Exactly.
37. And that's where you can say, like, oh, how do I feel about that? But it's technically
But-
not illegal. And there's really not been any evidence that there was any wrongdoing on his part. But,
Yeah.
you know, there's been enough time that has come by and enough evidence has come out against his accusers that I think without a doubt there's more than reasonable doubt that the allegations against him are not true. Like,
Right.
if we can't say
Mhm.
with 100% certainty, we're supposed to be looking at beyond a reasonable doubt. And there's just
Exactly.
so much.
And that's what's important about this hearing here, because that first juror said that the statements by the county clerk, by the court clerk rather, actually influenced what she was thinking. It made her take pause and double think. And that she also felt pressure from the other jurors because they all thought he was guilty. And so actually she's laying the groundwork right there that the process may have been tainted somewhat based on her statements, because her statements do border on inappropriate. She said, I think the quote was, watch him. Watch his body language. As if he was, and you know, that kind of infers that he's lying from the get-go.
Right. It does.
Yeah.
It
And
absolutely does. It's kind of influencing your mind, coaching you in a certain way. And it's improper. There's no way around it. It's improper to advise or tell it to try to say any comment to a juror of what to be thinking or observing when they're in the courtroom.
Yeah, it really is. It's like, and so I did put up a poll in the beginning, right after that first juror spoke, because to me, that was just it. Like, as soon as somebody said, yeah, I felt a certain way, I felt pressure and I was influenced, I knew it was over. Or actually, in my mind, to keep the jury process untainted and as pure as we want to, you know, as legitimate as we can, as sacred as they try to in the legal system, that they would have to offer him a retrial.
Yeah.
Because,
Okay. So
you know,
I did a Twitter poll also, and there's 92 votes. 48% said yes, you should get a retrial. 38% no, and 13% unsure. So
I had a
it's
lot
not like
higher
a slam
result.
dunk one way or another. Some people,
It's not. People are both ways, because you also have, like you said, like we were talking about, the cost to the court and the implication that we're saying, oh yeah, the jury was tainted. Well, no, the majority of the jury wasn't. We heard 11 people say, nope, I wasn't influenced. We heard one person say, I felt a little influenced. And like in my chat, people were like, she's a little wishy-washy. Like, I don't even like just the way she's speaking. She was going, you know, this and that, you know. And also the defense was so adamant on making sure that her prior affidavit was entered into evidence, which was not done under oath. It was given to to the clerk of his law office. So it was kind of like third-party statement affidavit. But what matters is what's said under oath in the hearing. What's said to the judge under oath is what matters, more importantly than whatever complaint the defense had made with the other affidavits. It had to be reiterated, and she did confirm that she felt pressure and she felt influenced. So, like, there's no getting around that. It could be quite costly for the court system to redo this, but it may just be necessary to preserve the sanctity of the process. You know,
yeah,
So
it's such a shame, because if you think about all the hours invested into that trial, like, that's crazy. But we've seen retrials. I mean, we saw Danny Masterson get a retrial recently. Like, it's happened.
Yeah, true. Yeah, it is, and we see it more often. I saw it in. Unfortunately, I also covered the Masterson trial. Not unfortunately, actually, as a matter of law, I found it quite interesting because of how long the accusations, how old they were, because of using the new statute to bring it forward, because of the 3-strike rule that they needed 3 cases, you know, the influence of Scientology with the Los Angeles Police Department. It was quite intriguing. And the fact that they came forward with the guilty for 2 of the cases and not the other, and he was sentenced, but now he is going for an appeal. But Scientology has disowned him. And his wife divorced him.
Mm-hmm.
And he asked to be let free, or to go on bail while his appeal is being settled. And the judge was like, "You don't have a wife to go home to. You're a flight risk. Nope, you're staying in jail." I mean, how many people get to come out of jail while their appeal is pending? Do you know of many? I don't.
No, I don't.
I thought that was like, a long shot to begin with, Yeah,
Mm-hmm.
and pretty entitled, mo
There's another trial happening right now that I'm interested in, but I'm watching this Murdaugh one today. The parents of the shooter of a Michigan high school shooting.
Is
I'm
that the
interested in that.
Crumbley case? Is that
I'm sorry,
Crumbley?
repeat that.
I'm like, Crumbley? Is that it? Something like
Yes,
that?
yes.
I wasn't following it, but it's been everywhere on the media lately.
Yeah, well, that one I have a little bit of personal connection to because I have a lot of family that live in Michigan, and my cousin in particular, she's a parole officer in that county, and
Mhm.
her husband works for the sheriff's office for that county, and he responded to that high school shooting, and it just how much it affected him really hit it home because I know Eric and he's such like a strong, guy. The
Mhm.
fact that he was rattled by it and all the things that he saw responding to that shooting and the massacre of everything, like it really drives home just how horrible those things are. Cause I feel like we get a little desensitized with the high school shootings because they unfortunately happen. We're shootings that happen unfortunately more regularly, but it's interesting that the parents are on trial as well. Like I find
Mhm.
that just
Yeah.
fascinating.
That is because it doesn't happen that often. There's always
Mm-mm.
talk about, parents should be responsible for what, underage people do as far as breaking the law, that they're responsible for making sure they know right from wrong, giving them access. In this case, is it not? It's a matter of access to guns and
Mm-hmm.
safety and this and that. And perhaps they should be on trial because maybe these things do need to be. I know there was a couple of other shootings that they were looking into whether or not the parents had provided access or they did not take due diligence, so to speak, in locking
Right.
up guns or making sure that if a child was of age, that they had proper training in gun handling and things like that. There was proper guidance in regards to mental health even. Well, a couple of
Mm-hmm.
them knew that their children were having mental health issues. Okay, and yet still guns were available in the home. Like that's insane.
I know it's unfortunate. I mean, just it's an interesting legal question because with minors, you think, well, they can't consent, so the parents are responsible for them. But then on the same time, so many of these minors that do violent crimes will be tried as adults, which is interesting. It's fascinating, and I don't know what the right solution is, but it'll be really fascinating to see what ends up happening with the verdict of
Mhm.
that trial, how much the parents in the jury's eyes are responsible for his actions.
Yeah, exactly, and that's what makes it like a precedent kind of case, which I like. I didn't know
Mm-hmm.
about it in the beginning, but I've been following it like privately. I just have such a load right now with everything coming into trial season, like the Boone and Clooney and like so many other oddball ones. And now with this actually maybe coming for a retrial, because I covered the original trial, of course, and the hearings, I'm gonna definitely want to cover the retrial if it happens. So I've just been watching it on the sidelines and some of the good coverage. So I'm glad we get to talk about it. I hope we get to talk about it some more privately because I
Yeah,
really do think it's going
definitely.
to set precedent because here's the thing. We all, and just like our conversation about Manson and how that can disrupt the chat and people's opinions and things like that, we have to remember that when we're talking about it and we're talking about the law cases, we're talking about the legal precedent that has to be set, the legal ramifications, whether or not there's law to support it or whether evidence has actually been presented, because everyone in a court of law is innocent until proven guilty, regardless of
Mm-hmm.
how we feel about their age and what they did or anything like that. Like for instance, all of this stuff that just came out with the WWE CEO of Vince McMahon, right? or it sounds horrible when you read the allegations. You like want to just put him in an orange jumpsuit and put him in a cell that's full of sewer. Like you just want to get rid of him, right? But here in America, he's entitled to full law, and we cannot just believe one allegation. We cannot believe the allegations until they're proven. They actually have to be proven.
Like you can put anything into a lawsuit. And a lot of these salacious claims are put into the lawsuit just because publicly it looks bad, but then those claims will never make it to the jury because it's found out that like there's no evidence to really back them, so it won't even make it actually to the trial. It's just kind of like I could sue you and say you've done anything in a lawsuit. Like in this country, you really can't sue anybody for anything. But I had no idea that was happening until last night, but somebody was telling me that he did resign, which, you know.
Yeah, he stepped down. There also was some reporting of like millions and millions of dollars he's paid over the years to keep people quiet. So people are stepping out, and it's going to be messy. It's horrible. And the allegations are horrific. And our first instincts are like, yup, guilty. Oh my God, that is just morally incomprehensible. Like, how could you do that to a human? You know, you really get emotional about it. But what I love is the black and white of the law, just going down and like, okay, how are we going to prove this? She stayed with him as his working assistant all that time.
Yeah.
She was not shackled. She, you know, and hey, I'm not victim blaming here, please.
Yeah, because I don't want to say that every public accusation is a bad one. Sometimes, like, there are public figures who do terrible things. That's a fact of life. Like the Harvey Weinstein, look at R. Kelly.
Oh, yes, and look at R. Kelly, Harvey Weinstein, absolutely. But then look at Kevin Spacey, unfounded. Like, okay, and reputation ruined. Okay, like this is what I try to fight against. Like the media takes over this stuff and it gets crazy, but we have to like stick to the law besides our biased opinion or whether we like it or don't like it, or if we're turned off by the accusations and we think they're wrong morally, they just don't fit with our life. You know, I get all of that. But you know, it's just really, I mean, look at the TikTok psychic. Do you know anything about that one? It's related to the Idaho Fall, the Moscow murders for the university.
Okay.
A TikTok psychic decided to accuse another professor of the murder. It stated her tarot readings told her that this professor did it and had an illicit affair with one of the students who was murdered, and that she got one of her assistants to do the crime. And she said it in 100 or more TikTok videos, even after getting us the cease and desist. And she's actually defending herself, Kelly. It's humorous, but actually kind of frustrating, you know, because the judge is trying to give her all this extra time because she's defending herself, whatever. But basically her defense is, you don't believe in psychic, you know, tarot readings. So like, you don't know. My spirits know what happened, and you'll find out eventually. But I don't have to prove it right now because they know, but I don't have to prove it was a true statement because we won't know until after everything comes out. And we don't have a timeline on that. And we're like, what? So basically, sometime in the future, if you're proven right, that means you didn't just defame and ridicule. Even after the Idaho police came out and actually the sheriff's office said that this particular professor is not under investigation, has nothing to do with this, leave her alone. And you still produce this content, you know, against her, and she's suing her, you know. And this TikTok psychic actually countersued her. It said that the professor was trying to ruin her her reputation as a tarot card reader in a TikTok psychic.
That's a curveball.
It's like, no, we're just trying to hold you to what you said. Like, you know, you're trying to ruin, like, this woman's up for tenure, you know. And she's in a university in Idaho. You know, the tension around that case was horrible. You know, just to even be implicated at all by anybody, it was terrible. It was so stressful for the woman. I don't blame her. But anyway, it just gets crazy.
Is there an estimated timeline of when that trial? Because I know there's been a lot of, you know, hearings kind of in the
TikTok psychic. They just finished Discovery closed on December 15th.
Okay.
So I do believe it's the spring. But I'm hoping that this woman settles. It may not even come to trial. The last update I did was that Rebecca Schofield, who is the plaintiff, who is the professor who is suing the TikTok psychic, Ashley Gilliard, she actually put forward for summary judgment because in the interrogatories, in the questions, in discovery, Ashley Gilliard actually admitted to all of the false statements and had nothing to prove that they were true, which means defamation occurred. And as long, then they just have to decide how much, So they're looking for limited summary judgment already, and that will affect like when they go forward. It'll be quicker with a jury if they just have to decide on the amount that she's awarded. But it looks already like if it gets approved by the judge, we'll see. The judge may have some leniency on Ashley and give her more time to answer the interrogatories, more advise her to get a lawyer, like a public defender, anybody,
Yeah. I wish the Sarah Boone case, like, I obviously want that trial to happen and I look forward to watching it whenever it does finally happen. But she as well is one of those people that's just kind of like, I wish she just had pled guilty and saved the county all the trouble of this.
It is. I have an update coming out Tuesday on that. There's been a little bit more going on with that. She's quite the card. I'll tell you. She's quite the defendant. I don't envy anybody having to represent her. It's got to be difficult. She's her own worst enemy. But that trial is set for May 14th, I believe. I think we finished everything.
Yeah,
May 3rd is the pretrial.
Yeah, but we've seen so many of her attorneys back out. Like, will the attorney even make it to trial?
We've had seven. We had seven attorneys and 16 continuances. Yes. Yeah. It's crazy to say that one is definitely crazy.
That 2-minute video of her talking to him in the suitcase. I love horror. I love true crime. But don't you agree, even though that's not like a gory, bloody video, it's just very, very disturbing.
It is so horrifyingly disturbing because we know the outcome. We know how he was found in the morning. We know he was really
just
pleading
for help, and she's taunting him from outside the suitcase.
And you just, if you put yourself in that person's position, and just to know that the person is out there and just not willing to help you, and you're telling them you can't breathe, and I just can't even imagine. It's a horrible, horrible ending. It doesn't make her look good, drunk or not, inebriated or not. Unfortunately, in Florida, if you willingly drink and take the drugs, it's not a defense for your actions. They have a law against it in Florida. There's statute there. So even if, like a lot of people said, well, maybe she should just prove manslaughter drinking. It was an accident. When you look at it, it could actually be an accident. She was pissed off. She went to sleep. I don't know if she intended for him to die. Did she intend to make him suffer? Probably. Was she having a good time laughing at him? Yes. But they had a contentious relationship. That's not, for me, that's not actually the nail in the coffin just because she did that. Okay. Like, to me, I think it would have been appropriate to charge her for manslaughter, like activities that you did that resulted in someone's death. Yeah,
hers is not first degree; it's second degree homicide.
Right, which means her actions contributed to her death, but that she did not plot a murder. That's about all. It just says she didn't plot it. It happened, but she didn't think about it the day before.
A theory that I don't know. It'll be interesting to see what's presented at trial, like if they look at any of her internet searches or whatnot, because when she's interrogated, she repeatedly says, I woke up this morning, and then she'll like correct it to be like at like 12:30. Like she does that a couple times.
Yeah, she says 11:30, and then I didn't get out of bed till like 12. I didn't come downstairs.
And another thing she stresses that it wasn't intentional. It wasn't intentional. It wasn't intentional. So I'm like, did she wake up and Google like involuntary versus voluntary manslaughter, like what was going through her mind? And I mean, who knows, like her head seems like a crazy place to be. But I'm very curious to see, because did you watch the Taylor's to Business trial? And they talked about her internet searches and everything.
I watched a little bit of it, and I was intrigued by the internet searches like that. I had another discussion, a couple of discussions. I there's another friend of mine, Mandy, who follows all this stuff behind the scenes too, and she actually turned me on to that trial. She said it's worth it. There's some shenanigans going on there, and like when I listened to it, I could see what they were talking about. Like it seemed so innocent until you actually looked at everything.
Yeah, I know. So it'll be really interesting to see what happens with Sarah. I just hope his family finally can get some closure. Like, what a painful process it is to ever lose somebody in that capacity at all. No one wants to lose a loved one in that horrific manner. But then to watch for now years and trial and attorney after attorney, trial date rescheduled, continuances. They're just, I really feel for his family.
No, I do. I do. I feel like for most of the victims' families in the whole process of a trial, how painful it is. And that is why I'm like really kind of discouraged about the Murdaugh trial, because that was quite painful too. In even for the whole town, the whole area, to go through it all over again, to learn about all of the back dealings and things that were going on and the dishonesty. And it just brings it all back up again. You know, you think about the survivor, Buster, his older son, who is just moving on with his life right now, his brothers, his, you know, the rest of everybody, his sister, everybody who's involved. Just to have to go through it all again, because you know they'll be there for the trial again, and they're all going to have to come through. Many of them are going to have to testify again. It's unfortunate, and I wonder how much of the first trial is going to make it into the second trial.
Yeah, I totally agree. And
I have to research that. Do you know anything about summary judgment? Do you think that the judge can come forward with summary judgment of guilty and just go through with the sentencing by jury, like after, like looking at the case, even if he gets a retrial? It just means a new judge. I wonder if it has to be a jury trial.
I'm not sure. I'm assuming it would just be a retrial with the jury as well, just based off of what we know about Masterson's, because that was, you know, that was a retrial also kind of because of the jury being, quote, compromised by allegedly Scientology. So if this is one juror, I don't know. It'll be interesting because it was only one juror that said that, but other people did say that they had watched stuff. But then when asked if it impacted their decision for the verdict, they said no. So it'll be interesting to see kind of how the judge takes all that into consideration in his ruling.
I guess it just matters because, like, here's what keeps sticking in my mind. Because of a guilty verdict for murder, a criminal charge of murder, a felony like this, you needed a unanimous jury. That one juror saying no, that's it.
Yeah, that's how I interpreted it. As soon as she or the juror,
but
was
I'm not
like,
a lawyer, you know. Like I just love the law, but I'm not a lawyer, like, you know. And I have asked I've asked a few paralegals, and I asked a few lawyers, and they said, you know what, that's pretty spot on, because it is that is the argument right there that the defense will use. They only needed one.
Yeah, well, you know, and we might not be lawyers, but we're all American citizens, and we believe in the Constitution, we believe in our rights, and if somebody has a right to fair trial and there's been any compromise to the jury, I ethically feel it's right for them to get a retrial, even though I know it's going to be a big headache.
Yes, I do too. Even though I think it's a horrible blemish for the state and it's a lot of expense, I just hope that they present their evidence in a good, strong case, and that justice is served. But I do think that if that juror was influenced, and she is saying she was, that a new trial is necessary, because it needs to preserve the whole process. You know, you need to preserve the integrity of the process, and he is supposed to be convicted by a unanimous vote by the jury on this pleading. And it obviously, if she was influenced, it wasn't unanimous. You know, so
Exactly.
you know. But I can't wait to hear what this judge is amazing. Do you like this judge? I'm like so impressed with this judge.
I think he's been terrific. I really do.
She has actually like just ruled that courtroom. Like she's like, nope, sit down. I already told you that in the pre-orders. Like Harpoolian keeps wanting to talk to the jurors, and she's like, I already told you about that. Like way back. Like we said, no, no, you will not talk to the jurors. I will do all the questioning. You can send me the questions, and we'll talk about it, and I will decide. Like she keeps telling them, I'm in control here. Sit down, sit down, sir. Yeah, it was pretty good.
I know.
I know. Well, she asked him in the beginning, did you bring the transcript you're talking about? And he was like, she called him right out. Then she had her court clerk pull up what he was talking about. He wanted to argue some points and he didn't even have anything to bring to her in regards to it, to show her what he was talking about. And she called him out right away.
Yeah.
Like, she don't like that showroom stuff. She don't like the shenanigans. There'll be no public relations speeches in her court. That's for sure. Yeah.
Speaking of judges, did you watch the Parkland shooter case and the sentencing judge? And there are a lot of criticisms of her. And so she formally resigned after the trial. And I watched an interview with her recently locally. Like she's not a judge anymore, but she is working for like civil law and whatnot, just as an attorney. And that was an interesting thing to watch because she was accused of just being unprofessional in the courtroom. But I watched that trial and honestly, it was chaos. Like the defense attorneys, I would say, were unprofessional and whatnot as well.
That was really, really a hard case. And I guess she was worried more about, well, if the perception is out there that she was unprofessional, then how could she do her judgeship? And I think she may have been wrestling with how she felt about it personally. And I don't blame her for stepping down. Once your credibility is put into that kind of light, it's just a target for every defense, coming forward, and appeals and having all your stuff overturned. No judge wants their stuff overturned. Like they really look at this carefully. This is like the higher echelon of looking at it in black and white and whether law actually pertains to a situation. So like they don't want to be second guessed. I kind of don't blame her for wanting to get out of the limelight that way. Because it would have been really hard going forward. Like every case would have been a struggle. Like every case.
Yeah, because I mean, I watched that trial and I thought she kind of lost her cool a little bit, but I didn't think she was horrible. I don't think she was unfair with her decisions. Plus, it was a sentencing trial, so it wasn't like the actual trial of his conviction of the crime in general. But like one of the things that she was talking about, because I guess at the end of sentencing, and he got life without parole instead of the death penalty, that she on camera was like kind of consoling the families. And she said that, people can criticize that all they want, but honestly, like at the end of such a gruesome trial, like in my heart, it felt like the right thing to do. And then I kind of understand her point of view there too.
Well, she's a human being.
Yeah,
I mean,
exactly.
And the trial is over. She's allowed to be sentimental if she wants. The trial is over. Her walking up and consoling anybody doesn't weigh on anyone. The jury is out.
Those families have lost loved ones in such a horrific manner. Like just as a human to human, compassionate thing to do, I don't think it was wrong for her to, give her condolences.
No, she had to hear
to the
those.
family.
She listened to all those victim impact statements. She heard the defenses. She heard the defendant speak for himself. Whatever. Like she had to play it off. Like she's allowed to be human. Like I can't imagine not wanting to give my condolences to the family and admire them like they did in the Starch trial. Okay, when the parents had to testify and came forward and were there every day, and they were actually and they were addressed in a manner of like your strength and your fortitude, and we understand how difficult this was, and we really admire you for going through it, and we hope that you have your justice now, you have your verdict. And I thought that was a great thing, and that judge wasn't admonished for that, like at all. I guess it's a matter of like who is doing the looking and what is their agenda actually at it, because I don't think she did anything wrong, that judge. But now she has to deal with the repercussions of the rumors and the allegations to be out there, It's unfortunate. I think it was unfortunate that Judge Newman had to go into retirement with this retrial over his head. He had a great career, and he dealt with these Murdaugh cases. He was so patient during that trial. Like, he was so
I
patient
know.
with both the plaintiff with the state and the defendant's attorneys. Like, he was so patient, and I did admire him. I did, and just to have it, like, he didn't do anything wrong, and he's going out with this little blemish, on his career, and it's just
I
not right.
know. It's really unfortunate because I thought he was incredibly fair in all of the pretrial hearings, obviously through the trial as well. Like, it's just.
And he
It's
had so
unfortunate.
many of the financial cases. He had so many of the other defendants in the financial cases too. Like, he had the whole enchilada, so, like, if he doesn't like Alec Murdaugh, like, who could blame him?
Exactly.
But he didn't actually come out and say that. Like, and as a law professional, as a judge, I'm sure he does feel a certain way about the Murdaugh family name being discredited, the judges and the prosecutors that were actually in that line and had their careers actually besmirched by all of this. When you have to take down pictures in your courtroom,
Oh,
of
yeah.
so that nobody is prejudiced against the family connections. I mean, that says a lot. Like, Alex Murdaugh, like, what he did to the reputation of lawyers in that area is incredible. Although I did just hear that they when it happened a year or so ago, his old law firm renamed themselves the Parker Group. Like, one of the other partners put their name first, and they renamed, and they stayed together, and they're still working. They were just named Business of the Year for that county.
Really?
Yeah, and I was
That's
quite surprised. Like I was like, wow, like, I want that PR team that worked on fixing that reputation, because they went how
Yeah.
many years of this man stealing from them, and they didn't know? Like, they didn't know? This man was stealing from them for how long? He was their partner, and they had no idea what he was up to? Like, I don't know. Like,
Do you think beyond a reasonable doubt that he's guilty of the murders?
I do, for one reason. And I say this often. Do I think there's a lot of evidence against him? No. There's no murder weapon. There's no DNA. There's nothing. But what there is a video of him there seconds before they died. And he lied about it. He's guilty.
Yeah, I think he's guilty as well.
Now, the rest of the evidence is circumstantial. They had to build the timeline around that video, and they did successfully, in my opinion. They tracked his movements. They proved that it was possible for him to do it. Just because we don't have the guns, we do know that the guns that did it did belong to him. Just because we can't find them doesn't mean, I mean, hey, like, there's doubt there. Oh, but I do think because of that video, reasonable doubt is gone. He was there seconds before they died. So he either did it or he knows who did it. Yeah.
Exactly.
And that's the only piece of evidence he couldn't go against. And he lied repeatedly until they told him they had that video. He said he was never down there. And unfortunately, his own words are used against him there. And rightly so, if he was lying about it. Well, in this case, I think that the victim actually did the best thing to get their justice. And Paul taking that video and having it on his phone, was the best thing. And then there was all the stuff about what he tried to do with the phones too. Like, that was pretty wild. How the phones were moved around and everything like that. It did show to be a bit premeditated, or at least a big cover-up after it happened. Like, if it was an act of rage or desperation, but actually everything he did after that point was with intent to cover up the crime. Seriously.
Absolutely.
But yeah, and if it does go to retrial, I will be based on the evidence, so whether they can prove it. But I'm wondering how they're going to be able to try to get that video out. Like, if I was the defense, I'd be trying to get that video out. Because that's what proved it. I mean, for me anyway.
I agree. I totally agree. Well, I hate to say this, but I have to go back
Oh,
to work.
no, I do love talking law with you about anything.
Yes,
See, we could
yeah, I
talk
love
so
that we
many
enjoy
million,
different cases.
anytime. And if I'm covering, if you ever see I'm live with these stuff, you're more than welcome. Hit me a
Oh,
note.
awesome.
Like,
Yeah, I will definitely hit you up on that for sure.
us civilian nerds in the legal true crime need to stick together. We do have such a passion for it, but those lawyers, they don't want to talk to us too much.
No, they don't. We're kind of a thorn in their side.
We're just a thorn in their side, but I want to make it relatable to the average person. They may not be as nerdy as I am about it, but I do want to try to drill it down into real language, real situations for them, and I enjoy
Yeah,
it.
I mean, it's really a benefit to everybody to understand how our legal system works.
Exactly. I have someone I stream with who preaches that all the time. We need to understand the system, and we also need to understand if you ever are approached by law enforcement for any reason whatsoever, remember, don't say anything until you contact your lawyer. Period.
Exactly. Exactly.
Exactly.
You
Yep.
see that all the time, these interrogations, and you're like, don't they know they don't have to be interrogated? They could stop this and ask for a lawyer. Like, people really are not aware of their rights.
Yeah. Well, there is a case I want to talk to you and to Lana about. There's this case that I stumbled across, and I've only done one video on it. It's Shawnee Lynn Crawl, and it's actually a murder case where the body got thrown out of evidence.
Whoa.
And all the searches afterwards. Yes. Even though they had him dead to rights and everything's been thrown out. He's on his 9th attorney, and the last one was threatened in a phone call with his mother. His mother advising Shawnee Lynn Crawl, maybe you need to do something to that attorney so you can get a new one. Like maybe some violence of some type.
Wow.
Oh, it's crazy. It's crazy. And I'm fascinated because they threw the body out. And yet they had the opportunity to drop the charges down and do a plea, and they didn't. They said they're fully prepared with other evidence to go forward and get him for this murder. And I'm like, whoa, what do they have? This is so intense. Like, wow, it got tossed. But yeah,
I'll have to look into that. That's crazy.
Yeah, I'll send you the link to what I did. And are you in my Discord? I'm going to send you the link to my Discord because I have a room for each case. There's all kinds of stuff in there.
Okay, yeah. I've never really gotten into Discord, but I do have a username. I just don't use it very often.
Well, you don't have to talk in there, but it is a good place for us to share
Just
information
read,
and read and just keep up on the stuff. If you want, no pressure. I never
Yeah.
pressure anybody into Discord.
No, I love it because
People
I
feel weird
like
about it.
I like chatter about multiple different cases because, as you know, the legal system, it moves pretty slowly. So it's pretty easy to like watch a lot of cases and not be overwhelmed because things move so slowly.
Mhm.
But yeah,
It
I
was.
love.
And what I like about it is like everybody who likes to follow this kind of stuff, we have chats in there constantly, voice chats in discussions that we plan about oddball case, even the stuff we're not covering here on YouTube, just because they love it so much. So I think you
Yeah.
find a lot of like minds in there.
I love that.
Yeah. It's good. Because like I said, we all have to stick together.
We
You're
do.
like me. I so enjoyed hooking up with you because you have the same outlook that I do about it, like about just the fascination of the law, but also about sharing the information. You and I never hold on to a link for any document or anything we ever find about anything. We want people to make up their own minds. And I want to give you
Yeah,
full
I'm
credit
always
for that
happy.
because there's not a lot of
I was gonna
YouTubers like that
say, like,
anymore.
yeah, exactly. Because I'm always happy to give people just like the full documents because you can pull out like the main points, but it's better. I really think there's a value in everybody being able to read all the arguments, see all the evidence from both sides, and make a decision, but also understand more, again, as we were saying, how our legal system works.
Exactly. That's why like we're pushing for Boone to actually get a trial. It's unfair that she's been in jail all this time, although she hasn't really helped herself. But I mean, I get it. She needs a fair trial. 4 years, she's been in there 4 years without a trial. That's a long time. That's a long time for anyone. This Shawnee Lynn, he's going on his 3rd year, I think. His 3rd year in there. Oh, he's pretty much to blame for why he's in there, like still like without a trial. But still, you want it to come forward. It takes like too long. you know, but there's
Yeah.
always, but I know you got to go because you're working, but you're
I know
welcome
I gotta get back
anytime.
to work,
Yeah.
but I
Yeah.
will be watching when this comes back in like what, half an hour?
Yep,
Becky
it's
Hill.
gonna in about half an hour, like at 1:15 it will. And I try not to talk, like you say, like I'm documenting it for everybody's opinion later to actually weigh in. So I only talk when there's long pauses, but I always bring people up for lunch and the long breaks. So you're always welcome, Kelly. You know, you're always
Well,
welcome with most of what I do. We got to get
yeah,
together on
if
Manson
I'm
again.
free to talk after, because I am
Mhm.
working on something for like
Mhm.
needs my concentration, but I will be kind of listening to it. But if I'm free to
Mhm.
chat after, I'll let you know. I'll DM you like
Okay.
after her
Great.
testimony because I'm very, very curious how that's going to go.
That's cool. And for everybody, I will be listing her podcast on the Manson coverage below after we're done, like in the description, so you can follow up with her. But definitely in all my Manson stuff, she's listed, and she's all over Twitter. You can find her.
Yeah, and if anyone's listening that wants to read all the Manson court documents, I have a Google Drive available on justiceformarilynmanson.com
Mhm.
with the legal documents from all parties, so people can read through. There's a lot of them.
Even the
But,
settled cases, even the ones that are dropped already, like everything's there.
Mhm.
The whole
Yeah.
history, you know, all the way back to the original February, like in what was it, 2020?
2021.
2021. I was going to say 2020, but that was like, that didn't sound right. Yep, 2021, February 2nd, 2021. Well, yep.
Yes.
Thank you so much for helping keep me company up here. And we got, I'm so excited because I got to talk legal, like lots of legal for an hour. And
Yeah,
like,
talk about different
I'm like,
cases, not just Murdaugh.
I know, Kelly, I'm vibrating now. Like, you're so good for me.
Alrighty, well, bye, Claire. Bye, everyone.
Have a good
watching.
afternoon. Yeah. Thank you. Thank you again. Oh, that was fun. I'm going to go through and make sure I didn't miss any questions because I got caught up. You guys know I'm such a legal, like when it comes to this stuff, I get so nerdy. Crazy Cat, how does a body get struck as evidence? That's mind-boggling. Well, I did do a video on it, Crazy Cat. It's the Shawnee Lynn crawl, okay? But I will tell you this. It was because of inappropriate search technique. Law enforcement didn't follow protocol and then kind of misled the court about it and then got caught out about it and it got tossed. And then fruit of the poisonous tree, because that got tossed, anything that they actually checked out because of finding the body got tossed out also. So it is quite the case. I'm not going to spill the whole thing here because I want you to go watch the video because there's a lot to it. And I will be continuing to cover it. There's a room in the Discord for it. There's a lot. There's just so much. There really is. I hate to do this, guys, but I have to mute for 1 second and I'll be right back. I'll put some music on for a second. I'll be Let me just cut the music. Hopefully that wasn't too bad. Did you hear the music okay? Well, yeah, Rocket Couch. There was going to be only one toilet flush on this stream. I could guarantee you. I don't think I would ever do that on stream. I mean, do you think I could get 100K, 100,000 subscribers immediately? Maybe I will. Just send an audio out. I don't know. But the numbers don't really mean that much to me, so no, I don't think I'm going to do it. Nope. No. Yeah. But I did need to make tea, so thank you all for indulging me. We've got 20 minutes left. Oh, Shield, thank you so much for finding the link. I would have dropped it. I cannot do a lot of searching when I am actually streaming other streams. It takes a lot of resources on my system, and I don't want to interfere with the band, the band rate or any of that stuff like with this at all. Well, I do appreciate it. And thank you all who have stayed, who have actually stayed to keep me company during the break. Yeah. I hope you enjoyed. It can be a little frustrating when Kelly and I get to talking about legal cases because we go really, really fast and we talk about a zillion cases at once because, as you can tell, we both have such a passion for it. And that's what I enjoy about her. I enjoy that about her coverage because even though she's passionate, she really does try to stick to the legal angles, the black and white in the documented stuff. And she's so great about sharing information. Almost all of the documents that are available on Marilyn Manson have come from her through her previous podcast. She has the website up. I do recommend that you check it. I know that people do have personal feelings about the Manson case, and I understand that, and I would never speak against it. We all have things we feel very strongly about in regards to abuse, in regards to consent, in regards to age, all of that, grooming, you name it. And I actually want everybody to be free to talk about it. But when we're doing a true crime, we want to stick to kind of the legal stuff, So anytime that I'm addressing it, please know it's only coming from that, and that I do actually want everyone to have the freedom to say how they feel about everything. It's just important for me to get proper information out in regards to the legality of something. That's all, really. Oh, good, Liam. I hope you enjoyed it, because I do hope she does join our Discord, because I think you all will enjoy the conversations with her. She has a unique, she's got such a way of looking at things sometimes, and often I have taken pause and said, I didn't really think of it that way, but yeah, let's look at that angle of it. It's so enticing. Oh, hold on one second. Okay, took care of that. Sorry about that. I hope that wasn't really loud. I hope nobody's ears got hurt in the headphones. I forgot to mute my phone. No. But I'm glad. Okay, there goes my signal again. Hopefully I'm still coming in. Oh no, I'm sorry, Liam. You're who I was thinking of, because I know you have your headphones up. I'm sorry. I did forget to turn it off. Oh, you're teasing me. Oh, you brat. You could always count on my mods to keep me in line, make sure I'm on my toes. Like, yep. Yeah. Well, okay, I'm going to take down this poll. Let's see. This poll says that 91% of you do like the high profile hearings. So I will continue to do some of them with the Kohlberger case and with the Boone case and any of the others, especially Crawl if we can. So far, I've been doing the hearings for Kohlberger and for the Rust cases, the shooting on the Rust set, Alec Baldwin and Hannah Gutierrez Reed. I just did Hannah Gutierrez Reed, but February 1st will be the arraignment for Alec Baldwin. I will probably record that, if not actually do a live coverage of it. So 91, the majority of you do like to have the live coverage and a place to talk about it. And I like it too. I like sharing this hobby of mine with you all. I know if you've noticed my channel has been changing slowly over the last, since I've been doing more true crime. It's been more true crime laden. And it seems to be that that's what most of the people who are following me want to talk about. Although I absolutely love my weekend stuff, and I'm not giving it up. And I'm not going to give up paneling on other channels for fun stuff and serious stuff anytime soon, because as it says on my channel, and as I tell everybody as to why I have, my presence out here on YouTube, is to have the conversations. If you know me, you know I like to talk, and I like to talk about all things. Like, I like to look at things from all different angles and hear lots of people's opinions about it and discuss stuff, and go back and forth. Like, I find great enjoyment in that. And I've been fortunate enough to have a group around me that enjoy it also. And so it's been quite a pleasant hobby of mine, and I don't intend giving it up anytime soon. On that note, I'd say that we're actually putting investment into it in a way. All of your contributions for 2023, I shouldn't say all, I should say the majority of your contributions for 2023, whether you were a member of the YouTube channel or a Patreon member, or you did gifted memberships, or you actually made a sticker, a super chat, all of that money went towards the investment of a new computer system, which is being built right now, a beast of a system, which should actually able me to Google and stream a live stream at the same time, which at this point is my only goal. Because right now, even with this other system that I did upgrade from the laptop to this other system, I can live stream now without being interrupted, but I can't go into Google or Twitter to get information without it doing some fluctuations or having some resource issues. And so I want to kind of prevent that. Like right now, I don't have Discord up, and I normally have Discord up all the time, because I go into the room to get information and stuff like that. But based on wanting to keep the live stream running the whole time, I just can't because of the resources. It will immediately start pulling on the resources of the system. And I don't know if that's because the system is older now, or if there's something wrong with the setup somewhere that I'm just not aware of. But I just know I need a lot bigger, more powerful system. I also want to get more involved in video. You all have heard me talk about how I'm just not very good at video. Although videos that I do put out, they're okay. They're successful. Okay. But it's not my favorite thing. I don't like editing. I don't like having a concept in my head that I don't have the talent to get through a video system, like a video creation system, no matter what. Like, you got to learn how the application, you got to learn all this stuff. Like, I get a little impatient with the idea that what is in my head, I can't actually put in front of me out there as a usable product. And that takes time. But I'm looking forward to learning more about it and being able to have a computer system that's going to be able to handle it. And I want to thank you all for your patience while I did that, and for your contributions towards it. The other thing we did, since I'm talking about the contributions, is we did keep up some of our donations that we do. I think most of you that have been with me from the start know that when I got monetized, it wasn't that I wanted to be monetized. It happens, okay? And I thought I could do some good with it to help other small creators, and to also do donations, which we've been doing that whole first year, okay? And we still did do our Trevor Foundation donation every quarter in 2023. We did do that donation anyway in regards to holding up all the others. That's why there was no voting polls during 2023 for where to put the gathered monies to, because we had said in the beginning of the year that it would all go towards the new computer. And I will be putting an accounting out for that. There has been the investment of all of you, and then a small investment of me, and then another investment by a private person who is donating time and effort and spare parts to help this dream of mine come true, to speed it up. Because honestly, I did not want, it's a hobby, so I needed the hobby to pay for itself. And some people don't understand it, but for me, it made sense. And it was my personal preference that the hobby needed to pay for itself. So I wasn't going to go into savings or, put some money out for a new one, which would have been fast and easy to do. I get. But for me, this was the line I drew for myself the day I started my channel. And when I draw a line, I try very hard to stick with it unless there's a really good reason to change it. And for me, there wasn't. It just made sense that the hobby should pay for itself. Rocket Couch, me too. Let me just put this up. Let me just find this comment over on this side now. Personally, though, that's one reason I like to have talented friends, and I can pass the torch. And with luck, I still get to see the idea take shape. Exactly. And I have collaborated with some wonderful videographers, wonderfully talented people. Like you see my intros, I'm all very proud of them. I have not created most of them. There are a few I did. I could take credit for very few of them. But the ones that I'm using the most now are the courtesy of those people that I actually give credit to all the time. Mocking Media and Counter Talk, okay, have really put what I would envision out there. And in regards to Mocking Media, he's usually just asks me a few questions and then puts together something that I couldn't have even thought of being as good. One of the recent projects we just did was trying to downsize our intro to true crime, because a lot of people like to follow true crime, but I am getting some comments that they really don't want to wait so long for the intro. And that's why I started time stamping the intro. But some of them, they even say it's too much effort to push the timestamp. So we have just recently pushed that one down to 45 seconds from like a minute 52, which wasn't easy to do. But I think Mocking Media did a brilliant job of getting the concept out there from start to finish of this whole true crime scenario, from like when you get accused and arrested to when the door slams behind you, the judge, the whole thing. Not as pretty as the first one. I still love the first one. And I'll be using that as the outro, because by the time the video's at the end, I don't care if they get pissed that it's more than 45 seconds. I love the creativity that is in that short video, in that intro outro. I love it. And I stand by it, So, I do love working with other people to do it. I just want to actually be able to do more, especially with my reads. I've been doing a lot more of reads. Some of you know about the project for the Hitchhiker's Guide to the Galaxy that I've been putting out in Bear's Library, which is another part of my channel, which is all just reads with very little video to go with it, but just, concentrating on voice and the story. And we're bringing Douglas Adams' whole series to YouTube because I loved the book. I've wanted to do that since I came out here. Like, I've wanted to bring a whole series to light. Like, I did Kafka's Metamorphosis. I've done some Stephen King. I've done a lot of Edgar Allan Poe. I even did William Blake. And I've done some naughty books too, like Jiggle, Wiggle, Pickle and things like that, But I really wanted to bring, just great stories out. In this project actually brings a lot of other people's voices into it. Every chapter is read by a different person, and it makes it more interesting to go through the story. Some people may find it a little disjointed, but for me, it is in celebrating Douglas Adams' original vision of a great story, just a great story that would mean so much to so many people in so many different ways. Everybody looks at it a little differently. It stood the test of time. To me, it's a classic. It's so enjoyable, and everybody has a different take on it. So adding all those different voices, some of them using sound effects, there's very, very little visual. There's like one thumbnail through the whole thing. And now, with the ability to create my own AI generated art, and yes, I create the AI generated art for that series. I'll put it in the description of the actual playlist, but I do need to add it to every video that I've done that, because I am looking at the new, conversations that are going on in regards to using AI generated art and stuff like that. I do not fashion it after anything except for the characters' names. Each one's a little different, We are going to be bringing book 2 of that series out in February. Restaurant at the End of the Universe is in what do you call production now? Like I sound like I'm from Hollywood or something. Oh, it's in production. What it is. I mean, people are actually reading the chapters and sending them to me. And then with the help of the person that I absolutely love that does audio for my channel and has helped me so much this last year in how I use my skills with my mic, how my audio has actually improved and helps me with the editing and audio for the whole project of Hitchhiker's Guide. That would be MC Wrecker, who, oh, just as if I was thinking about him, he just like joined the chat. Oh, yeah. Oh, that's a good suggestion. My long intro though, I'm actually using it as the outro now because I don't want to use the outro from before that had the members on it that I had to keep changing like constantly. Because my friends do this, like people that I love working with, collaborators, creative collaborators and friends, and I don't want to take up their time doing that all the time. So I'm going to use the long one as the outro, but use it for my legal playlist. Can you actually put an intro on a playlist? Because if you can, I didn't know that. Wrecker, we need to talk. Like, if you can do that, then I want an intro for every one of my playlists. Like, now people are going to get busy. Look what you did. Look what you did. But anyway, I was just singing your praises there. Take your accolades, everybody. The man behind the audio in helping with the project, that's him right there, MC Wrecker. And I couldn't tackle this huge project without him. So Columbo says, oh, just one more thing. Yeah. Oh, how many books are there, Turtle? I believe there's 6. No, I read the original 3 when they first came out, and then it continued. And then there is some speculation. I'm not sure I'm going to do the last book in the series, whether it be 6 or 7. I'm not sure. Because it was put out after Douglas Adams died, and it was only put out with some of his original content. Somebody else helped finish the story. And I don't know how I go back and forth about how I feel about that. That might be a good question for you guys in the chat. Some of you have participated in this project. Some of you have sent me very nice notes about the project in general that you love, listening to the audio chapters. How do you feel about that? If it was not all of his original work, do you want to include it in the series? That's the thing. Thank you, Liam. Just me being able to stream better. Yes, without those interruptions in resources. I agree. Without any of those problems, Some things like my forgetfulness on the banner, which I just realized I did again, which I should hold for a few minutes until they come back. Oh, and they're back, so I missed it. Okay, here we go. Oh, okay, they're back, but they're not back. They're showing us the wall. Okay, do we need to see the wall? Okay, let's keep it like this until they start talking. All right, and so I can put up the banner for just a second until they start talking, and then I'll take the banner off and put them back up again. Okay, Rocket says, personally, because some of it is his original work, then that's good enough for you. That's a good point, Rocket. Because the whole point of the series is to actually proclaim how great I think Douglas Adams is, but yeah. Yeah, Liam, he's getting some practice on how to highlight a panel. That cameraman. Yeah. Yeah. Oh, you read the draft, Liam, before it was expanded? If you could get a hold of the draft, could you get a copy of that and send it to me? Or I've got to look for it. I want to actually see what they changed.
Please be seated.
I'm quiet now. I'm not messing with Judge Toal.
is state ready to proceed?
Proceed. I think they're still getting the defendant ready to sit down, but
Very good. We certainly will wait on that, Mr. Harpootlian.
Your Honor, once he's seated, I have a matter I need to put on the record.
All right, sure. Yes, sir.
Your Honor, we last week discussed the standard by which you would proceed during this proceeding and evaluate the evidence. We argued that you should use a case called Bremer. You rejected that. But under any standard, as I understand it, the burden of proof is on the defendant to show certain statements were made or certain conduct happened. So far, Your Honor has called as court witnesses 12 witnesses. We were not offered the opportunity to cross-examine them. And so we've not had the opportunity to present any evidence whatsoever. And before the state presents evidence, I believe that we should be able to call witnesses. And I would ask the court to allow us to present some evidence before the state comes up with rebuttal. And by the way, under the cases you cited, they have no affirmative obligation to present anything at this point. There's no requirement they present anything. So I would ask you to allow us to call a witness or two before you make a decision as to whether or not they need to call a witness.
State?
Your Honor, we obviously have argued very extensively some of the cases, and I think the South Carolina jurisprudence is very clear that while an evidentiary hearing is appropriate, and that's what we're doing here, that manner of inquiry is purely within the discretion as the trial judge sees fit. This is not a criminal trial where we're here with the jury to present the normal criminal trial process. This is a inquiry that is very much directed by the trial court and what the trial court thinks is appropriate. And so the state certainly is comfortable with the inquiry the court is conducting. And my understanding is, as far as putting up Ms. Hill, this is the manner in which the court wanted that evidence presented. And so we're happy to comply in that regard. But we think that this inquiry is within your discretion, and we have no issue with the manner in which Your Honor's proposed to conduct it.
Please, the court, Your Honor. Certainly, the conduct of this hearing is within your discretion. What is not is who has the burden of proof. We do. And we can't meet that burden if we can't call witnesses. And so I'd ask the court to allow us to call witnesses. And if at the conclusion of us presenting those, you believe the state has required to present evidence to contradict that evidence, or in some way, I'm not quite sure, since Remmer is not the standard, I'm not quite sure what they have to prove, but that's an argument down the line. I believe we ought to be able to call witnesses now, and we have witnesses which would substantiate the burden we have to show you that statements were made by the clerk of court, and that those statements had impact on a juror or jurors.
All right. I've got a couple of reactions to that. Number one, the pretrial was the time to figure out exactly what we were going to do here. And I think it comes at the last minute for you to now come and say, we want to present witnesses. You briefed the matter of witnesses. We had a long pretrial. After I made my rulings on what I thought the scenario was that should be used based on State versus Green, you lodged objections to that, but you did not offer at that time any information about who you wanted to call other than this lengthy filing in one of your briefs. It comes pretty late in time for, in my view, for you to do that now. Second thing is, I gave the defense a big break when I allowed you to be the cross-examiner and the state to be the presenter of Becky Hill. She's really a witness that each side needs to prove their view of what happened in this matter. The state puts her up to try to show that there was no impact by anything she said, and that some of the things your witnesses say were said, she says were not. So there's a conflict in the evidence there. I'm not going to rearrange the situation and go to any witnesses of yours right now. I'm going to see what Ms. Hill has to say. And then afterwards, we can talk about whether there's any need for any other witnesses.
Your Honor, just factually argue this with you. We did not understand. We assumed you'd adopt Remmer because that was.
Well, I don't know why you assumed that.
Because
when
that's
the
the
South Carolina Supreme Court said very clearly that we do not go by the guidance of the 1950s case of USB Remmer.
We do not believe that's what Justice Kittredge has said.
He said it straight out, as clear as a bell can be, but I ruled on that.
Yes, ma'am.
And,
All I'm saying is-
and the South Carolina Supreme Court's going to have plenty of chances to decide that they want to modify Green.
Well, when we were somewhat taken aback by a ruling as a result, and that ruling came at a point where we didn't know what these witnesses were going to testify to. So we now, and by the way, you've set aside 3 days for this. What's the hurry? This gentleman is facing life with no parole. We should take this in a very deliberate way. He's got a 14th Amendment right to ensure that he had a fair
These
trial.
arguments should have been made before this time,
Why?
Mr. Mark. Well, Mr. Harcourt, I've told you how I'm going to handle this thing. Your objections are noted and they're on the record. But right now, what I'm going to do is what I said I would do. We're going to call Ms. Hill and see what she has to say. I have no idea who all you want to call as witnesses or whether they're here in the courtroom at the present time. But we'll get to that after Ms. Hill testifies.
Yes, Your Honor.
All right.
Just let me bring to your attention this email.
Just one moment. Let me go to a little something here that I'm just getting an email on and put this on the record right now. I have a communication from Mr. McCullough that's only, that is copied to Mr. Harpootlian, Mr. Griffin, Mr. Waters, and Attorney General Wilson. And basically says his client, Juror Z, wants to enhance the testimony she gave with some sort of affidavit that he wants me to look at, and I have looked at it. I want to hear from the state and the defense, but I can tell you, I'm not inclined to get back into the testimony that's already been taken by these jurors. Her inconsistencies, whatever they are in the record, and she now wants to have another bite at the apple. I'm not at all enthusiastic about that, but I will hear from you, Mr. Waters, first.
Your Honor, the jurors testified, the court conducted the inquiry that needed to be conducted. She answered the questions. I would agree with Your Honor that multiple bites at the apple are not warranted. So we believe we should proceed forward as the court has indicated.
All right. Mr. Harpootlian?
Your Honor, I'd note two things. The first thing is we asked to be able to examine this juror. You denied that request. Number two, she's not our witness. She's not Mr. Waters' witness. She was the court's witness and a juror that, and you commended all of them on their honesty. She's attempting to be honest. This process we're going through is an effort to seek the truth. This is the truth. I don't understand why it can't come in.
I think I understand what your position is, Mr.
So we'd ask you to make it a part of the record. You can say you're going to consider it. You're not going to consider it, but it should be a part of the record.
Well, I'll give some thought to whether this thing should be a part of the record, but I can tell you this. Witnesses don't get on the stand and testify under oath and then seek to add or change or deal in any way with their testimony. Those questions were very open-ended questions that asked for her responses, and she gave them. If they're inconsistent, she can't come up now and try to close the loop of consistency by some additional testimony. I am not thinking about allowing that to be done.
With all due respect, Your Honor, we believe, and we said at the time, the way you questioned her put her in a position of saying, yes, that was my verdict then. We think, and we couldn't examine her, and Your Honor, to say now that this affidavit doesn't accurately depict her position is to deny fact, the truth.
You've already said that once. I know your position on that matter, but I decline to adopt it. All right.
We'd make this an exhibit as a proffer for our case. This affidavit, we proffer it for our case. We have the burden.
I'll give some thought to it. I'm not ready to deal with that right now. I have looked at it just in the moment right before I put it on the record. I'll do some research about that, and we'll close that loop before the end of the day.
Your Honor, again, I indicate we have 2 more days. We don't have to wrap everything up today. Thank you.
Yes, sir. All right. Mr. Waters.
Thank you, Your Honor. The state calls Rebecca Hill.
All right. Get Ms. Hill and bring it to the courtroom.
Do you swear or affirm that the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good afternoon, Ms. Hill. How are you?
I'm fine.
I want to get started, if you would, if you could state your full name for the record and spell it for the court reporter, please.
My name is Becky Hill, last name Hill, Hill.
All right. And if you would, just give us, you're currently the clerk of court for Colleton County, is that correct?
That's correct.
And just very quickly, if you would, what year were you elected as clerk of court?
At the end of 2020.
At the end of 2020?
Yes.
And prior to that, did you have any involvement or experience with the state judicial system?
I did.
And could you tell the court what that was, please?
I was a South Carolina official court reporter for about 14 years.
All right. And were you, in being an official court reporter, you would serve in the courtroom, which is Ms. Harris is here today, is that correct?
That's
what
correct.
Was your, and was that primarily in the 14th Circuit?
It was primarily in the 14th Circuit. However, I did travel throughout the state.
Did you have any other experience in professional experience prior to becoming a court reporter or clerk of court?
I was a court reporter freelance for 2 years before that.
Okay. And then any other professional pursuits you've had over the course of your career?
I was able to be a middle school teacher, and I worked for the Board of Disabilities for a few years as well.
Let me go ahead and just kind of get straight to it. In your capacity as clerk of court and in your previous experience being a court reporter, were you familiar with the rules that apply to court staff as it comes to interactions with jurors in the course of a criminal trial or a civil trial for that matter?
Yes.
All right. And could you tell the court generally what those rules are as far as what contact is permissible and what contact is not permissible, just very quickly?
The judge gives the law and gives the instructions for a jury. And the attorneys will state their opening argument, their opening statements, their closing arguments. And basically, the clerk of court and anyone else, court reporter, we're there to, my understanding would be to make sure that everyone's taken care of. Do you need some Kleenex? Do you need some water? Different things like that, just to make sure that they're taken care of.
Is it common for clerks of court to have interaction with jurors during the course of a trial to see to those various logistical needs that you just described?
Yes,
And did that happen in the Murdaugh case?
it did.
And can you give us an example of some of the logistical things that you, or other things that you would see to deal with any needs that the jurors may have? I mean, did you provide them food, coffee, make sure they were comfortable, things like that?
Yes, all of that.
Provide blankets for them if they were cold?
Our courtroom was very cold in Colleton County, yes.
Did you provide them with aspirin or Tylenol if they needed, make sure coffee and snacks were available?
Yes,
Did you take lunch orders for them so that they were fed each day?
yes.
At any time, did you interact with any juror in an attempt to influence their view of the facts in the State v. Murdaugh case?
No,
All right, now I want to ask you some specifics about that and some allegations that have been raised. At any time, did you tell the jury not to be fooled by evidence presented by Mr. Murdaugh's attorneys?
I did not.
At any time, did you instruct the jury to watch him closely and look at his actions?
I did not.
At any time, did you instruct the jury or tell the jury to look at his movements?
No,
At any time, as the jury moved to deliberate, did you tell the jury this shouldn't take long?
no,
At any time, did you tell the jury that the defense case, watch out for the defense case, they're going to try to throw you off, or anything along those lines that was meant to influence the jurors against Mr. Murdaugh?
no.
Let me ask you if you ever made any comment to the jurors about the fact that the defendant was going to testify. Did you have a conversation in the presence of the jurors prior to the defendant testifying about the fact that he was about to testify?
It wasn't directly related to the jurors. I was talking to Mr. Bill, who was our bailiff foreman, our bailiff over the jury, and I was talking to him about that.
All right. And what did you say?
I told him what I had just come from downstairs telling my security and bailiff office, that Judge Newman had allowed more testimony in regarding the financials, and that also the defendant had decided that he may testify.
All right. And where were the jurors at the point that that conversation occurred?
There were a few jurors standing in line, and there were some in the bathroom, I'm sure, because they said they were waiting on jurors to get out of the bathroom. And there were some in the jury room just milling around from what I could see, looking down the hallway.
And again, what were the words that you said during that conversation? What were the effect of them?
To Mr. Bill.
Yeah. And what did you say?
I told him that that Judge Newman was allowing more of the financial evidence in, which would prolong the testimony in the trial a little bit, and also that the defendant had decided that he was going to testify.
Did you say anything about this being an important day? Pay attention. We'll get coffee for you. Things like that during that?
I usually give a little pep talk to the jurors. It's sometimes hard sitting a long time, but my usual, and I do remember saying, pay attention. It's a big day today. Whatever you need, let Mr. Bill know, or one of the other bailiffs, and they'll be glad to get it for you.
Did your comments, or were your comments in any way phrased in favor of one side or against another side, or were they more of a neutral comment about paying attention?
No, it was not for one side or the other.
Were you present when the jury went to the Moselle property to conduct the jury view?
I was.
All right. And was Judge Newman there as well?
He was.
During the time that you were on the property, traveling there, traveling back, did you have any conversation with the jurors where you made any comment about the substance of any testimony or any comment about the merits or the strength of the case?
No, no.
Did you have a quick comment to the forelady about how the property was beautiful and there were tea olive trees there that bloom and smell good, or words to that effect?
I did.
All right. And was there any other conversation related that you had where you made any comment about the case or the merits or anything like that?
Oh, no, no.
During the course of this trial, did you have a bailiff employee whose primary job it was to see to the jury and their security and to keep them separate from everyone else that was involved in this trial?
I did.
And who was that?
Mr. Bill Polk.
All right. And he was ultimately the jury coordinator in this particular case?
That's correct.
During the course of the deliberations, once the jury went back there, did you have any contact with the juries or have any substantive discussion with them?
Not at all.
Did you have any discussion with them about logistics, about staying in a hotel or anything like that?
I did not.
Did you have any interaction with the jurors or anything to do with them having smoke breaks or anything like that?
I did not.
During the course of the trial, did you have any discussion or interaction with the jurors about them giving any interviews to the media or making themselves available to the media? I'm asking during the course of the trial itself.
No, not during the course of the trial.
After the verdict had been reached and the case was in sentencing, did you have any conversation with any jurors at that time after they had already entered their verdict and been individually polled?
Yes, after the sentencing.
All right, and tell the court what that interaction was at that time.
There were several outlets, news outlets, that wanted to interview the jury as a whole and really wanted to get them up to New York. And so I was trying to get a hold of all the jurors to talk about that. That was something we had not prepared for.
Did you at all pressure the jurors to speak, or did you just tell them that it was their option to speak or not, and here's the contact information?
I did not pressure the jury to speak. No.
Did you advise them that it was their decision and their decision alone whether or not they wish to speak to the media?
It was totally their decision.
And did you advise them of that?
Yes, yes.
I'm going to ask it again, but I just want to be sure. At any time, did you make any comment to any juror or in the presence of any juror in which you at all tried to influence them in favor of one side or against another?
I did not.
Did you understand, being a longtime court employee and clerk of court, that that is outside the boundaries of what is appropriate interactions with the jurors during the course of the trial?
Absolutely.
And at any time did you violate that rule that you understood?
I did not.
Court's indulgence, 1 moment. Nothing further this time, Your Honor.
Please, Court, Your Honor.
Mr. Harpootlian, on cross-examination.
Ms. Hill, we spent 6 weeks together, didn't we?
We did.
And during those 6 weeks, you were as helpful to me as you could be, correct?
I was.
Accommodated just about every request I made.
Yes, sir.
Wait.
That was the court. That definitely wasn't me.
Where were we? Oh, yeah, we're old friends.
Heard, that was the microphone that was supposed to, you're fine where you are, absolutely fine.
Yes, ma'am. It was a staged microphone that was obscuring my ability to question a witness.
Yeah, well, what I'm wondering is whether you can be heard without a microphone. Do we need to try to get a microphone
I
up on
can
this
hold this
podium?
mic over if necessary.
Yeah, that would be good. All right.
I don't know who's supposed to hear this other than you, but I assume they can hear us. Court reporter, I'm sorry. She's more important, not as important as you. Your
Yes, I agree.
Honor. Oh yeah, we're old friends, right? We spent 6 weeks together in a very pressure-filled situation, correct?
It was a long 6 weeks.
It was a long 6 weeks. And during those 6 weeks, you were helpful to me in a number of different ways. Accommodating friends that I had that wanted to come watch the trial, for instance, correct?
That's correct.
You even allowed me to use the private restroom down on the first floor so I didn't have to stand in line with the rest of the people trying to get breaks, correct?
Correct.
So we have no animosity towards each other. You didn't do something to me and I didn't do something to you during that trial, right?
Absolutely.
Okay. Now, given that, I'm going to ask you some questions today that may indicate to you that I have some antagonism towards you. Let me disabuse you of that. I'm here doing a job representing my client, and you've been around the court system for decades, correct?
Yes, sir.
So you understand what we're doing here today.
Yes.
Now, let me understand a couple of things. I think, and I've read your book, some editions of your book. There's several. We got a bunch of emails in which you have drafts that you forwarded to your co-author, correct?
Your Honor, objection. I believe I would object to relevance. I believe any draft she sent to her co-author with the book is beyond the scope of this inquiry here today.
Overruled. You may proceed.
Thank you, Your Honor. And in those drafts, you say certain things about the trial, about the process, which you later did not include in the final version. It's called editing. Is that correct?
I would agree with that.
Okay. Now, let's talk about this book for just a second. When did you first decide you were going to write a book?
I think a thought was there, a very fleeting thought before the trial.
Did you take any steps before the trial or at the initiation of the trial to begin writing this book or working with somebody on this book?
Oh, no, sir.
When did you and your co-author get together?
It was several weeks after the trial.
Okay. Did you talk to anybody about the fact you were going to write a book before the trial?
There were several anchors and several journalists that I did speak with about the possibility of writing a book.
I'm so disorganized, I apologize. Did you seek assistance in this trial from other clerks of court?
Yes, sir, I did.
And who were they?
Rhonda McElveen, who is the Barnwell County Clerk of Court, and Renee Elvis from the Horry County Clerk of Court.
And Were they there with you the entire 6 weeks?
No,
I mean, how long were they there? How often were they there?
Rhonda McElveen was there as often as she could be, probably several times a week. Renee Elvis helped me during the jury selection.
And did she begin, that is, Ms. McElveen, did she begin working with you prior to jury selection?
Can you repeat that question?
Was
one more
she,
time?
we began jury selection, I think, on January 23rd, correct?
Correct.
Was she working with you or consulting with you prior to the 23rd?
No, sir.
Did you have any conversation with her about the trial?
Not until she got to the trial on what, I can't remember the exact day she came.
Okay. Now, is she a friend of yours?
She was a friend, yes.
Was?
Well, she is a friend,
Okay.
yes.
She's done nothing to make you any less a friend.
No, sir.
Now, did you tell her about the time of the trial that you were going to write a book? That you had thought about and were going to write a book?
I can't remember exactly. I think we did have a conversation about a book possibly in the future.
And did you tell her you're going to write a book because you thought it would make a lot of money?
Oh, no, sir.
You never said that.
No, sir.
And did you tell her that you were going to write a book to make a bunch of money so you could buy a lake lot and build a house on it?
No, sir.
Okay. Now, did you ever tell her that you had given a juror a ride home, that you had accompanied Mr. Bill, what's his last name?
Bill Polk.
You're right. That you and he took a juror home one night? Did you tell her that? Did you take a juror home one night?
I didn't take a juror home one night.
Did
No,
Mr.
sir.
Polk and you take a juror home one night?
No, sir, we
Okay, you
didn't.
never gave a juror a ride in a car with Mr. Polk or without?
No, sir.
Okay. Now, also, during the trial, your daughter ended up on the Venari, is that right?
She did.
And she was coming up, and did you talk to me and Mr. Waters about putting her on the jury if at all possible?
I'm not sure that we wanted her to be on the jury if at all possible, but I think the question was, would she make a good juror? And I said, she sure would.
Now, I don't think we asked you. I think you told us she would make a great juror. Did you not?
I remember you asking.
Okay. Okay. I was considering putting your daughter on the jury.
Yes, sir.
And who does she work for?
She works for Compass South.
Did she work for the sheriff's department at some point?
No, sir.
Okay. Did she work in law enforcement at all?
No, sir.
Okay. Now, let me ask you this. How many jury rooms were there?
We have 2 jury rooms in Colleton.
In this trial, how many jury rooms did you have? How many?
2.
Okay, so the entire jury wasn't together at any one time. They were separated into 2 rooms?
Yes.
Okay. And when they're separated into 2 jury rooms like that, are they next door to each other? Are they down the hall from each other?
They are next door to each other.
Okay, so but if you close the door to one, can they hear what's going on in the other one?
Some women probably have very good hearing, and men too, but I would say probably not.
Okay, are there restrooms in both of the jury's rooms?
There are.
Okay, are there 2 restrooms or just 1?
There's 1 restroom in each jury room.
Okay, were either one of those restrooms designated men and women, or did everybody use the same one?
They were unisex.
They were unisex. Okay, now, prior to your testimony here today, have you met with the Attorney General's office in SLED?
I have.
On how many occasions?
I want to say twice.
Okay, and remember when the first time was?
I think the first time was in September.
Okay, and the second time was last week,
Yes, sir.
and that was in Walterboro?
Yes, right.
And y'all spent about 4.5 hours together?
I want to say maybe 2 hours together.
Okay. And in those 2 hours, you went over your testimony here today?
They asked me questions.
Did they ever correct your answers or suggest you answered differently?
Oh, no.
No.
Oh,
So
no.
you just went through what you went through in 20 minutes here. It took 2 hours to go through when you were with them.
There were times when I would step out of the room and come back in. But I would say we were there for about 2 hours.
Now, you have described in your book your role as Switzerland. Is that correct?
Correct.
Okay. And that is that you should not be in any way opinionated about what's going on in the trial. Is that correct?
That's true.
Okay. Yet in your book, you indicated a number of different points during the trial you had concluded he was guilty. Is that correct?
I think,
Your Honor, I object at this point. I don't know if her conclusions in the book are in any way relevant to what occurred during the trial and whether or not there was any communications with the jurors, which is the sole issue that we're here for today, is whether or not Ms. Hill had any extraneous influence on the jurors. And so I think this is going a little far afield. We object to the relevance, Your Honor.
Overruled. You may continue.
Let me give you an example. You indicate riding back from Moselle that you and 3 other people were in a car and you all decided adamantly, I think was the word you used, that he was guilty, that he had killed his wife and son. Is that what you put in the book?
I can't remember if I put that in the book, but if you say I did, then I will
Did
agree
that
with
happen?
you. We did have a conversation about what each of us thought,
And they all 4 agreed that he was guilty, correct?
and none of us were jurors.
No, trust me, I know that. But you had an abiding conviction, at least by the time of the Moselle visit, that he was guilty. And the other people in the car with you were bailiffs, were they not?
No.
Who were they?
Some were not bailiffs. One was a court reporter. One was our security officer, head security, and another was a deputy sheriff.
Okay. But the 4 of y'all rode out there, and based on what, and I mean, you want me to read to you how chilled you were and how you felt that poor Paul and Maggie had been executed by him on that scene, that visiting the scene convinced you that he was a horrible, horrible murderer? You want me to read that to you, or you will concede that's what you wrote?
I will concede that's what I wrote, but if I may, I would say that a lot of that is poetic license in writing a book and in making it sound like that.
Okay, so some of it's poetic license, and some of it you just stole. You purloined it from that BBC writer, right?
Right. Again, I object to not only the relevance, but the scope of cross. I would object also under Rule 608. I don't believe that's appropriate cross-examination.
Overruled. You may continue, Mr. Harper.
Did you steal part of the book?
I did plagiarize,
Okay,
Mr.
so
Hartfield.
that's stealing, isn't it?
And it is, and for
Okay.
that, I'm very sorry, and I have apologized.
Okay. And that makes it okay?
What I did, and I
Okay.
apologized for
Okay.
that.
And part of the book is, you say, literary license, exaggeration?
I wouldn't call it exaggeration.
Okay. Now, let me ask you, this is Switzerland. And you're saying this is happening while you're supposed to be Switzerland. You decided the defendant's guilty. And if Ms. McElmeen says that it's going to make you more money if he's found guilty, don't you think it's reasonable to assume that you may have crossed the line from time to time?
Your Honor, I object to the form of the question, assuming facts not in evidence.
Overruled.
Can you repeat that question one more time,
I'm
Mr.
not going to
Hartfield?
repeat it. Let me just move on to something else. Let me ask you, you had interactions with some jurors, and I believe in a conference in judges' chambers, you indicated that you had seen a post on, is it Walterboro Word of Mouth?
Your Honor, again, I object. I think he's delving now into the Facebook inquiry. We believe again that that's irrelevant to the inquiry for Your Honor.
I will allow a limited, as I understand it, trying to impeach her testimony and explore her credibility. And I think I've already told Mr. Harpootlian that I don't want a whole trial about the business of Facebook and the egg juror, but I will allow limited examination on this point. You may proceed, Mr. Harpootlian.
Am I oversimplifying that? I mean, it's in your book. You saw something on Walterboro word of mouth, which appeared to you to be from the ex-husband of one of your jurors. Is that correct? Am I oversimplifying that?
I remember reading one night something on Walterboro word of mouth. And when I was in the courtroom on a Monday morning, listening to the judge and the attorneys talking about a matter, it sounded like it was relevant to each other.
Okay. And you became aware somehow that this juror had a restraining order out for her ex-husband?
She told me that herself.
Okay. And tell me how it came for her to tell you about that. Where did she tell you?
She was very talkative. And when I was instructed by Judge Newman to go and get her from out of the jury room with a deputy following me, she was talking to me all the way back to the judge's chambers. And she mentioned that there were restraining orders out when they had divorced.
So how did the judge, who brought it to the judge's attention about this Walterboro word of mouth thing?
I let the judge know, thinking that it could be related,
Okay. And you let the judge know what?
that I had read something on Walterboro word of mouth.
Okay. And that you knew it was tied to that juror?
I didn't know that it was. I wasn't sure at all.
Who do you think it was tied to?
From what y'all were talking about at the bench, I felt like I needed to let him know, just in case it was related. There was something about an ex-husband and an ex-wife and somebody being on the jury.
You didn't tell the judge that you had found what we call the apology post? You didn't tell the judge that?
I didn't call it that, no.
You don't remember producing it, saying that producing it to the judge, saying this is a post in which the guy that posted it on Friday night says the devil got in him and drinking and he apologized for what he posted? You didn't produce that?
My staff did, one of my staff.
But you gave that to the judge and gave it to us, did you not?
Yes, we did.
As if it were from that juror's ex-husband, correct?
Correct.
And you know it wasn't?
I don't know that, Mr. Harpootlian, no.
So, and this, you did not take that juror out and talk to her before you took her to the judge? Is that your?
I never talked to that juror about stuff like that.
Okay. Did you ever talk to the forelady of the jury, separate from the jury?
I did.
Okay. And tell us, where did that occur?
When I would go into the jury room and I would speak with the forelady, we would be in like the hallway in the two jury rooms were side by side, and the opening to the jury room went out into the hallway, and we would be surrounded by the jurors at all times. Mr. Bill would be very, very nearby, or another bailiff as well, when we would speak.
And what did you speak to her about?
There were several instances. One was there was a juror who needed some feminine products. There was another time when Band-Aids were needed. There were times when Tylenol would be needed.
Other than items that were needed by the jury's health object, did you ever discuss, did she ever discuss with you, is some issues jurors had emotionally or some issues with dissension in the jury room?
She only told me that there were some loud jurors and it made some of the other jurors a little upset. But other than that,
What did you tell her to do?
I told her if it got out of hand to write a note to the judge and that she could sign the note and get Mr. Bill to give it to the judge, and the judge would handle that for her.
Okay. Now, you did publish a book after after this trial. Is that correct?
We did.
And you went to New York and took some of the jurors to the Today Show.
The Today Show did invite us, yes.
Now, one of those jurors that went up there with you, the day of the verdict, wore, for the first time I can remember, wore a suit to court. Do you remember that?
Your Honor, again, I would object to discussion of the jurors wearing a suit or a post-trial trip to the Today Show. I don't believe there's any connection to the inquiry that's focused for Your Honor, and that is whether or not there was any extraneous influence during the course of the trial.
I'm going to connect it, Your Honor. I believe.
All right, overruled. You may continue, Mr. Albuquerque.
Did you text, email, or communicate on the morning before final arguments were completed that to people that this was on a Thursday, that they probably, if they're going to see the trial, should come on that Thursday because it'd be over by the next day? It would be, the jury would not be out very long. Did you ever communicate that? Email, text, or verbally?
I do remember saying that, yes.
And why did you think the jury would not be out very long? Had you communicated with jurors?
I had not communicated with jurors about anything related to this trial at all. I've been a court reporter for at least 14 years. I was clerk of court for 3. And you just get to where you kind of see things happen as they progress. And it's a guess, it's a gut feeling. And that's all that I meant by that.
Well, why are you telling this young man who wanted passes for the next day in an email, it won't be happening tomorrow? That was or did you say, you didn't say, I don't think, you just said, you better come today if you're coming. Remember doing that?
I don't remember that. But, if he wanted to come, I knew that the trial would be ending shortly as far as testimony. So if he wanted to come, he needed to come.
Why wouldn't the jury have been out a week on a 6-week trial?
They could have.
But
They could have.
you apparently were telling the press and others that there'd be a quick verdict. Were you not?
That was just a gut feeling that I had.
Okay.
And that was my opinion.
Okay. Your opinion, you were right. Jury was out 3 hours on a 6-week trial, correct?
That's true.
How much money did you make off that book?
There was not a whole lot of money made off of the book after paying different things and paying for some expenses that went along with that. But I want to say roughly around 100,000.
Okay. That's not a lot of money.
No, especially when you publish your own book.
But that was 100,000 you made.
With my co-author.
Okay. In what period of time? 6 months?
I would say 6 months, yes.
When was the book published?
August 1st.
Okay. The trial was over. That's 6 months after the trial's over, you've published a book, correct?
Correct.
And then I believe you've recently stopped selling the book because of the plagiarism you've admitted to, correct?
Correct.
And so there's no more money?
Correct.
Now, you also indicate in the book that the Murdaughs had a reputation of criminality, I think is kind of what you put. Did you not?
Well, Mr. Hartpooley and my grandfather and Old Man Buster were very close.
Well, were they criminals?
I wouldn't know.
You wouldn't know, but you believed and you published that the Murdaugh family had run that part of the state and they'd been participated in criminal conduct, correct?
Your Honor, again, I would object to general testimony about the alleged criminality of this family. I'm not sure how that has any bearing on the focused inquiry before the court.
He's asking about what she said in the book. I'm going to allow it.
Yes, sir. Did you say that in the book, that they were criminals?
In the book, that was more of the literary ease that we take, I think, to make a story a little more interesting for the reader.
By calling people criminals? I guess what I'm saying is this. Were they criminals?
Your Honor, again, I object to that particular question.
Overruled.
Were they criminals?
I wouldn't know that.
Okay, so you either made it up or you're lying about it? about the reputation of people that can't defend themselves? They're dead? You're going to call them criminals? You did that in the book so you could sell a book?
No, I didn't do that to sell a book.
What'd you do it for? Made it more readable, you said? Which
Liter-
sells books?
Literary ease. Yeah.
What?
Literary,
Literary what?
the literary ease that you can take with when writing a book.
Literary ease you can take with writing a book. You can make stuff up. You can lie. You can lie about people.
Not with that. I think the public perception was one that it was very interesting during this time.
So you're feeding the monster out there that wants to believe bad things about the Murdaughs, and you'll make stuff up to do it. Let me give you another example. I read your book and I found this somewhat humorous. My co-counsel did not. In describing myself and Mr. Griffin, in the book you say that I neutered him. We've both been very interested in what you meant by that. What do you mean by neutering Jim Griffin?
Mr. Hartpoolian, it was a book.
Did you make it up? I know it was a book. The
Right.
Bible's a book.
Right.
Just because it's a book doesn't mean you can lie in it.
It's just a word that was used.
Nature of that exchange.
Don't argue with the witness, but the witness, Ms. Hill, you're instructed to answer his questions. You may proceed, Mr. Hartpoolian.
So let me get this straight. The book, and I'll see if I can cut to the chase on this. I could read you chapter after chapter, verse after verse, which is not true. Okay, not true based on my experience of being in a courtroom, and not true based on knowing some of the people you described. You say that is.
Mr. Hartpoolian.
I object. The counsel is just testifying right now as to his observations about the book.
Question, Mr. Hartpoolian, please.
You have conceded there are things in the book that you don't know to be true, correct?
Correct.
Okay. You would concede then that you have lied in the book.
It's only because I wasn't there at the time. I can't interview my dead grandfather. I can't interview Mr. Buster. There's just things that we can't interview them on. We can go by what was written in a newspaper and get facts from that.
And take the inference that one of the Murdaughs was a pedophile. You could have printed that, and they're not here to contradict it. You could have printed anything you wanted and made it up to sell books. That's what this whole scheme was about, selling books. As you told Rhonda McElveen, if him being found guilty would sell more books.
Your Honor,
Isn't that true?
I'd object to the argumentative nature of the question, the compound question, and assuming facts not
It
in
is a
evidence.
compound question. If what you're asking is what she told Ms. McElveen, go on and ask that, but don't precede it with
Yes, Your Honor.
testimony.
Beg the court's indulgence for just a moment. Write your book about that juror whose ex-husband had posted something we now know probably wasn't her ex-husband. Did she have any other ex-husbands that you found out about?
I have no idea.
Well, you wrote, we learned later the ex-spouses hadn't seen each other in 14 years and she had 3 restraining orders against him. Did she have 3 restraining orders against him?
I don't know. That's what she said.
Okay. Did you tell jurors at the end of the trial after President's Day break? President's Day break would have been a Monday, correct?
Correct.
But before Mr. Murdaugh testified, did you tell the jury not to be fooled by the evidence presented by Mr. Murdaugh's lawyers?
Mr. Hartpoolian, I never talked to the jurors about any of the evidence
If the
in
answer
this
would be
case.
yes or no, then you can explain. Did you say that?
No.
Okay. Okay. Did you ever instruct the jury to watch him closely immediately before he testified, looking at his actions, looking at his movements? Did you ever tell a jury to do that?
No.
Did you ever tell the jury to pay attention to Mr. Murdaugh's testimony?
To pay attention, not specifically to his testimony. I did tell the jury to pay attention.
To what?
Just generally in the hallway when I was speaking.
Not to him,
No,
just any witness.
right.
Okay. Did you ever warn the jurors the defense is about to do their side? This is right before, right at the beginning of the defense case. They are going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off. Did you ever tell the jury that?
No, sir.
Okay. Did you ever tell the jury, if you get emotional, we want to see your face because that is what they want to see? Did you ever tell them that?
No, sir.
Did you ever tell the jury that Mr. Murdaugh was about to testify?
I didn't tell the jurors that.
Now, did you tell the jury that if they didn't reach a verdict by 10 o'clock, they were going to have to spend the night?
No, sir, I did not.
Did you ever tell them they were going to have to spend the night at
No,
some
sir.
point? Did you ever tell them that they couldn't smoke?
No, sir.
Okay. You got any other books in the works?
No, sir.
I mean, doesn't this make a good book? Thank you.
Yes, sir.
Your Honor, there were a few matters that came up on cross, obviously, that I'd objected to.
You won't waive your, you may reserve your rights to object to the entire line of testimony, but you may offer cross-examination subject to the assertion of your objection about the testimony.
Thank you, Your Honor. One of the things you were asked about is finding this Facebook post, and you brought that to the court's attention after a different issue had already arisen related to a juror. Is that correct?
Correct.
All right. And are you technically capable of manufacturing a Facebook post? Is that anything that you have any capability to do?
I'm not.
All right. And did you ask your staff member to go see if she could find this post?
I did.
Did you tell her just generally what you recalled reviewing?
Yes.
And did you give her any further instruction other than that?
No.
Were you sitting behind her as she was doing this particular search or anything like that? Or did she eventually report back to you?
She is very, very techie. And then she reported back to me.
All right. So you weren't there when she was searching anything like that?
No.
She was like, I couldn't find that post, but I did find this, and handed you the Facebook post. Is that correct?
Correct.
And then you provided that to Judge Newman, and ultimately it was provided to the parties. Is that correct?
Right. Correct.
You were asked about conversations that you had with the forelady. Did those involve logistical issues and things like that for the jury?
The conversations with the forelady was everything. There was nothing regarding the defendant and this trial.
All right. So they were logistical issues, not anything to do with the substance of the trial. Is that correct?
Absolutely. Yes.
You were asked about whether or not you had texted some people, this won't be long. Was that at all in any way based on any conversation you had with a juror as to their internal thinking or anything like that? Or was that
Oh,
just your assessment being an experienced person in the court?
Absolutely not.
It was based on just your assessments?
Just my assessments, yes.
Did you ever communicate with the jurors on how long they would be, or did any juror ever tell you how long they thought they would be?
I never talked to any jurors about anything like that.
You were asked about your book, and I don't want to get into too much detail about that, but you were asked about some of the assertions that you made in the book. And you were asked if these were lies. Were they lies, or were they ultimately things that were based on inferences from newspapers and community stories?
You are leading by, this is your witness, Mr. Waters, so please ask a direct question.
Thank you. Some of the statements that you were asked about in your book, were they lies, or were they based on your inferences from just general community knowledge and things that you had researched and knew?
Still leading, but I'm not going to.
Thank you.
He's right about that, Mr. Waters. Just ask a direct question.
Did you lie in your book?
No, I did not.
Thank you. You were asked about when you told the jury to pay attention. When you asked that question, did you also mention anything about, we got coffee for you, or things like that?
I knew that Mr. Bill would take care of that. And the jurors knew too. Coffee, we had done some Dunkin' Donut runs. We had provided coffee, different other things to help stay awake in the cold courtroom that we found ourselves in. And so I knew anything that they needed, Mr. Bill would see that they got, because that's what he did.
At any time, did you have any conversation with any juror in which you tried to influence their decision?
I did not have a conversation with any juror about anything related to this case.
Nothing further, Your Honor.
All right. Ms. Hill? I want you to turn your attention to a hearing that Judge Newman had about the alternate who was dismissed, sometimes called the egg juror. Do you recall that hearing?
Yes, ma'am.
In the hearing, Judge Newman expressed his unhappiness with you for questioning that juror before he questioned her. Do you recall that?
I do remember seeing that.
Well, then let's go back and talk about that juror. You on examination in this courtroom, you said that she talked about a lot of things to you, but you didn't ask her any questions. But that's not completely accurate, is it?
Yes, ma'am, that is true.
Well, you asked her direct questions, and that came out in the hearing that Judge Newman had. You asked her questions before she was even examined by the judge, did you not?
Your Honor, I did not ask her any questions.
The juror was examined by the judge in a hearing. Do you recall that hearing? It's the second hearing on this matter.
I do recall that hearing, yes.
And the court asked you about, the court asked this juror about postings on Facebook, did he not?
Correct.
And the juror said she gave Miss Becky my full access to my Facebook. And I put positive posts on it. I've done that for the past 3 years. Do you recall her testifying in that regard?
I do remember reading that.
And the judge said, has anyone posted anything on Facebook about you? And the juror answered, I was not aware of it until Miss Becky told me today. Do you recall that?
I do remember her saying that.
And do you recall the judge saying, what did she tell me? And the juror said, she asked me if I had an ex-husband, and I said, yeah. Did you ask her that?
I remember her saying this, Your Honor, but I did not ask her any of these questions.
And she further says, she asked me if I had talked to him about the case or being on jury duty, and I said no. I had questioned her about why she was asking me that. I haven't seen my husband since 2014. Do you recall her testifying to that?
I do remember that, yes.
And with that, having jarred your memory, do you recall asking her about her husband and his post?
Your Honor, I don't remember saying anything about that.
Well, what was the post that you read in the Walterboro Word of mouth? What was the nature? You read that, did you not?
I did.
What did it say?
My memory is a little fuzzy with that, but it was about a ex-husband who found out that his ex-wife was on a jury, and he didn't think that she would be a good juror. And it just sounded very similar to what I had heard the judge and the attorneys speaking
So
about.
you then went to that juror and questioned her about that, did you not?
I did not, Your Honor.
Well, she says in this testimony that she didn't know about the Facebook until Miss Becky told me. Was that incorrect?
I'm not saying.
Some kind of conversation went between the two of her for her to know about that post, correct?
That's true. And I'm thinking that it could have been someone, it wasn't me. I just know that it's not me that she talked to about that.
Well, when the judge, the judge was questioning the juror about this, she also said that she had 3 restraining orders against him. And she also said, I was very upset after she told me that. Like I said, I have 3 restraining orders against him, and I wouldn't have anything to do with him if I didn't have a child with him. But I haven't seen him since 2014. Y'all didn't discuss that, the restraining orders?
On the way from the jury room to the back chambers where the judge was, she was very scared. She was talking about the 3 restraining orders that she had out on her husband at the time that they were divorcing. And she was scared that he would be trying to get back in contact with her again.
Well, how do you know that? Did she tell you that?
She was talking about that on the way to the jury room, to the chambers with the judge.
And in the court, in this hearing now that I'm looking at, that the court is conducting, she said, they're asking about this Facebook post, and she said, Miss Becky said she went to look for the post again and that it had been deleted. I don't know who she talked to or anything else, but she said apparently, do you recall her saying that?
I do remember her saying that.
And the court then said, what did she tell you about that? And the juror said, it was after you let us go on the last break. I was very upset. This is what you're talking about. And she came down and talked to me and said that apparently, I don't know who talked to him, but he said he was drunk and he removed the post. Do you recall that?
Well, she didn't tell me that, and I didn't talk with her about that.
Well, You saw that post, the so-called apology post, did you not?
Right, I did.
And you assumed that was a post from her husband, did you not?
Right.
And then you talked to the juror about that, did you not?
I did not talk with the juror about that.
Well, who did you talk to about it? Did you bring it to the judge's attention?
No, we didn't get a chance to talk to the judge about that.
The court asked this juror, has the clerk discussed anything about the case with anyone on the jury? The juror said, not that I'm aware of. The judge said, okay, she was just discussing with juror. She pulled me aside when we went downstairs after the last break. I want to say it was after lunch, and we came back, and that's when she first told me about it, about this, what we now know was not a post from her husband.
Right.
But you assumed it was a post at the time, and y'all had a conversation about it, correct? Don't that just nod, answer the question.
Yes, sir. Yes, ma'am. I believe that it was one of my staff that she talked to, but it was not me that she talked to.
But the juror says, and I want to say it was after lunch we came back, and that's when she first told me about it. She's talking about you.
Correct.
Then we went back into the court, and I never even got to sit on the jury. The judge says, the judge then stops the questioning and she exits the room. Mr. Griffin, Your Honor, I think that satisfies it. She hadn't talked to anybody, hadn't expressed an opinion, hadn't made up an opinion. She's got an ex-husband and she has 3 restraining orders against him. The court said, Mr. Waters, just obviously we're all invested in this. My main concern, I certainly would love to, but not love to, but would want to hear, what one of these individuals said. But, she answered the questions as she did, talking about the juror. They then have a colloquy about this juror and whether this was really her husband that put this post in that you talked to her about and apparently talked to the court about at some point. Am I right?
That's right.
And then at the end, the judge said that he was not too happy with your having talked to the juror before you talked to him. Do you recall the judge saying that?
Yes, ma'am, I do.
And did you pop right up there and say what you're saying now, that you never talked to her?
We never talked about it after that. I wasn't in the room when he said that.
The judge brought up another thing right after sentencing that I want to explore with you briefly.
Okay.
All right. One of the big responsibilities of the clerk of court is to take control of the exhibits that are presented in court. Isn't that correct?
Yes, ma'am.
And there were sealed exhibits presented in this case that were photographs of the 2 decedents at Moselle when the law enforcement authorities first investigated the murders. You recall that?
Yes, ma'am.
And those photographs were sealed by the judge, were they not?
Correct.
And when the testimony about them was completed, they were under your control as the clerk of court, were they not?
That's correct.
How was it that those photographs came into public view?
Are you talking about after the.
I'm talking about the fact he alluded to it on sentencing, and said that he was frustrated about it and was going to try to look into it. Those photographs that were sealed court exhibits under your control found their way into the public media, did they not?
I believe they did. And I think what happened, it was someone from the gallery took a picture from a screen that had some of the pictures on it, if I'm remembering correctly.
Did you ever allow anyone from the press to view these sealed exhibits?
No, ma'am.
Did you allow Netflix to ever examine the exhibits for trial?
No, ma'am.
How did you handle exhibits? Because you did have the press have great access to the exhibits, and you say several times in your book that you had to stay after to be sure that you interacted with the press about these exhibits. That's true, is it not?
That is true. We had Mr. Jay Bender, and then we had the pool photographers and someone from maybe the state, I believe, or the Posting Courier, along with the court reporters, someone from court administration, and then someone from the clerk's office every night that would go over the exhibits to make sure everything was correct and within our domain.
Were any press people ever allowed to view the exhibits, even the sealed exhibits that you had on file?
No, ma'am. No, ma'am.
What was the methodology for allowing them to examine the exhibits? How'd you handle that?
I wasn't there a whole lot when we did this every night, but it's my understanding that the people that were involved with the exhibits, and especially the court reporters, and there was a certain time frame that they were allowed to take their pictures, and everything was all of the pictures were looked at by the court reporters that were there, and the lady from court administration, along with someone from my office and Mr. Jay Bender, to make sure that everything was done correctly.
What I'm asking is how you handled having them, the press, view these exhibits.
If I remember correctly, the press, we had certain designated photographers, and then someone, I think, from the state or the Posting Courier, and they were responsible for putting it out on a stream for the rest of the media to
And would
access.
they do that by photographing the exhibits as they were in your possession after court was over that day?
That is correct.
All right. And how did you handle the sealed exhibits in terms of their availability when these press people are there photographing exhibits?
They stayed sealed.
And so you think that you're aware of the fact that some of these on the scene photographs of the two decedents found their way into the public press. You're aware of that, are you not?
Yes, ma'am, I am. Yes.
And you contend that they photographed them in the courtroom?
That is what I heard.
All right. Finally, you have indicated about your book that some things that you put in there were, you called it literary license, not literally true, correct?
Correct.
Did you ever, by any kind of email communication or in any way, shape, or form, indicate or state that you wanted a guilty verdict because it would increase the sales of the book? Did you ever say that in an email or verbally or in any other way?
No, ma'am, I did not. It didn't matter to me if it was guilty, not guilty, or a mistrial.
Well, in your book, you suggest that the guilty verdict was what you wanted, and you were fearful that that a guilty verdict would not be rendered. You say that a lot about your feeling about wanting a guilty verdict, do you not?
I do agree that that is said in the book. And part of that is because I think it was a guilty verdict.
Well, this is way that you were describing a time way before the verdict was rendered when you wrote about those things in the book. Isn't that correct?
It is, yes.
And you even have something where you say that your eyes met with jurors and others at Moselle, and y'all had an understanding, unspoken, that he was guilty. You said that in the book, did you not?
I did say that in the book, and I would consider that part of the literary, the word that we just said. But there was nothing spoken with a juror at all at Moselle or anywhere else, at the courthouse or anywhere. I think that's part of that poetic license that we write to make something more apparent. But at no time did I read or try to read someone else's eyes. And that was just one of those gut feelings that I wrote in the book.
You wrote in the book, speaking of a time before the jury verdict was rendered, I was conflicted about knowing the Murdaugh family and about having so many people watching and listening to me as I read the verdict. I was mostly concerned about Alex being found innocent when I knew in my heart he was guilty. I had this fear that the goodwill the Murdaughs had built up in the community would influence the jury. You wrote that, did you not?
Yes, ma'am.
So you had those feelings well before the verdict was announced in this case. You had some definite opinions and feelings about what the verdict should be, did you not?
I did have a certain way that I felt.
And
But I would
wasn't
never.
that's not any poetic license, what was said there. That's how you felt, correct?
Correct.
All right. Those are my questions. Anything further from the state, Mr. Waters?
Very briefly, Your Honor.
Yes, sir.
You were asked a number of questions about the interactions during the in-camera proceedings with the juror who was excluded. Were you in the room during the entirety of those interactions, or just were brought in here or there as those occurred?
No, I was only brought in for my asking of my questions from Judge Newman.
And you were asked a little bit about sealed exhibits and about Judge Newman's comments at sentencing at the end of trial. And just to clarify, those were not pictures of any sealed exhibits. It was a picture that someone had taken in the gallery that had actually been disclosed. And that's what Judge Newman was talking about, to your understanding?
That was my understanding, yes.
And then after the trial, there was even a post-trial hearing or some discussion about the fact that some body cam videos had not been sealed, and Judge Newman fixed that problem after the trial. Is that correct?
Correct.
Nothing further, Your Honor.
Just a couple questions.
Mr. Hartpootlian?
Let me understand this correctly. You would agree that you did release all of the exhibits in this case, sealed and unsealed, to the Texas film crew. Is that correct?
No, sir.
Hmm?
No, sir, I did not release the sealed exhibits.
What about to Netflix? Didn't you indicate to the judge they'd been mistakenly released and you're getting them back?
As an error before, when we realized everything, yes, those two did go, and Netflix had not even, they said they had not even looked at them.
Did you get them back?
We did get them back, yes.
And what about a Japanese film crew? Did they get exhibits, the sealed exhibits?
They did not get any sealed exhibits.
What about NBC Universal?
No sealed exhibits.
But you do concede that Netflix did get sealed exhibits.
They did it as an error. It wasn't
Whose
listed.
error?
Well, I would say the court reporter didn't mark it on the listing.
Well, why were you so accommodating to these national documentary folks? I mean, is this good for the book? I mean, the more documentaries out there about the Murdaugh thing, the better your book sales are. I mean, there was money in this for you, right? Again, it's about the money, right?
What's your question now?
Isn't it financially beneficial to you at the time to get more of these photographs out, more publicity, more Netflix, more HBOs, more Japanese? Doesn't that sell books for you? Didn't you see a financial advantage?
Not at all.
Okay. Thank you. No further questions.
Ms. Hill, you may step down. Let's hang on for a moment. Mr. Lewis.
She excused her subpoena. I just wanted to make sure she's now excused.
Oh, well, I wanted to step down. Yes, she's still under subpoena. I haven't heard what's going to be said. Mr. Harpootlian still has some things he wants to raise about other witnesses and so forth. So what I would prefer is that she remain with you, Mr. Lewis, until we see what else is going to happen. You may step down. All right, Mr. Harpootlian.
Your Honor, we've got literally millions of pages of documents in this case. Ms. Miller just uncovered an email relevant to what you asked. We don't have it printed out. But what it is an email from Rebecca Hill to Miho Takachuchi, something. Miho, first name, the Buford McDowell body cam should not have gone to you. Please get rid of it. Do not use it. The judge, Judge Newman, specifically ordered that body cam not be used if it got out. Apparently, it's still on the videos we were saved. I appreciate your attention. What about what about the other body cam video we could see on many news documentaries? Can you provide it? It seems the camera was on the other police personnel. I mean, here she's having emails between this Japanese production company about body cams telling them to get rid of it. I think that's important, and I can have a copy of this printed out for you when we can get it to a printer for you for the record.
That would be fine, but do you want to offer it as an exhibit?
I do.
All right, Mr. Waters.
I have no objection. If I could just ask the date of that.
The date is July 17th, 2023. July.
All right, that's one thing. What else? I will admit it. I will allow it. That is a impeachment of her testimony to me that she did not send any emails or release anything.
Yes, Your Honor.
In fact, she changed that testimony on redirect when she said she did, so-called by accident, release some things.
That doesn't appear to be by accident. So we'd like that made part of the record. Secondly, I have sitting outside the courtroom the clerk of court for Barnwell County, Rhonda McElvey. She specifically denied saying certain things to the clerk of court of Barnwell County and denied doing certain things. I think you're going to find her testimony extraordinarily instructive and educational. And it shouldn't take, I would be shocked if it took 20 minutes. This is,
Well, in light of the answers she gave to my questions and some of yours in that regard, I'm going to allow it. Now, I want to know what else we're looking at here.
Do we have only one copy of this? Your Honor, I want to hand up to you an affidavit from a witness we would propose to provide in addition to court reporting. This is a alternate juror, not the egg lady. This is the alternate juror who was dismissed when she was not needed for deliberations. And she is here also ready to testify. Testimony would take about the same time as one of those jurors this morning.
Sir?
I would expect her testimony would take about as much time as one of those jurors this morning.
This is your offer in refutation of the testimony Ms. Hill has given today.
She denied saying any
She
of this.
denies saying anything. That's correct.
Yes, yes, Your Honor.
Now, is this juror, alternate juror, going to testify?
She's here. Yes, yes, Your Honor. She's sitting.
Well, you just say she's here. She's available.
Yes, ma'am.
All right, Mr. Waters.
Your Honor, a couple things on this particular alternate juror. We've just been handed this particular affidavit. Your Honor, I believe that Your Honor had correctly ruled that the focus again was on those jurors, and the inquiry has been made to those particular jurors. I don't know why we would go into detail with an alternate juror that ultimately did not sit in any deliberations and cannot testify as to any effect on the verdict, which is the ultimate inquiry before Your Honor. And so we would object to this particular testimony as far as it relates to the alternate juror.
Here's the one thing that gives me some heartburn, and you can help me with this, please. I stand by the rulings I have made that only jurors can be questioned about the effect on their verdict. And that is why I did not allow the testimony of the egg juror in that regard. He is now offering this testimony, and it's testimony of certain things that were said to the jurors as a whole, rather than just to this particular juror. I would, as I say, I would ordinarily not allow this, but Ms. Hill testified several times during the course of her just concluded appearance that she never told any jurors anything along the lines of what has been asked here, particularly the comments about they're going to say things that will try to confuse you or throw you off, things of that nature. She was asked about that, and she denied she ever said anything like that. So this is an attempt to impeach as I see it, and that's what's giving me a little heartburn about just turning him down flat.
Well, a couple things as to that, Your Honor. First of all, I think that we have some very specific statements and a specific individual that's mentioned here. And so if we're looking at Rule 613 B, which is essentially where they're operating, I don't know that there was an appropriate foundation laid as to the specific time and to whom these specific statements were made. I think that it needed to be cleaner with regards to that, as to, you know, mentioning this particular person and as much as you can, the time and place and the very specific statements that were made. I think Mr. Harpootlian, again, we had these general allegations and kind of went through those, but I don't know that now that we've just been handed this affidavit, that they were set forth as an appropriate clarity that's required by 613B. So I think there's a failure there.
Mr. Waters, look for a minute at paragraph 3, 4, 5, 6. 7. Those paragraphs all address things that have been asked her, and they are pretty specific as to time and place. And the content of this testimony is an attempt to impeach her, Ms. Hill's testimony. That's why as I guess colloquially I said, I'm having a little heartburn about excluding this, is because she was asked directly about these matters. And this testimony would be in conflict with that, which would be permitted to impeach someone.
Right. And Your Honor, I certainly understand the point. I guess I would have just 2 points to that. Number one is that, as we've already talked about, this evidentiary hearing is within your discretion in the manner, particularly when you're talking about jurors and the manner to be conducting that. Now we're talking about putting the juror on the stand and having attorney examination. And I think under the case law, that's within your discretion as to how that inquiry should go, as opposed to were we purely in a trial setting and applying the evidentiary rules. But if we were applying the evidentiary rules, again, strictly applied, I think that I don't know that they have laid the foundation with enough clarity to offer extrinsic evidence under 613B. And that would be our argument there, that we just had generally discussion of some of these concepts, but not the place, time, and person to whom it was made with the specificity that 613B requires. So that would be our evidentiary objection in the event that Your Honor is addressing those. So that would be our position. I do also, before we get started, I do want to go back and address the sealed exhibits issue whenever it's appropriate.
Sure.
If it's now, I'm happy to go.
All right. Mr. Harpootlian, slow for a minute. I'm turning to Mr. Waters to try to get some clarity about why he objects to this testimony. One is the 613 issue that he's explored, and I understand that. He now wants to say something about the sealed exhibits. So I want to hear from him on that, and then you can reply to both of them.
I'm sorry, Your Honor.
That's all right.
Distracted by Mr. Barr.
Sure, I understand.
And, finally, going back to the juror issue, we would also raise 403 as well, just because of the nature of the inquiry that we're here to assess. Going back to the sealed exhibits, I just want to clarify for Your Honor, Mr. Griffin and Mr. Harpootlian were at this hearing. After the trial, there was a release of, and these were publicly filed exhibits, of a number of exhibits. What also got released at the time were 2 body cam exhibits, which had images of the victims at the scene. Those had inadvertently not been marked as sealed exhibits. And ultimately, then we had a hearing in front of Judge Newman, and essentially those were clawed back. And so I just want to be clear that when we're having testimony about that particular thing, as it relates to what Ms. Hill was saying, those were the sealed exhibits that were released. And again, at the time, they had not been marked sealed, and that was sort of retroactively fixed. And then the other issue, of course, is, Your Honor, is again that the issue that Judge Newman was talking about after sentencing was a gallery photo. It was not what apparently would be maybe a press photo of the exact exhibits. And what we did at trial, and Mr. Harpootlian can speak to this, and Mr. Bender could as well, is at the end of each day, first of all, the sealed exhibits would have a cover sheet or a folder that they would be in. And then they would verify with the parties that these are the okay exhibits, these are the sealed exhibits. And then at that point, after court was concluded, the media would then be allowed to review and or photograph or get copies of the unsealed exhibits. So that's just how the procedure was working at the trial.
That's very helpful to clarify this, because I now see this in perspective that there were that the materials that were photographs at the scene or depictions at the scene of the 2 victims. What you're telling me is that those were inadvertently released after the trial by, I guess, it would have to be by the clerk of court. She's the one that had them. And then they were, and they weren't properly marked. And they were then clawed back.
Yeah, they were the two body cam videos. And so in those videos, it weren't physical images, but they were the body cam videos. And then in those videos, you could see the victims at the scene. And those two exhibits, to my recollection, were the only two that should have been sealed, but they, in fairness, were not marked sealed. And that's how they got released. The second we realized it was a problem, we took care of it and clawed those back.
That clarifies that issue for me. So I frankly, that puts my mind at ease about what happened there. Now, Mr. Harputney, and I'll come to you momentarily. Anything else?
No, ma'am, Your
Okay, now, Mr. Harputney.
A couple of things I point out. The first is this, in terms of the statement by this alternate juror. She was interviewed by SLED on video, said exactly the same thing as she's saying in this affidavit weeks, if not months ago. So they know exactly what she said. I can assume they reviewed it. By the way, I asked, basically read from this affidavit as I cross-examined the court, and she denied each one of these statements. The second piece of that is this.
I know it's on that basis that I'm even pursuing the idea of you're offering something by way of impeachment. So I understand that.
And secondly, as to the sealed exhibits, I think we're going to hear testimony from Ms. McElveen that may elaborate on your concerns based on our interview with her this morning.
All right. Well, here's what we're going to do. It's about 3 minutes of 3, which is when I generally take my afternoon break. I'm going to adjourn the court or recess the court, and we come back at 3:15, and I will allow you to offer Ms. McElveen and the alternate. I want to make it clear that they will be offered on what we've talked about, matters about which Ms. Hill testified that you think are impeached by Ms. McElveen's testimony and that you think are impeached by the alternate juror's testimony. So and the alternate juror's testimony, as I look at it, is the part about which impeachment would lie would begin at paragraph 3. So do you understand what I'm saying?
Yes, ma'am. Can I make you one other offer?
Yes, sir.
Today and today only. Egg Lady is across the street.
Well,
no. If you want to put her on the stand.
No. I've made my position quite clear about that. I think we've got in the record what is needed in terms of what she says, Ms. Hill says, and what Ms. Hill says she says.
I agree. We did not intend on calling her. I just didn't want you to miss the opportunity if you wanted the opportunity to examine.
Thank you, Mr. Harputney. All right, court will be in recess until 3:15.
Oh, okay. 15 minutes for snacks, loo break. Yeah, I'm not flushing yet, Pete. I might have to. We'll see. We'll see if I can make it the whole 15 minutes and then go during, when she's up. Yeah. Yeah, how about that? Harpoolian making deals with the judge. One time offer, here you go, egg ladies across the street. You want her? You want her? Like, how many times did that judge say she's already addressed the issue with egg lady? She was not part of the jury that rendered the verdict. Her affidavit is not important to whether the jury was influenced. This is a hearing about the retrial of whether the jury gave an uninfluenced verdict unanimously that he was guilty. It's about fair trial. It's not about Becky Hill being sneaky, slimy, whatever, trying to make deals, making book money, or whatever nasty stuff she said about Harpo or anybody else. I mean, that's what this seems to be turning into. I mean, Becky Hill is not giving herself much credit here. She does seem a little guarded and careful in the beginning of her testimony, and then outright hedging, outright circling around questions. And I think the judge caught on to that. I do think that she will get impeached as a witness in then we just take her out of the picture as the declining that she said what she said, which goes right back to juror number 1, who said they were influenced by statements made by Becky Hill. And let's not forget, Becky Hill says she didn't say it, but it was more than that one juror who said she did. Several jurors said they did hear her make comments, but it didn't influence them. Several jurors said that. I am, it's like a Beatles song. I am the egg lady, and that is one Miss Hill. Yeah, I don't want to fight on. No, I don't want, I could not stand behind anything that Becky Hill says at this point. I don't know whether to believe her or not. I just find her testimony to be not credible. If I was a juror, which I'm not, there's no jury right now. It's just the judge. But by the judge's tone, I do think she also is thinking that there might be an issue there about credibility. Yep. Time for chippies. Yes. That sounds good. I'm hungry. Yeah. Looks like we're going all the way to 5 o'clock with this one. I hear you. I hear you there, Pete. Cuckoo, cuckoo. Anyway, I dropped the link if anybody wants to come up. Not that I'm pressuring anybody, but if you got something to say, please come. Say it. Because this is entertaining. I am glad that I got up for this, actually. I am very happy because this is the kind of legal back and forth that I truly enjoy. There's a lot to discuss here, Oh, it's okay, crazy. Maybe next time. I mean, it sounds like this is not going to be done today. It sounds like we will be there tomorrow. But the way it's progressing, I can't even imagine we'll still be at it on Wednesday. What do you guys think? I guess I should put up a poll about impeaching Miss Hill. Let's start that one. Us a simple yes or no poll. Do you think Judge Toal will impeach Miss Hill? I don't get to vote, but my vote would be, well, maybe I shouldn't say. I don't want to prejudice you guys, Yeah, Karen, I agree. Alex is not my favorite defendant, but I did enjoy the first trial. I enjoyed all of the people I met during the first trial and the relationships that we built. In some of you that are still here following some of my other true crime cases that I get into, and it kind of feels like whenever we talk Murdaugh, it's like a home again crew comes, especially Pete. Like whenever we do Murdaugh, anything to do with it, like I love to see you there. Mandy too. We, you guys, like we went back and forth often about this one for sure. And many of you that have been here for all of them. Yeah. Yeah, Harpo, you know what? That's what I'm afraid of, Liam. Harpo could make a 30-minute speech last 3 days if he wanted to. Yeah. No problem, Shill. It's a short break. I mean, I was thankful Kelly came up for part of lunch because like my voice has not been the best, and I did plan, or if it got bad, to put on music and take a break, which I hate to do, but I do want to keep the stream running for the whole time. But I may not be able to stay up here for hours at a time and talk like normal. Well, so I was glad, and I think it gave some good context. Talking about legal is always good in these cases because they all kind of link together for different reasons, as far as the law in the black and white of things and the different way that judges look at things, the defense attorneys present them, and prosecutors actually go against, it's all so fascinating to me. I love having others to talk to about it. Yeah, I do believe we're going to go through tomorrow. So it's nice to know you'll be here, Crazy Kids. At least like somebody will be here keeping me company. Yeah, because I think we'll be getting up early tomorrow. It's just a matter of whether we do the true crime episode in the evening or not. Because, gosh, guys, I've got some stuff on Boone. There's a little bit more on Kohlberger, after the hearing. I agree, Liam. Harpo really likes his winding run-on sentences. And I like when he does those little sideline things like, well, we think that's true. Well, we would, well, honestly, we think it's dishonest or whatever. He makes like a snide remark, little Mr. Snarkster on the side. Yeah, I am very curious as to whether she gets impeached. But this woman, this judge, I don't want to just keep saying this woman, but man, is she strong. Like, she's strong in her legal opinion, in her confidence of knowing the law. That is her reputation. She knows the law front and back. That's why it's so rude of Harpootlian to try to even school her on what a legal brief means or a court decision as a judge. Like, that took a lot of balls. But then again, that's Harpo. Like, he's going to do it. But she pushed back. And she pushed back legally, not just with the well, I don't think that's what it means, Judge. She pushed back onto why it doesn't mean what he thinks it means. And I have to give her credit for that. She knows what she's talking about. She seems to be no business. I don't think she's going to take more than these 15-minute break to decide whether Becky Hill gets impeached. I think this issue is serious to this. Although I do not think whether she is impeached or not is really going to be the deciding factor on whether there's a retrial or not. Because remember, it's not about whether Becky Hill is a POS. Okay? It's about whether the jury was influenced. It's about whether the jury took anything into consideration or just did their job. It's about the keeping the sanctity of the jury process intact, without a doubt, that Alex Murdaugh got a fair trial. It wasn't stacked against him in any way, because that's the foundation of our system, and that's going to be paramount. That is going to be the paramount issue. And we do have a juror who came right out and said, I was influenced. This is why. I'm not sure, Karen, if she will call her back. If the Judge Toal will call, you mean Miss Hill, back on the stand? I'm not sure. She did press her with quite a few questions while she was on the stand. And she did readdress some things that she wanted to clarify. But I think she has the information she needs to make her decision. Yeah. I think the judge asked all the questions she needs. Whether or not they're going to allow some of these other witnesses. You see, Harpootlian wants all these other witnesses, and he has from the start, because that's what his allegations were. That Miss Becky Hill orchestrated this whole thing to try to throw the whole jury. Okay. Now, Judge Toal's goal, she's looking at it differently. She don't care if Becky Hill's a good person or not a good person. Her goal here, and she has said it from the start in all her orders, in all her procedural orders that came forward in the pre-hearings, that her main issue was whether or not a fair trial was given based on the jury's determination of the verdict and if they were influenced, because that's all of the factor that matters right here into what they should be discussing. But Harpo keeps wanting to, and Harpootlian, I don't mean to be disrespectful. I'm sorry. An attorney does deserve me to use his full name. I might type his name shorter in the chat, but I should be saying Harpootlian. It is his full right name. He and the defense themselves want to turn it into more than that, to say that Alex Murdaugh was prejudiced against. Because if they can prove prejudice, okay, then they can also move the new trial, out of the area, and get him a better look of people that don't understand anything that went on. This is such a high-profile case that it's going to be very difficult to find a jury that hasn't heard about it. It's going to be difficult. Juju, yes. When she said that she was influenced by several other jurors, that does happen in a jury room. They are arguing with each other as to why they think it's a certain way, or not arguing, just debating and discussing as to what their opinion means and why they got there. And if that influences someone, it should. And if it influences you, it's because it's making you doubt what you believe because you can't justify what you believe. And rightly so, you should change your mind. So, like, I'm not so sure the other jurors is a problem. The problem is she said she heard what Becky Hill said and it influenced her decision. She said that. She said Becky Hill said something about watch his body language and watch what he says, or listen carefully to what he says. In other words, she used language that made it appear that she thought that Alec Murdaugh was guilty and that his actions were going to prove it on the stand. And that is exactly what the juror says she took away from it. That it made her feel that that Alex was guilty. Those statements. And that's the problem. Those statements there, not afterwards with all this other stuff about, who wrote who home, which didn't happen. One thing we did learn during this speaking to all the jurors, that a lot of the allegations that are in the Harpoolian draft of the original complaint, the defense, Alex Murdaugh's appeal for a retrial based on a complaint of all of these things, a lot of them are just hearsay. A third or fourth person saying something to him that was not clarified or justified and nobody stuck up with. Because when put under oath, the jury said no. Okay. The jury member said, nope, Becky Hill did not give me a ride home. Never did, never happened. I don't know what they're talking about. I don't think the jury members have a reason to lie. I don't think serious jury members would lie. This is serious. Who's going to sit in front of a judge like that and lie? I'm not. There are penalties, and a judge can put you in court, in jail for contempt for doing it. Well, Liam, either way, we don't get to judge whether she's weak-minded or strong-minded or determined or whatever. But if she says that she was influenced, it's a problem. It's a problem for procedure. You have to admit it's a problem for actually making sure that the jury process is not tainted in any way. Okay, whether she's weak and wishy-washy or whatever, I know if you have a nice bridge to sell her, she would probably buy it. You could make a good fortune, but still, it's going to amount to a retrial. Okay. Thank you, Mandy, for the Amber Alert. I get those and repost them on my phone all the time. Anyone near Kentucky? I know we kind of picked up on it, Pete. I would admit that most of us were getting a bad feeling from her, not based on what we've heard or found out, just based on her testimony. I do not like the way she phrased herself. I did not look how she was being guarded and careful. And I guess in some ways it can be quite intimidating to sit in front of a judge. And I guess, I might be nervous too and very careful about what I said, Oh, no, don't apologize, Mandy. I'm happy you did it. There's never any problem with you putting an Amber Alert in my chat. That's a good thing, Mandy. Don't apologize. I didn't mention it to make you feel bad at all. I mentioned it because I wanted people to make note that there was an Amber Alert in the chat. It does make me sad to see. It does, And that's another thing I wanted to bring up. For those of you that bring other cases like into the Discord and all, and you put it in the appropriate rooms, don't ever apologize for that. Bring everything you think is pertinent. Just because I'm not covering it doesn't mean I didn't read it and find it interesting. And like it may line up someday to something legal that I'm looking into. But I really appreciate it. I like that you all feel that you have a place to share this and to talk about it. I really do. I don't know. Maybe Mandy knows better if there's an actual way to get the alerts. I get them on my phone. My service provider has a thing on there that I can actually ask for them or not. You can turn them off or not. But I have all of the emergency ones on, the Amber Alerts, the weather alerts, and the national alerts, just in case zombie apocalypse or something, I'd want to know. Yeah. Yeah, I know, Karen, Yeah, I know, Karen. Not so much weak or it's like, but just that, who is Becky Hill that she could influence all these people? Like she's a magician of sometimes, right? Yeah.
Order, all rise.
Okay, we're back.
Please be seated. All right, Mr. Harpootlian, I believe it's you to present your witness.
Yes, ma'am.
Please be,
Rhonda McElveen. You know this book?
Sure.
You know this book?
Yes, I do.
Do you swear or affirm that the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am, that's what I'm here for.
Thank you. Please have a seat on the witness stand. State your full name for the record, and please spell your first and last name.
Rhonda McElveen, RHONDA MCELVEEN. You want to make sure I'm going to stay here. Yes, sir.
Say your name for the record, please, so I can make sure I can hear you.
Rhonda McElveen.
Your Honor, can you hear? Okay.
I can't hear you great, Dick. I can hear you, but I would doubt that anybody posted lawyers would hear you.
Is that better? No?
Is that thing on, Mr. Bailiff?
I think this is Mike for the other courtroom. This is Mike for the next door.
I don't want to get into the thing going.
Well, I can speak up.
haywire, man.
I'll just speak up. How about that? I have a big voice. I'll use it.
It's just not on at all, though.
No, it's all right.
Is it on?
Yes, ma'am.
Okay. All right, Mr. Harpootlian, you may proceed.
I'll speak a little louder if that helps. Say your name again for the record, please.
Rhonda McElveen,
And Ms. McElveen, what do you do for a living?
Clerk of Court and ROD for Barnwell County.
Clerk of court in what?
Register of Deeds. I have 2 titles.
2 titles. And is that an appointed or an elected position?
Elected.
So you're elected by the people of Barnwell County.
Yes, sir.
And how long have you been the clerk of court of Barnwell County?
This is my 16th year.
16 years. And
And I'm running again, sir.
you're up this year, 24 is?
Yes, sir.
All right. Don't think I'm allowed to plug that, but you have been the clerk for 16 years. You're up again this year. Now, do you know the clerk of, well, back up for just a second. Do you hold any position with, is there a state organization of clerks of court?
Yes, sir. I'm actually the president of the South Carolina Clerks of Court and Register of Deeds.
Okay. And that means that of the 46, there are 46 of y'all, is that
Yes,
right?
sir. Yes, sir.
And you were elected to be the chairman of that group,
President of that group.
president of that group.
Yes, sir.
Now, are there certain rules and constraints that clerks should operate under in terms of dealing with juries?
Yes, sir.
And is there training for that, or is there a book for that, or how do you learn that?
You have the Clerk of Court manual for one that's on the judicial website. You also have the law books that have it in there. There's actually 2 separate forms, SCCA 237 and 238 maybe, that has regulations on it. And then we also have in the handbook or not handbook, but in the program within the CMS system, they actually have rules and stuff that you can go by as well.
Now, as a clerk of court, are part of your duties to deal with juries?
Yes, sir.
I mean, we understand there's a jury venire that's brought in at the beginning of a term, and then individual juries are picked for both civil and criminal cases. Is that correct?
That is correct, unless it's a non-jury trial.
And then there's just a judge, like we're doing here, right?
Yes, sir.
And in the process of picking juries, do you assist as clerk of court? When I say assist, who actually picks the jurors out of a hat, or whatever the process is?
Well, actually, the first process is you draw a jury by computers through the CMS system, and then summons are sent out. And then once we come to court, we usually do a roll call. We see what everybody's doing, their jobs and everything, to help the attorneys to decide which jurors they would like to get. They have so many strikes, etc. And then you call the names and they have the strikes, and then that's your jury pool.
And then the judge will seat a jury in a jury box, although I've never quite seen a jury box that looks like that, but a jury box in a courtroom, right?
That is correct.
Your jury box in Barnwell County is like 2 rows of 7 or 8 people.
Well, I actually have a jury box on both sides of the courtroom, because I have the grand jury on one side when they convene, and then I have the petit juries on the other side when they convene.
Okay. And the jury, they're sworn by the judge, and then they're put in the jury box, and they begin to hear arguments and testimony and jury charges by the judge. Is that correct?
Well, actually, sir, where we do it, the clerk of court usually swears them in with the judge presiding over the whole deal.
Okay. Once that jury is sworn in, what is your role in terms of dealing with those jurors individually or as a group? Are you allowed to talk to them individually, to pull them out, to converse with them about your opinion about the case?
To pull them out of the trial while we're going on?
Yes, ma'am.
No, sir, we're not. If they're on a break, et cetera, or if they request to see someone, then we manage to, I'll go in the door open. I'll say, which one of you needs to see someone? It might be the judge. And I said, hold on. And then I go get my judge. And so we've got a juror that needs to speak with you.
Do you converse with jurors about the merits of the case, by the merits, whether someone's guilty or innocent, or whether a plaintiff or a defendant should win in a civil case? Do you ever do that?
No, sir. About the most only thing I ever do is go in and count them and tell them I can count up to 14 without even using my toes. And then I might get their lunch order. That's it. And the doors are usually open when I'm doing that.
And you have bailiffs that sit with the jury or sit outside the jury room?
They sit outside the jury room, and usually there's one beside them in the courtroom in case somebody needs something. But usually they'll catch my eye, or they'll catch the judge's eye, and we'll get something handled.
Okay. So did you have any contact with the clerk of court of Colleton County prior to her being elected the clerk of court of Colleton County? Did you know her before she was clerk of court?
No, I did not.
Did you come to know her once she was elected clerk of court?
Yes, I did.
And was it a pleasant relationship?
It was.
And how did you come to be, and to cut to the chase, you ended up being in the courtroom during the Murdaugh trial for part of those 6 weeks. Is that correct?
Yes, sir.
How did you come to be there?
When Becky and I met each other at a conference, clerk of court's conference, where she was discussing that she had that trial coming up, and I knew that she was relatively new, and I said, I'll offer to come help you if you would like. And I think she ended up talking to Judge Newman about it, and they both said, yes, it would be good that I was there.
Okay, because you tried a murder case or two in the past, correct?
Yes, sir.
Okay. And did you go and help Becky Hill try that murder case?
I did. I couldn't go for the first 3 days because I had court in Barnwell, and I told both of them if I had court going on in Barnwell, I could not be in Colleton County.
Okay. To your knowledge, had Ms. Hill ever been the clerk of court that managed a murder trial prior to this?
Not that I'm aware of, sir.
So this was their first murder trial, as far as you know?
As far as I know of this magnitude, I don't know if they had one before then or not.
Okay. Now, when did y'all, I mean, initially, what were you talking about in terms of logistics and how you did it and all those sorts of things?
Yes, sir.
During that, before the trial, before we ever picked a jury, did she ever discuss with you that she was going to write a book?
Yes, sir.
And
She
did
wanted to write a book. Yes, sir.
Wanted to write a book. Did she indicate what the book was going to be about?
About the trial?
About the Murdaugh trial?
Yes, sir.
And did she discuss with you, what, if anything, did she discuss with you about how she felt the verdict should turn out to be in the Murdaugh trial, vis-a-vis in reference to the book? What would help the book?
A guilty verdict.
And tell the judge and me what exactly she said to you that you remember. This is prior to the trial.
Okay. Well, first of all, she said we might want to write a book because she needed a lake house and I needed to retire. And then further conversations, a guilty verdict would sell more books. And we left it at that. This was before, even in December.
And when did she ever say that again to you during the weeks you spent there?
Several times. It could be said it was, amongst friends in her office, or we might be having dinner, that kind of stuff, but that's about it.
That she needed a guilty verdict to sell more books.
That would be the best way to sell books, yes, sir.
The best way to sell books. Now, during this process, did she ever express to you an opinion on whether or not, in fact, was Mr. Murdaugh guilty of the murders of his son and his wife?
Yes, sir.
Tell me what she said, and if you remember when.
I don't exactly remember when. I know it's over half of the trial had already happened, but the evidence was coming forth that it looked like he might be guilty, and she made a comment that guilty verdict would be better for the sale of books.
Okay. Now, as a result of a conversation you had sometime during the trial, I don't want you to relay to me what was told you. Did you have a discussion with the clerk, Becky Hill, about her being with jurors on her own?
Yes, sir, I did. One morning I showed up to Colony County, and I was told that she had taken a juror home the night before. And I was in the courtroom and I saw her, and it was between the pews and where the back row pews are. And I mentioned to Miss Becky, I said, please tell me you didn't take a juror home last night. And she told me, she says, I did, but I didn't talk about the case. I had a bailiff with me. Mr. Bill was with me. I said, Becky, you don't do things like that. I thought we had stopped everything. It wasn't far enough along to really cause a major problem, or I would have told Judge Newman. But I thought we had to understand that you did not spend time alone with the jurors.
Okay. Now, I'm going to read you some statements. Well, first of all, did you ever hear her say anything in front of you to a juror about whether or not, on the merits of the case, that is, whether or not he was guilty or innocent, or what you should pay attention to? Did you ever hear her, what, if anything, did you ever hear her say to a juror or in the presence of a juror? Anything?
No, sir.
Okay. But let me ask you if you've ever heard her say these statements, and if so, to who? Don't be fooled by the evidence presented by Mr. Murdaugh's attorneys, which I understand. Do not be fooled by the evidence presented by Mr. Murdaugh's attorneys. You ever hear her say that?
Your Honor, this time I would object. This witness was specifically called as a Rule 16.3B extrinsic evidence. I think we've covered the two grounds that would be permissible for her to testify to, and I believe that should be the extent of her testimony. So we would object any further extrinsic evidence as improper impeachment and also irrelevant. I think that the issues that were raised with the prior witness have been covered, and that was the express reason that this witness was called, and Your Honor allowed the testimony.
Overruled. You may continue.
Thank you. Did you ever hear her say that?
Can you repeat the verbiage?
Don't be fooled by the evidence presented by Mr. Murdaugh's attorneys.
Yes, I did.
And who was it said to?
was said to me.
Okay.
And sometimes it might be a staff member in our office or someone from the media there. But other than that, I didn't hear her say it out there in front of any jurors.
Did she ever say to you or to other people around you, I'm not talking about jurors, watch him closely, talking about Mr. Murdaugh. This is just before he testified. Look at his actions, look at his movements. Did you ever hear her say that?
Yes, sir.
Okay. Did you ever have any conversations with the bailiff, Mr. Bill?
Yes, sir.
Did he ever discuss with you the clerk's contact with jurors?
No, sir.
Okay. Did you ever hear her say that the defense is going to try to confuse the jurors? Did you ever hear her say that?
No, sir, I don't think so.
Okay. Now, let me deal with one last area. Let me see if I can simplify this. There was a setup in the courtroom. Pardon me, I've got a little frog in my throat. And I'm fine, thank you.
I think so. I'll share my bottle over here if you want part of it.
Once a cork, always a cork. So, and I was there, you were there, this judge was not there. And prosecution tables over here, defense tables over here, judges up here. And then there's a rail behind which the clerk was. And because of all the massive electronic equipment we had there with big screens, there was an area over on my right facing the judge. And then I think you were located in that area right between the judge and that area. Is that correct?
Talking about in the well area?
Yes, ma'am.
Okay, yes, sir. For
Now,
the most part, now sometimes I was out there with the screen
right,
in the gallery.
right. But there was a screen on which you could see not only what the gallery back there could see, but the images that only the jury was supposed to see that were under seal. Is that correct?
That is correct.
Now, there's a woman named Rhonda Ryder, correct?
Rich.
Rich. And tell me who she is.
At the time, we did not know who she was. The first time they were there, we didn't know. Then she came in Miss Becky's office the night before, and she asked if she could have another seat in the courtroom for the next day. And Miss Becky said yes. And she says, and what's your name again? And the only reason why I remember Rhonda, because of course my name being Rhonda. And the next day, Miss Rich was sitting, I don't know how to tell you, but she was sitting. Do you know where Doug was sitting?
Yes, ma'am.
All right. I know, Judge, you don't know where Doug was sitting, but anyhow.
But Doug was the audiovisual guy, and he had access to the unscreened, the unsealed images, correct?
Yes, sir.
And she was sitting right next to him, right?
Yes, sir.
Okay.
In that little part. And
So she could see the body cam, she could see the unredacted corpse pictures, the autopsy pictures, all the photos that the judge had sealed, correct?
well, no, the only thing she could see was what was being put up at the time.
Right. But
Okay.
as they were put up, she could see them.
Right. But they tried their best to seal it where you couldn't, but you could still see it there. I didn't see any of those.
Right.
Okay.
But she could see them.
Right. And Doug was really having a problem with that. And I can also tell you that our court reporters didn't know who she was either. Okay.
And she turns out to be a writer, correct?
Yes, sir. After I found out. Yes, sir.
And her name is Rhonda Rich.
Correct.
She was given access to areas that only court personnel should have had access
Right.
to.
But then we broke, and then she moved her in the well with me. She was about on my left, and either Elizabeth or Mike was on my right. And I noticed she was taking notes. And I asked her what was she doing, taking notes. She says, I'm a Sunday school teacher. Well, I immediately covered up everything I had.
You don't trust Sunday school teachers?
So,
You don't trust Sunday school teachers?
let me just, there's too many preachers in my family on both sides, okay?
So you determined she was not a Sunday school teacher and later learned that she was a writer writing about the Murdaugh case, correct?
Now, I don't know if she's ever a Sunday school teacher or not. There's just, I don't even know where she goes to church or anything, so I can't tell you that answer. But I did find out that she was a writer because shortly after she was put there, and evidently after I covered everything up, shortly after that, Judge Newman asked for a recess so we could find where people were going to be working. And that's when she put Miss Rich up in the gallery in control of that screen.
And she ended up writing the foreword to Becky's book. Is that correct?
Yes, sir.
Okay. And Becky gave her access to area only court personnel should have had. Is that correct?
That is true. But now I'll be honest with you, sir. There's been a couple times when we had other people that were sitting on that side where we weren't planning on seeing sealed documents that day.
Right.
But there were some other people that sat there, but nobody that actually sat in the well that wasn't court people.
Okay. Thank you, court's indulgence.
Mr. Waters, on cross-examination.
Thank you, Your Honor. Just about that. 1 second.
Oh, okay.
Judge, do you have an extra bottle of water up there by any chance you're willing to share? Oh, Miss Elizabeth's got one. Thank you.
Ms. McLean, how you doing today?
I'm good, sir. Please call me Rhonda.
I always called you Miss Rhonda. I've known you for a long time as well. In fact,
Yes, sir.
I tried one of those murder cases in front of you years ago. Right.
Yes, sir.
Wanted to ask a couple things. I won't be that long. One of the things that you said earlier is you said when you initially were talking to Miss Hill, she said something like, we ought to write a book or something.
That is correct.
Okay. And so did y'all have any further discussion about you writing the book or participating with the book?
Oh,
or anything
no,
like
sir.
that?
I'm crazy enough not to write one.
Okay. During the course of after the trial, she did send you like chapters and things like that to take a look at.
I did get to see a couple of drafts of the manual.
Okay, so she did send you those to take a look at and review and that sort of thing. Is
Correct.
that correct? Okay. All right. And you were asked and again, Your Honor, just to be clear, I've made some objections.
You do not waive any objections by cross-examination. They are all preserved. You may proceed.
Thank you. You mentioned, some statements that you attributed to Miss Hill, during the course of conversations during the course of the trial. Is that correct? Just things like watching closely, watches mannerisms, things like that. And where were those conversations? Were those conversations taking place back in the clerk's offices with clerk staff and people like that?
Yes, sir. In the clerk's office. It might have been downstairs in the bathroom.
Okay.
That some of us had privilege to go to.
All right. So you and Miss Becky and other court staff maybe just discussing the case and that sort of thing. Is that correct?
That is correct.
And people were expressing their opinions about what was going on and that sort of thing. Is that correct?
Now, when we were having those discussions, there weren't more than 1 or 2, maybe 3 people there.
Okay. But just a few people there just talking back behind the scenes. That's what I'm trying to ask.
Yes, sir.
It was behind the scenes, and it's not uncommon for, clerk staff behind the scenes, not to the parties, not to the litigants, not to the jurors, but among themselves back in the hallways back there to talk about the day's activities and things like that. Is that fair?
That's correct.
Okay. And that's a big difference between the natural conversations that people that work together, court staff and the like, have with each other and actually having those conversations in front of the jurors, right? There's a big difference between those two, correct?
Yes, sir.
Okay. And it's not uncommon for you. You're a clerk of court. You got people that work for you. Y'all are going to have private conversations about what's going on that are not to be shared, particularly with jurors, but with the public as well. Is that fair?
That
to
is
say?
true.
Okay. All right. And so there were conversations like that going on that you were privy to and part of. Is that correct?
That is correct.
Okay. All right. And you mentioned a little bit about, well, let me ask you this. So there are all these conversations going on, and that's natural. That happens, private conversations with court staff behind closed doors. But you never once saw or observed or had anyone tell you that any of those conversations were being shared by Miss Becky with any juror. Is that right?
That is correct.
All right. And if that had happened, if you had observed anything untoward or improper going on at this particular trial, you would have immediately gone to Judge Newman as part of your obligation. Is that correct?
That is correct.
And you never did that because you never observed anything like that. Is that correct?
That is correct.
Okay. All right. Now, you were asked a little bit about Rhonda Rich, who was a member of the media, and how she was placed kind of back where the defense IT guy was. Is that
No.
correct?
I didn't say she was part of the media, sir.
Okay, well, she was a writer.
Yes, sir.
Okay. All right. And then you said that that eventually, though, Judge Newman stepped in, and then she was moved out into the gallery in charge of the screen out there. Is that
Right, but I don't know. I thought Miss Becky moved. I'm not saying Judge Newman did.
Okay. All right. And over there in that area of the, if we look in the courtroom, there was sort of the grand jury box over here, and that was where court TV was and media was stationed and that sort of thing. Is that correct?
That is correct.
All right. And inevitably, there were media members that could view some of the images that were being shown. They were just not able to report those just because of the nature of where the courtroom was. Is that accurate?
Well, I was told they couldn't see it, so I don't know what they actually saw because I didn't discuss it with the media.
All right. You never had a conversation with court TV or anything like that?
Other than the fact that be careful what they put on my front page of the New York Times on me.
All right. All right. And you're not aware of any image or confidential information or sealed image or anything like that that was ever made privy to Miss Rich that was put in any sort of publication or anything like that. Is that correct?
Not I'm aware of, sir.
Okay. Because if you had found out about that too, you would have immediately gone and reported that to Judge Newman because you would have said that that's improper. That I need to go report to
That
the
is
judge, correct?
Correct.
And you never once saw anything during the entire course of this trial that caused you to say, you know what, I got to go talk to Judge Newman. Something ain't right about what's going on here. Is that correct?
That is correct.
And you would have done that without a doubt if you had seen that, correct?
Yes, sir.
All right. Now, in looking at, back at this trial, you mentioned that there was a few days at the beginning of trial that you weren't there because you had your own court to take care of back in Barnwell County, correct?
Correct.
All right. And then pretty much after that, I guess you were pretty much present the majority of the remainder of the time. Is that fair to say?
I was. I had one medical procedure done. I missed 2 days, but basically other than that, I was there every day.
All right. And there was a period of time, though, during the middle of the trial where Miss Becky had a medical issue and had to be absent from the courtroom for about a week or something like that.
That is correct.
Okay. And during that period of time, you were present and functioning as the lead clerk of court during that period of time.
That is correct.
All right. So the reality is that you were present for probably as much, if not more than anyone in the clerk's function during the course of this trial. Is that fair?
Yes, sir.
Okay. And again, just to reiterate, there was not one time that you observed or came in possession of any information that you were like, I got to go talk to Judge Newman about this.
No, sir.
Court's indulgence, 1 moment.
At this point, I am just getting very excited at hearing Judge Toal's closing arguments about this.
Yes, sir.
Half a question.
All right.
Mr. Waters indicated to you that you were not aware of whether or not, and you agreed that you never witnessed her talking to a juror about the evidence. Is that correct? We
That is
agree on
correct.
that. Do you know, but she did admit to you that she had been with a juror alone in a car for some period of time when you confronted her with that. Is that correct?
Yes, sir.
And did she indicate to you what she talked to that juror about while they're alone in the car?
No, sir. She told me, the only thing she told me was that she did not discuss the case, that she had Mr. Bill, the bailiff, with her, and he could tell her that. Tell that.
And when she said she didn't discuss the case, did you bring that up or did she bring that up?
She brought that up.
You didn't say shouldn't be with him because it's frowned upon?
I did tell her that I would caution her on doing that because the perception of dealing with the jurors one-on-one is not tolerated.
Is not tolerated. Thank you.
Thank you, Ms. McElveen. You may be excused. All right, Mr. Harpootlian, call your next witness.
Your Honor, we would call juror 741.
I know you're not going. Well, that's right. She's an alternate. That's all right.
We're not going to sign her a letter. We'll go with 741.
I got you.
And Your Honor, while she's coming, my understanding is I'm limited to 4 questions.
Yes, sir. I have a copy, and I have given the court reporter a copy of this affidavit with the name obscured and the number, I think, as well. So, but the affidavit that supports this testimony that you're about to offer is Court's Exhibit 5.
Other than a little background about her getting picked for the jury and how long she was on the jury and
That's
then she
fine.
got excused. That's all we intend on asking these 4 questions.
All right, sir.
Unless Mr. Waters asks.
Sure.
more.
I mean, they'll have cross-examination.
And I'll be crossing, so.
He
I'm
will definitely open the door.
That,
So
all right.
He's limited to the 4 questions initially, is that?
Yeah.
No, sir. He's just telling me that's what he intends to do. Sometimes you can hold lawyers to that, and sometimes you can't, Mr. Miller.
Yes, ma'am.
I intend on only asking her those 4 questions.
That's fine. Yeah.
The numbers.
Yeah. I'll talk with the lawyer.
Do you swear or affirm that the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God? Yes, I do. Thank you. Please have a seat. Please stand.
Your Honor, I assume the same rules apply to her that apply to the other jurors in terms of her image appearing.
That's correct. There'll be no photograph made of this particular witness who was an alternate juror in the matter. Thank you.
I'm going to refer to you as Juror 741. It's what we got to do here, so we don't use your name, so people don't know who you are. Is that okay with you?
That's fine.
And you and I have met before.
Correct.
I came to your home one Sunday afternoon. I believe you're cooking Sunday dinner, and we talked. Is that correct?
Correct.
And then you were interviewed by SWED,
Correct.
and you gave them a recorded statement. And then this morning you came here and you gave me an affidavit that you signed, and you're here with your lawyer. Is that correct?
Correct.
Now, just for purposes of the record, you were a juror. You were selected to be a juror on the State versus Alec Murdaugh murder charge, correct?
Correct.
And you sat in the courtroom for 6 weeks and listened to all the testimony.
Correct.
And you were the alternate.
Correct.
And so when the jury went out to deliberate, you were excused. Is that correct? Now, I'm going to go through a series of questions based on your affidavit, okay?
Okay.
Which you signed this morning, which was based on our initial interview with you and your interview with SWED. This is basically the same thing you told SWED. Is that correct?
Correct.
In your affidavit, you say before the defense put up their case.
Sir?
Lead.
Overruled. Go ahead.
Thank you. In your affidavit, you said before the defense put up their case, Ms. Hill told the jurors, quote, "The defense is about to do their side. They're going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off," unquote. Is this true? Did Ms. Hill say
That's
that?
exactly what she told us.
I'm sorry?
That's exactly what she told us.
Okay. The next thing you say is Ms. Hill made the above statement warning the defense would try to confuse us in the presence of all the jurors as we assembled in the same jury room. Is that correct?
Correct.
Now, y'all were initially in two
We was
jury.
in 2 separate rooms, and when she came in, we all went in 1 room.
Okay. Paragraph number 5, Ms. Hill said, "If you get emotional, we want to see your face because that is what they want to see." What does that mean?
She said, don't get nervous. Don't be afraid to show your emotions because that's what they want to see.
Who wants to see?
I don't know who she was speaking of. I'm assuming the court.
Okay. And then number 6, Ms. Hill also informed us Alex Murdaugh was going to testify, but I don't recall exactly what she said. All the jurors were assembled in one room when she made that comment.
Exactly.
She told you that Alex Murdaugh was going to testify.
Exactly.
Did you know before that he was going to testify?
I think we knew that he was going to come up. I think he was supposed to do it the day before, but he didn't. And I knew he was going to be the last person that afternoon.
Okay. During the visit to Moselle, juror number 826 and I walked to the scene together. Then juror 826 began walking with the clerk of court, Becky Hill. I could tell they were talking. I could not hear what was said between them. Is that correct?
Correct.
Is what you put in this affidavit truthful?
Yes, sir.
And this is what you told us back in
I don't remember that
August,
months
I
ago.
believe. I think I interrupted you cooking Sunday dinner.
Right.
All right, thank you. Please answer any questions defense may have for you.
Mr. Waters, or Mr. Meadows.
Thank you, May please, Your Honor. Good afternoon, Ms.
Good
741.
afternoon.
It's nice to see you again. When's the first time you talked to Mr. Harpootlian or Mr. Griffin or any other attorney?
I can't tell you exactly. It's been months. It's probably been September, August. It's been months.
Okay. And were they the first attorney to talk to you, or
Talk to.
you sure?
I think it was so many people trying to call me, and I was trying not to be involved, so I can't quite remember. But he's the first person I've seen.
First person in person?
Yes.
Okay. So when he came to your house?
Yes.
Mr. Harpootlian came to your house?
Yes.
Okay. And at that point, was Miss Holly with him? Holly, you mind raising your hand? You see Miss Holly?
Yes.
Okay. And was anybody else with him?
Yes. He was.
Mr. Griffin? Thank
Mr.
you.
Griffin.
Thank you. And you gave them a statement then, right?
Right.
And did they record you? I mean, were they audio or video recording you? Did they say we'd like to record this?
No.
They didn't?
But neither did the people that came out. They didn't. I didn't know I was being recorded by them neither.
I'm not trying to fuss.
Oh, okay.
But is there an audio recording of your conversation with them that you know of?
No.
Did they say?
Not that I know of. No.
Okay. So you don't remember them saying?
No audio recording. We're required to tell her if we're recording her under rules. We didn't record her.
He's on cross-examination.
Thank you, Ron. And at that point, and that was again, do you remember, you said you think, was that around the end of August, 1st of September when they first came and talked to you? Roughly?
Roughly. Okay. I don't want to.
And you told them basically everything that you've told us now, right?
Yes.
Exact same thing?
Exact same thing that I told them.
Nothing less, nothing more.
Yes.
So Mr. Harpootlian, just, and you didn't sign an affidavit back in September or when you talked to him the first time?
No.
And why not?
Because he was just coming out to talk to me. He just was asking questions. It wasn't nothing officially. He had, so.
When you say nothing officially, I don't know what you mean.
He didn't, he was just coming out to ask, he was just asking questions about what went on during the trial. It wasn't.
But did they ask you to sign an affidavit that day?
No.
Okay. Did they ask you to sign an affidavit anytime right after that?
No.
They never asked you to sign an affidavit until this week?
No, I was supposed to meet with them a couple of occasions, but I was having my own personal issues and I couldn't come.
Okay. Well, I'm sorry about that.
No problem.
So you told them at this first meeting back at the end of August, 1st of September, that y'all going to hear some things that will throw you off. Don't let it distract you or mislead you. Is that what you said?
That's what, I didn't say that. That's what the clerk of court told
Yeah,
me.
I'm saying that's what you said to them. I'm sorry. Okay. And where did that take place?
She would always stand like on the outside of the jury room, like in between, like on the outside. She would never really come inside the jury room.
So you were in, there were two rooms, right?
Yeah,
Okay, one room, and then the other room separated, correct?
right.
And you couldn't hear people talk in the other room, could you?
No, that's why when she came, everybody came in one room.
Okay, so this comment you said she made, did she bring everybody out in the hallway?
Some people was in the hall. That's why I said she was standing right at the head of the door.
Standing at the head of the door.
Right.
Was Mr. Bill there? Your bailiff?
Yeah, he would be standing in the hallway.
He's all out there, right?
Right.
And then she said in front of everybody, the defense is about to do their side. They're going to say things that will confuse you. Don't let them confuse you or convince you or throw you off. She said that to everybody.
She said that to everybody.
So everybody could have heard.
Everybody could hear it.
And you said you were all in the same jury room.
Yeah, we would all be in the same. When she came, she was standing in front of the door with the jury room that I was in, and everybody would come over. They would let us know before she came. They'll let us know like after lunch she gonna come talk to y'all, and we all would gather together.
So would you go from the two rooms into one room?
Some would be standing out. She would stand in front of the door. Some would be standing around her outside the door, and some would be in the room. But it was clear enough for us to hear and see her.
And I'm just, Mr. Harpootlian led you, and Ms. Hill made the above statement warning that the defense would try to confuse us in the presence of all of the jurors as we had assembled in the same jury room.
We was all in the same jury room. She would be on outside the door, and we would be in the room, and someone would be standing beside her. We was always all together when she came.
And do you think that was unusual?
No, because I guess she didn't want to walk back and forth to room to room.
No, in fact of what she said. Do you think that was unusual?
Yeah, I did.
And if you get emotional and see his face, they want people to see your face?
Because some of the jurors was getting emotional, and I guess she noticed it, so she commented on it.
And you said you didn't, the statement he read, she informed you that the defendant was going to testify, but don't recall exactly what was said.
After, yeah.
When was that?
That was, I think he came in that afternoon, like at 2:33. So that was before he testified, I think.
And where was it?
Oh, in the jury room. Where we were all, like I said, we would all meet.
And I guess what I'm saying is you're in two different rooms for a while, right? And y'all get up there, you split, don't you?
Yeah.
The people that talk loud in one room and the others in the other. Pretty much.
No, it's not like that. It was just, they just split it off. They just asked us what room we wanted to go to.
So when you were fixing to come back to the jury room, to the box, you tell us you'd all go into one jury room together?
Only when she came to speak to us.
And Mr. Harpootlian asked you about, I believe, number 7 on the affidavit. And when did you sign this affidavit?
This morning.
And when's the last time you had talked to Mr. Harpootlian?
No, I haven't talked to him since he came to my house.
Or any of them before today?
No, I haven't talked to him since he came to my house.
Talked to anybody else involved in this case before today, since then?
No, he was talking to my lawyer.
Okay, and who was that?
Sean Wilson.
Okay, and when had Sean Wilson talked to you?
He's been my lawyer.
Since when?
Since 2021.
Okay, when Mr. Wilson talked to you about this case and what you told Mr. Harpootlian prior to.
All right. They apparently don't object to this, but I am very uncomfortable with your asking what her lawyer told her.
And I wasn't going to time test. I was just looking for timing.
Well, she's told you a couple of times that he was her lawyer since 2021.
Well, see, you're a lawyer for this.
For what you mean for this?
Well, like being a juror.
For being a juror?
Yes, sir.
He was always my lawyer.
You didn't hire him for this?
No, I didn't hire him for this.
But he had talked to Mr. Harpootlian about your affidavit and your testimony today, hadn't he? Is that a yes?
Yes, he was looking over the paperwork. He was looking out for me because he's my attorney.
When was he looking over the paperwork?
Oh, I guess ever since September, October. I wasn't really keeping up with it to be honest, because I'm.
So do you know if he's talked to Mr. Harpootlian this week?
Yeah, he talked to him today.
Talked to him today?
We was together.
Who was together?
Me and my lawyer.
And Mr. Harpootlian?
Yes, when I went to go sign the affidavit
Okay. Where'd you sign it?
at his office,
At whose office?
Mr. Harpootlian office.
Your Honor.
I was supposed to.
I would object. Commissioner.
Okay.
This meandering, I mean, there's no jury here. It's you. And I don't know what this is.
How about helping a little bit? I think we got all the information. Yeah, all right. I think he's gonna move on. Yeah.
And that's the last question Mr. Harpootlian asked you about this affidavit, isn't it?
What was the last question?
During the visit to Moselle jury, say the number, whatever the letter is, it doesn't matter. You saw a juror, and I walked the scene together, then the juror began talking with the clerk of court. I could tell they were talking, but I couldn't hear what they were said between them. That's the last question he asked, right?
Correct.
So, and you have no idea what that conversation was about?
No, I don't.
Now, the next, number 8, he didn't ask you about was I also overheard discussions in the jury room that Ms. Hill drove a juror home. I believe it was a juror whose nickname was Boston. Now, he didn't ask you that a minute ago, did he?
No, but, okay, no.
And you didn't include that in the first conversation you had with him back in August and September in this affidavit Ms. Holly did you? You didn't tell him about that.
I can't remember.
Have you seen the affidavit Ms. Holly did for you back in September 1st,
Objection, Your Honor.
2022?
Ms. Holly did not do an affidavit. Ms. Holly
She
did
just
her affidavit, her notes of what this young lady said to her, and what she included and didn't include was based on what Ms. Holly thought was relevant at the time, but she
Yeah,
can't be
that
cross-examined.
affidavit's not in evidence, Mr. Meadows, so I think you
We'd
need to
offer
move.
it, Your Honor.
Sir,
I'd offer it. Just didn't get it.
well, how is this thing gonna be authenticated?
You know, even more importantly, he can't question her. I'm sorry.
Several people can't talk at one time. I don't even have the affidavit. Let me see what you're talking. You talking about the one that was just offered today?
This is one Holly did when he first talked to her back in August, and she's referring back to
Miss Miller. Okay, Miss Miller.
This is Ms. Miller's affidavit about what she thinks this juror said. I'm not going to allow this, Mr. Miller. I don't see a whole lot of difference between this and what's been said in the affidavit that has been offered by Mr. Waters, but I'm not going to allow that.
Thank you. You did not tell them about hearing that Ms. Hill had driven a juror home back when you met with them in September, did you?
I can't remember.
I'm sorry. All right. Who is Boston?
She was a juror on the trial. I don't know her, but that was the nickname they gave her. I don't know her first name.
And what, if anything, did you know or convey about Boston?
She was a juror on the case, just like everybody else.
But anything else?
No. Nothing.
Ma'am?
No.
Okay. So again, Mr. Harpootlian didn't ask you, but when you, in the affidavit of today, I also overheard discussions in the jury room that Miss Hill drove a juror home. I believe it was a juror whose nickname was Boston. Is that something was added after your lawyer was with Mr. Harpootlian today?
I don't know if I added it. We talked about it today, but I don't know if I mentioned it in September or not. But I know it.
You've ever talked about it, wasn't it?
Your Honor,
No, it's not.
No reason to raise objection.
The first thing is, Mr. Meadows, I'm going to caution you one more time about this. You cannot talk over a witness. The second thing is, you don't need to be marching all back around here. You talking only to me, not the jury or anything else. So let's slow down, and, you know, this is repetitive of questions that have been asked before. If you want to take this tone with her, I don't know exactly what you're trying to accomplish.
I'm not trying to take Tony. I apologize. She knows that, and I'm sorry.
Well, you're just talking to me.
I'm sorry.
This is not some drama thing for the jury.
I know, I'm sorry.
All right, well,
I'm sorry.
let's
It
finish
does-
this thing up.
The only reason I did it, what he hadn't asked about it, and it to me is the key issue here. They're trying to say was different.
Mr. Meadows, I mean, you lecturing to the witness or to me or what? Please don't do that. Strike that from the record, please.
Don't strike. I'm
Let's
so
line
sorry.
it-
I'm
Let's
sorry.
line this up.
I-
All right.
Uh, in number 9 in the affidavit, that before the jury began deliberating, I heard a member of the court staff say the deliberation shouldn't take long. I don't remember specifically who made it, but it was made in the presence of the entire jury right after closing arguments in the jury room.
Correct.
Then I think you said something, Judge Newman came to see you afterwards, but after the jury went to their room, you were in a separate.
No, when we first left out the courtroom, we all went in the same jury room, and then they separated me.
Miss Simply, when I mean to raise my voice.
Oh, that's okay.
I apologize.
That's fine.
But when they started deliberating, were you in a separate room?
Yeah, when they started deliberating.
So you had no involvement in the deliberations or verdict of Richard Alexander Murdaugh? at
No,
all,
sir.
did you?
No, sir.
You didn't get to come back to the verdict, did you?
No, sir.
Have you read Miss Hill's book?
No.
Okay. And I noticed your interview. I did watch it. And I think Mr. Radford back there, you raise your hand, Kyle Radford, I think came to your place and interviewed you.
Right.
At some point during the trial, I think there was some discussion that somebody might have wanted to do an interview with you.
Yeah, that's what she said.
Okay. And then after the trial, I think there was some discussion. Somebody, since you weren't on the jury, they may not have wanted to interview you. You remember that, roughly telling the officer that?
Yeah, that's not what she said. She came to me roughly in the middle of the trial, and she said, I have a few people who would like to interview. She said, she didn't say a few. She said, I have a lot of people that's inquiring to interview with you. She said, but I'll have to get with you after the trial. But after the trial, she came back in the jury room, and she started handing out cards. And she handed everybody cards but me. And she was like, I don't have any cards for you for an interview because no one wants to speak with you. That's what was said.
And did, I mean, you weren't happy with that, were you?
Yes, I was.
You were happy with that?
I don't need to be interviewed.
Dave Portugal.
Briefly, Your Honor. The matter just asked you a series of questions that I'm not sure I've heard before. Who approached you during the trial and indicated the media would want to interview you?
Miss Hill.
Miss Hill?
Miss Hill herself.
Just you or all the jurors?
They had, I think it's the day they had the bomb threat. And I think that was the day. And she approached me.
You?
Me, by myself.
By yourself. And where were you?
That's the day in the lunchroom when they had the bomb threat. We went to the middle school. I believe that was the day.
The middle school. And she came over to you and said what?
That she had some reporters that was reaching out to her that wanted to speak with me.
To you?
Yeah.
Not the whole jury, to you. Was there anybody with you at that time?
No. It was
Did
just
she indicate why they wanted to speak with you? Just you?
No.
Did she indicate what reporters?
No.
Did she ever talk to you about doing interviews with the media after that?
No.
But you indicated she brought some cards at some point?
She brought cards in to hand to the jurors.
Before?
After.
after
The verdict was read.
cards of media people?
Yes, sir.
Did she tell you she was writing a book?
No.
Did she indicate to you why it might be good for her if you did media interviews?
No.
But she had a conversation with you in the lunchroom of the
I
middle
believe it was the
school.
lunchroom. I
by-
think the day of the bomb threat.
the day of
But
the bomb threat.
I'm 100% sure she came to me and she told me that in the middle of the trial.
Was there a bailiff with her or just
No,
her?
it was just her.
Pulled you over and said, "Hey, I can make you famous. I can put you on TV."
She said she had media that wanted to talk to me. That's what she said.
Okay. I hyperbolize. I apologize, Your Honor.
Yes, sir.
That's all I have.
All right, no further questions, Mr. Harpootlian?
No, Your Honor.
Very good. All right, thank you very much, ma'am. You are excused. All right, Mr. Harpootlian, that it?
I need to put one matter on the record, Your Honor, and that is it.
All right,
As soon as I've told what to put on the record.
all right, sir.
Your Honor, earlier today, you received a very short affidavit from Juror Z. We'd like to proffer that and make it part of the record.
Right, I did not admit it, but I'll accept a written proffer, and if you would give the thing to me, I saw it on the screen on my law clerk's computer, but I don't have a printed out copy.
We don't either, but would you allow us to do that?
Well, I will allow, before I close the record with Ms. Harris, if you can get it to us. When can you get it to us?
We could email it this afternoon.
Very well. How about do this? How about email it to Mr. Waters, to me, to Ms. Diaz, and to Ms. Harris, the court reporter. And I will say now that it's offered as a proffer, and I admitted it into evidence. All right.
Your Honor, we referred to earlier on a email to the Japanese television folks. I do have copies of that. I'd like to make that part of the record.
All right, but hand it up to me and let me see it. And also, of course, to Ms. Waters.
Oh, I'm sorry.
I got two of these, Mr. Harpootlian. I'll give you one back. All right.
And Your Honor, for the record, the hearing before Judge Newman to seal the body cam videos was on May 26, 2023. This email is in July, just to give you the context of
All
what's
right,
going on.
and this is being offered as a after the fact email to Rebecca Hill, and her replies garnered from the emails that were released by Cotton County at a certain point. And it addresses the issue I raised with Ms. Hill relative to the security of sealed records.
Exactly, Your
All
Honor.
right, I'll admit it. Mr. Waters?
As to this specific exhibit, Your Honor?
Yeah.
Your Honor, I mean, we don't have any objection other than the ones we've raised just generally to the testimony. But I have no further objection to
Very
Your
good.
Honor.
All right.
Your Honor, that's all we would have.
All right, hang on. All right, have you got a copy of it there? I got it. This is his next exhibit, Harpootlian. Proffer is his one.
So this is two.
Right. The proffer is your exhibit one, Mr. Harpootlian, and this file, which I have admitted, is your exhibit two.
Thank you, Your Honor.
All right. All right. Now we proceed to closing. You prepared?
Yes, ma'am.
Very good. Mr. Waters.
Thank you, Your Honor. Just to go back and reiterate as to the standard, and ultimately, we've of course argued that the defendant has the burden. We've also discussed that the standard for Your Honor, of course, is first of all, was there any misconduct that occurred? And then regardless of that, whether or not there was any effect on the verdict. And the standard has been expressed in multiple cases is whether the verdict is solely the product of honest deliberation or the product of outside influence. And that inquiry fundamentally, as the court recognized from the very beginning, focuses on the jurors themselves, because it doesn't necessarily matter what was said as much or what was intended or what was inadvertent, even assuming that those existed. What matters is what the jurors heard, what they perceived, and whether or not it had any sort of effect on the verdict. And Your Honor went through that inquiry with these jurors. 11 of those jurors were clear and unequivocal that there was no effect on their verdict, and also clear and unequivocal that nothing was said that could in any way be inferred as any sort of attempt to influence them. And I think that's very important, Your Honor, because there can be sometimes behind the doors, as we've talked about, I think some of the cases recognize this, that some conversations can go on and things like that can happen. But ultimately, and while I think there were some cases cited in some of the various South Carolina decisions, that it's not, that's unrealistic and not surprising to think that sometimes things like that can happen, an untoward comment or something was said. But that was an Aldrich, Your Honor, in the 1999 Supreme Court case. But the mere fact that something like that may be stated, that could be stated in a neutral reason, is not enough to undermine the verdict, because the inquiry ultimately boils down to what was it that those jurors heard, and in the end, though, did they listen to the instructions from the trial judge? Did they come to a fair and honest verdict? And Your Honor, the evidence here is overwhelming, I would say, from the people that matter, and that's those jurors. And that is, there was no effect on the jurors. And you saw every single one of them very clearly and strongly looked you in the eye, all 11 at least, and I'll get to the 12th one in a second, but looked you in the eye and said, no, that didn't happen. No, I didn't hear anything like that. No, there was no effect on our verdict. No, this was our verdict, and it was based solely, which was Your Honor's question, solely on the evidence and the law and the testimony at trial. And I think that carries the day. We have the one juror, and I want to make sure, because I'm about to say the number and I don't want to do that. Let me go back to Juror Z. And let's look at Juror Z and what she said, because Juror Z also said that, yes, I said this was my verdict. I was polled and said this was my verdict. Juror C also said that my verdict was solely based on the evidence and the law of the testimony at trial. Answered question number 2, yes. Absolutely, yes. But then goes on after that to say she heard some communications from the clerk, and then says, well, it had an effect on my verdict. Even after she had already answered question number 2, when she said her verdict was based solely on the evidence and the law and the testimony at trial. And beyond that, then, Your Honor, I think that it's very telling that the affidavit that was submitted from this particular juror, and we've been pointing this out from the beginning because it's very crucial and very telling, because despite the things that she alleges that happened, even though the other jurors say it didn't, despite the things that she alleges that happened, she says that she voted guilty because she felt pressure from other jurors. Not that her verdict was in any way affected from some supposed external influence. In that affidavit that was filed with the defense motion from day one, that is what she says that she felt pressure from other jurors. And Your Honor, we've cited the cases over and over again that the internal mechanics of the jury room, the fact that one juror feels pressured by others, as long as there's not violence or things that go beyond the pale, that is not a basis for undermining a verdict. That is part of the deliberative process, and it's expected, and it occurs. But I think it's very telling that we have those conflicting answers. And Your Honor, without waiving any objection to the latest affidavit that we were just discussing from this juror, I think that's very telling. Because now we have answer number 3 as it relates to this particular juror. And of course, it is clearly manufactured and rehabilitated, recognized after the fact. She, of course, is, this juror is represented by Joe McCullough. And ultimately, we've got now a third version of events from this very juror. So we have this juror who's given answers all over the place that are inconsistent with 11 other jurors who were very strong and unequivocal that, yes, this was our verdict. It was based solely on the evidence, the law, and the testimony, that there were no communications from Becky Hill that influenced that verdict. And I think ultimately when you look at the case law, in the end, it's up to Your Honor to make that ultimate determination and looking at all that law together. We cited a number of decisions, including, as we discussed, the questions to be had. I sent an email where we set out some questions that it's not uncommon, perhaps, for a juror to have a second thought. But the law is very clear that it does not recognize that, because what that would do would be to consistently and constantly put every verdict that occurs in any courtroom in this state or in the nation at risk. Jurors don't have to vote in perpetuity. They vote on one day and one day only. And here, Your Honor, the evidence is overwhelming that those jurors' verdict was the product of honest deliberation. And the only bit of contrary evidence to that effect is from a juror who, frankly, not only said that it was purely the result of honest deliberation, but then has answers all over the place. And Your Honor, I would say that the other 11 jurors are credible. They were strong. They were clear with Your Honor. And I think that ultimately that carries the day. Now, we've had testimony from other people since the jurors were here. We've had testimony, obviously, from Ms. Hill. We've had testimony from Ms. Rhonda. And we've had testimony from this alternate juror. But again, none of that testimony at all goes to what is the ultimate test for Your Honor, and that is whether or not this verdict was the product of honest deliberation. And on that, again, the evidence is overwhelming and strong and clear that it was the product of honest deliberation. It's very interesting as we look at some of the testimony from the other witnesses. And obviously we have Miss Becky, and as Your Honor has pointed out, we're not here to go through some of the issues that have been alleged or are percolating out there. That's not the point of this proceeding here today. But Miss Becky is a court reporter and then became a clerk, and was clear to you that she never made any comment in an attempt to sway the jury one way or the other. We have Miss Rhonda. And Miss Rhonda came in and testified, but I would submit to Your Honor that this is kind of a red herring, because what Miss Rhonda described were conversations that she herself admitted are just the kind of conversations that go on. And that's the reality of it. The conversations that go on among a trial team when we're not in open court, where we're discussing things, the kind of conversations that go on among court staff behind the doors, those types of conversations go on. But that does not mean, nor does that necessarily indicate that somebody's not going to come out here and do their job fairly and understand the distinction between influencing a jury and not doing that. And one thing that I think is very important is Miss Rhonda was at that trial more than Miss Becky was. And she was very clear. and I probably was as repetitive as anyone here today, and asking that question over and over again because I didn't want that point to be lost, that Miss Rhonda said, I was there more than anyone else, and I never saw anything or observed anything or had anything happen that would cause me independently to go to Judge Newman, because that's what I would have done, to go to Judge Newman and say, something's not right about this. This needs to be fixed. Something's going on that's improper. And I think that that is an extremely crucial fact, because Miss Rhonda admitted and said, of course, as she would, that if something had happened that the judge needed to know about, she would have been the first one to do it. And it never happened. And she was here more than Miss Becky was. It never happened. When we look at the balance of those facts, when we have the clerk of court come in and testify that, you know, maybe I did this or maybe I did that, maybe I plagiarized the book, a portion of it, maybe I did this, maybe I wrote in things in there that are based on community knowledge or newspapers or poetic license or whatever you want to call it. I don't care about the book. And I would submit that Your Honor doesn't need to care about the book either, because the book and what happened with the book afterwards is not what is relevant to the inquiry. But she was clear that she did not have any attempt to influence that jury. She was clear about that. And Miss Rhonda was clear that she was not aware of anything like that either. And what does that do but corroborate the most important witnesses here? The defense, I think in one of their letters, tried to say that Miss Becky was the state's star witness, and that's not what this inquiry is about. It's not what this inquiry is about at all, because as I've said from day one, if there were not facts to be litigated, if we had not done an investigation and had those 11 jurors say, that didn't happen, there was no effect on our verdict. This was the product of honest deliberation, we would be the first ones here standing here to say that. But what we do know, Your Honor, is that what Miss Becky said and ultimately what Miss Rhonda said corroborates who are the true, if you want to say it, and I'm only using this term because the defense accused us of Miss Becky being our star witness. There are no star witnesses here. This isn't about stars. But what Miss Becky and Miss Rhonda do is corroborate who are the most important witnesses. And that are those jurors. And you have 11 of them strong as a rock saying this verdict was not influenced. Nobody tried to influence. And regardless, it was the product of our honest deliberation. And you have one juror who said that too, but then has answers that are all over the place. And if you go back to her original statement, what she says is not external influence anyway. It's not sufficient under the law. So I think that the proof here is overwhelming. I think the proof here corroborates what those jurors say. I think the only juror that we have to contend with, her testimony is compromised. And I'm not saying that that person is in here maliciously lying. I just think that this process is a lot. But it's clear that if there was any attempt to influence this jury, those jurors who sat in that box, every single one of them, you saw them, and we saw them for 6 weeks. They are conscientious. They take their obligations seriously. They were not here to reward friends or punish enemies. They were here to do their job appropriately and fairly. You saw that in their eyes. You saw that in their mannerisms. You saw that in their demeanor. And they were strong and clear that this verdict was fair. Your Honor, we would submit that the motion for new trial be denied.
Mr. Harpootlian.
Mr. Griffin will be arguing.
All right.
Okay, if I stand here, Your Honor. That way I won't be interrupted by Mr. Harpootlian as I'm trying to make my points. Your Honor, I want to first start with State v. Green because I understand that that's the guidance. That's what we're following here. And reading, excerpts from State v. Green, first, it is absolutely clear in State v. Green that we find ourselves, and the issue is whether there's a defendant's right to a fair and impartial jury under the Sixth Amendment has been violated. Reading from the opinion, it says, in the Sixth Amendment's context, the Supreme Court of the United States has held that, quote, any private communication, contact, or tampering with a jury during a trial about the matter pending before the jury is deemed presumptively prejudicial. Now, Green goes on to say that we are not going to categorically apply the presumption whenever there is a contact with the juror. But the question is it prejudicial? Not whether the verdict would have been different. It is it prejudicial? And I'll keep reading. The court says we're not persuaded that the Rimmer presumption of prejudice, we're talking about prejudice, not is the verdict different? It was their prejudice. Was this tainted process? Was it prejudice to the defendant? Was the process prejudicial to the defendant because of extraneous communications? Not whether the verdict would have been different, but whether there's prejudice involved in the process of the trial. The court goes on to say, our unwillingness to categorically apply the Rimmer presumption of prejudice stems from our view that not every inappropriate comment by bailiff to a juror rises to the level of constitutional error. Goes on to say the attempted bribery of the jury and Rimmer conduct, which goes to the heart of the merits of the case, is a far cry from the circumstances presented in this case. The bailiff's actions here, though improper, did not touch the merits, but only dealt with the procedural question of how the judge might handle a jury impasse that apparently never materialized. The court says, while we decline to adopt the Rimmer presumption of prejudice in every instance of inappropriate bailiff communication to a juror, the occasion of this case presents an opportunity for our clerks of court and circuit judges to ensure that all bailiffs are properly trained. Now, the only thing the Green did was reject the presumption of prejudice in every case. And Your Honor, I just want to preserve for the record that our position is that the comments that you heard in this case go to the merits, go to the heart of the defense. And if you find that those comments were made, and I'm going to establish for the record, we clearly have proven that then we do get the Rimmer presumption, that we do get the Rimmer presumption if we have proven these comments were made. But I'm going to argue that we proved prejudice also in this case. So to start with, let's go to the evidence that was presented since Friday. And Your Honor, we have 12 deliberating jurors. In this case, what you've heard, 3 of the 12 have testified under oath that they heard Ms. Hill make comments about the case, whether it's, how they categorize it as merits or not. But Juror X on Friday acknowledged that Ms. Hill made a comment about Alex was going to testify, that it was going to be epic or some words like that, and that the defendants don't normally testify. That's what Juror X said on Friday. Today, so that's one who says Ms. Hill made a comment about Alex's testimony, how it's going to be a big deal, and defendants don't normally testify. Juror Z today says that first she says Ms. Hill said to watch his actions, to watch him closely, and then she said there are other things that he said I don't remember, and then we were allowed to show her, and with Your Honor, I asked her questions about her affidavit, and she says, confirm what was in her affidavit, that Rebecca Hill told the jury not to be fooled by evidence presented by Mr. Murdaugh's attorneys, which I understood to mean that Mr. Murdaugh would lie when he testified. She also acknowledged, this is a truthful statement, that she instructed the jury to, quote, watch him closely, close quote, immediately before he testified, including look at his actions and look at his movements, which I understand to mean he was guilty. And she also said and confirmed that Ms. Hill said when they began deliberations that this quote, this shouldn't take us long, close quote. And that if we deliberated past 11 p.m., that we'd be taken to a hotel. Those statements go to the merits. Those statements go to the heart of the defense. Those statements go to what Mr. Murdaugh, his credibility. So that's 2 deliberating jurors down. The 3rd deliberating juror who testified today is Juror P. And he says, you were asked, Juror P, did Ms. Hill make any comments about the case? And he says, yes. She said the day that Alex was taking the stand, excuse me, Juror P is a he, but he is saying that she, Ms. Hill, said the day Alex was taking the stand, that she, Ms. Hill, made the comment about watch his body language. That's all I recall. So 3 of the 12 deliberating jurors heard Ms. Hill speak about Alex Murdaugh's testimony. 3 of the 12. And then we get the alternate juror came in and basically corroborated what those 3 of the 12 heard. And she had additional things that she had heard, but she corroborated what those 3 of the 12 heard. And then you've got Ms. Hill who gets on the stand and denies it all. And Your Honor, I couldn't agree with you more that you're able to judge the credibility of witnesses. And on this record, there's no way to find Ms. Hill credible. There's no way to credit her statements that she did not make these statements about his testimony. I mean, she crossed herself up as Your Honor is questioning her about the transcript involving the egg lady and how the egg lady learned that there's some Facebook post that was allegedly attributed to her husband. There's no way the egg lady would have known that unless Ms. Hill told her, and that pretty much came out there. I mean, so, you know, and I know this is not a jury argument, but if someone misrepresents a fact to you once, I mean, I don't think you should go back and credit anything beyond that. What we hear from Ms. McElveen is that she heard these almost identical statements from Ms. Hill that Ms. Hill told that 3 of the 12 deliberating jurors heard and the 4th alternate heard. That Ms. McElveen heard her make very similar statements about the defense's case, about Mr. Murdaugh's testimony. So you got to put Ms. McElveen's testimony in our category. And Ms. Hill gets up there and says, never drove a juror home. Ms. McElveen's got no dog in this fight. And she says, she goes to court one day, she hears that Ms. Hill took a juror home the night before and went and talked to her and said, you can't do that. And Ms. Hill said, I didn't talk to her about the case. Well, she gets on the stand under oath here and tells you, I never took a juror home. I mean, it's totally inconsistent. And for her to say, I never made these statements, you know, she tried, I mean, she kind of gave herself a little wiggle room at the end. Well, when they were lining up, I may have said he's going to testify today or something, but these jurors heard this information. And the question under Green and Rimmer, was it prejudicial? Now, what we got from Juror Z today, the question was, did these comments influence your verdict? And Juror Z says, yes. Then you ask how? And Juror Z says, to me, it felt like she made it seem like he was already guilty. Then you said, did it affect your finding of guilt in this case? And the answer was yes. And so that's prejudice, Your Honor. That is prejudice from one of the 12 deliberating jurors. Was your verdict influenced by what Ms. Hill said? And good grief, how could it not be? How could it not be? And to ask all these other jurors who heard the same thing, was it influenced? It's really an impossible task because you don't know what's influencing a jury. And frankly, that's why the Rimmer presumption is there. But let's try to sort this out. And Your Honor, I think it was a State v. Kelly case where the deputies went out and they were investigating the jurors' beliefs on the death penalty. And there was really no testimony about, did that affect your verdict? But it was just so wrong. The conduct was so wrongful that the Supreme Court says that's prejudicial and we're granting a new trial. I mean, this is prejudice, and this has been proven. I mean, Ms. Hill is not credible. Ms. Hill is not credible. And she's talking about her book, talking about taking literary license to lie. Literary license to lie is that's what she thinks a literary license is. So her testimony should not be credited. We have proven, we have met our burden of proving that there was extraneous contact with these jurors. 3 of the 12 deliberating jurors have testified to that. 1 of the 12 says it influenced my verdict. How is that not prejudice? And that's all we have to prove. We believe, for the record, there is a presumption of prejudice that they have to overcome, but we have proven prejudice. And Your Honor, we respectfully request that a new trial should be granted based on the record developed today. Thank you.
All right. The arguments are closed. I will take until 5 of the hour to examine my notes, and then I will come and make a ruling from the bench on this matter. Court will be at ease.
Okay. Well, there we have that. Wow. You know what? There was a lot of controversy before this hearing started, and I can't say I feel any better about it today right now. I really don't. I don't think I've settled either way, except for that I really do think that a retrial is necessary. I hate the fact that it is necessary. I do not agree with the arguments as to why it's necessary. To me, it's simple black and white, a matter of legal precedent, a matter of protecting the jury process. I get the risks of, like, let's not open it up for everybody saying, oh, that person sneezed at me and that really put me in a bad mood, so I voted against the guy. And I know that sounds ridiculous, but I get that argument. I understand what people are saying. I do. Hey, Beck, how are you? Thank you all for hanging out with me all damn day. And I believe she said tomorrow, right? Did she say tomorrow? Because I got so excited. I was answering a very exciting message. And I missed the last second. So somebody please tell me if I'm staying here or if I'm coming back tomorrow, Yeah, Pete, it's unfortunately necessary. Hello, Beck. Yep. I have settled that this is dumb and shouldn't be occurring. Just do a new trial and let us move past this effing case. I get you, Juju, but I do hope when we have to do this effing case again that you'll come keep me company. I really do. I'm going to need all your support, people. I am. I know you were, Beck. You were up here all the time. Yes, you were. And it looks like we might have another trial. I'll be back tomorrow. And I do throw the link down for the breaks in for lunch and all, like before. It's over 7 hours. Oh my gosh, it is almost 5 o'clock. Okay. Eye roll? Why are you doing the eye roll? Why are you doing it? Oh, do you miss hanging out with us? Don't do the eye roll because you miss hanging out with us. Dude, this is not cool. Good luck finding some jury impartial. There's going to be fun. There's going to be a change of venue for sure. Absolutely. And I think rightly so. Anywhere in South Carolina is going to be tough, but they have to do it in South Carolina. Okay, could somebody please tell me if she's coming back tomorrow? What did you hear? Oh, the eye roll was for that. I agree with you, Beck. Like that is a big eye roll. Somebody came in and they hadn't even heard anything yet, and they were like, "Oh my God, this guy again!" Like, "Oh my, I'm so tired of this guy. He is just absolutely disrespectful to the system." Thank you, Beck, for clarifying. I didn't really think it was because of me. I thought, we're cool. We're all cool. I don't think I have any haters in the chat. If I do, they're not talking. Yeah, exactly. Okay. 5 to what? Okay. Decision at 5 p.m. today? So I'm not going anywhere. Are you serious? Erin, is that exactly what she said today? Like in 15 minutes, she's going to decide? This is over? Okay, I'm going to drop the link. Somebody come keep me, somebody have pity on the bear and come keep me company because my voice is about out and I can't talk for another 15 minutes straight. I really can't. All right. Juju, Beck, somebody, Aaron, anyone, Pete. Pete, one day I want to get you up here with me. I really do. Yeah, Juju, I really think that the judge made up her mind hours ago. I do. And I don't think she allowed 3 days, but I think she knew it wasn't going to take that long. Hmm. Thanks, Beck, for having pity on my poor voice. There you go. Oh, you're muted. Can you hear me? You okay, Beck? Beck. I can't unmute you. You're muted. Is that what you heard too, Ricker? 15 minutes yet? Like, okay. Beck, if you can hear me, you're muted. Oh, there you
Yeah.
are. Okay.
My headphones weren't connected right, and I didn't want to get the feedback. Yeah, they said they were going to come back at 5 p.m. So
Okay, so I'm glad
in
I
14
didn't
more
crash the
minutes.
stream. I'm glad I didn't run away. I was tempted to because it's been a long day. Yeah.
Yeah, I'd
Yeah.
much rather hang out with you than work. Abso-fucking-lutely.
Wait, I'm taking you away from work. That's so funny because, like, Kelly from Manson Files, like, not from Manson Files, from Justice from Manson, she came up, like, with me
Yeah.
during lunch, and she was working too. And Mandy's in the chat, and I know she was working too. Like, I know
No,
some
I
people
just got
working.
home from work actually, like 20 minutes
Yeah.
ago. So yeah.
Oh, okay. It's funny. We're like reunited over Murdaugh. You, me, Pete, Mandy, like everybody in the chat going, "Oh man!" And whenever I hear Murdaugh, the only thing I want to see Bubba. Like that's the only pleasant thing I remember is
Doesn't
Bubba.
Buster has Bubba now, right?
I don't know who has Bubba.
That's what I heard.
I know that the housekeeper took. That very well spoken housekeeper that made a lot of money that took care of their private stuff.
Yeah.
Yeah, she took Bubba at first because she said that Bubba was really, really close with Maggie, and Bubba didn't want anything to do with Alex after the death.
Yeah,
And I thought that was a big tell right there. And I don't know why they didn't bring a dog expert, a dog psychologist in there to say, hey,
Yeah,
if
'cause-
Bubba doesn't like Alex anymore, there's a reason, people. Like it might be because he just blew off his family's heads. Like I don't know. It could be. Like it could be. Like the dog has issues.
Yeah, it's pretty bad when if dogs and children don't like you, it's a big tell. I'm just
True,
saying.
like they can tell. They can tell. They
They feel it. They feel it. Yeah.
But even like they might not like you because you're nervous. Like if you're scared of dogs, like they might hedge from you. It's not that they don't like you, but they would be untrusting because you're giving off like a weary vibe. Like
Yeah,
so
but
I
I'm
guess,
saying if a
but
dog
if they really
walks
don't
away
like
from you, if a dog walks away from you with like its tail tucked and its head down, yeah, that's bad.
either that or you smell really, really, really bad, like really bad, like
I
shower time.
did
Shower
see
time.
some I did see some paparazzi video after the trial was over and he was in jail. It was like a
Mhm.
month later or something, and they showed Buster walking Bubba. So I don't know if they're just trading him
Well,
off or if he's going full
I'm
time.
sure the whole family, I'm sure the whole family would visit, like whoever's left, because Bubba, like he's a popular dog. Like he was friendly. Everybody was calling Bubba. Like everybody knew
Yeah.
Bubba. I mean, yeah, Bubba. I mean,
Bubba,
gosh.
he's got a chicken. It's a guinea.
I was just thinking, just so because we're passing some time and we have some of my longest members are actually in the chat today. So I want to throw this out there. How do you guys feel about, bear merchandise? Like I'm actually thinking that I could raise more money to donate if I actually sell bear merchandise. And I think, Bear and Bubba would make a great t-shirt.
Yeah, absolutely. Right. Bear and
Yeah,
Bubba know the truth.
Bear ass Bubba. Bubba knows who did it. Bubba knows.
Bear and Bubba know the truth.
Bear said Bubba knows. Why isn't anyone asking Bubba? That's what it should be. Like just Bear and Bubba on a t-shirt with like, why isn't anybody asking Bubba? Like Bubba was there.
I'm going to tell you, if animals could talk, there'd probably be a lot more people in jail right now.
Oh God, they really would. And small children too.
Right.
Absolutely.
Yeah.
Mhm.
Like if you could take a
Yeah, it would be
2-year-old's
funny.
word in court. Yeah. It's true.
True. Mhm.
Hope Bubba charged for those publicity photos.
Yeah,
Juju.
yeah, exactly. Turtle, I just don't have the time to write a book. Unless I get like the team, Mandy, if Mandy and Juju and Pete and a couple of others, Liam, you all join together with me to write this book, we'll write this book. But I just don't have any time. I can't even keep up with what's going on this week with all these hearings going on and the trials coming up. And then I got sick. Oh, God. Just
That
shoot me
might
dead.
actually be interesting if you got a bunch of people, each person to write their own chapter about it and their own perspective.
Well, that's kind of
You
what I'm
get
doing
5
with the
different, 6
Hitchhiker's
different
Guide.
points of view.
I get
Oh,
everybody
really?
to read it. I get everybody to read a chapter. Yeah, I'm putting that out there in my Bears library. I just did the first book of Douglas
Nice.
Adams and the Hitchhiker Guide. We did 18 chapters. It was really great. And now we're on book number 2. And I'm still taking
Nice.
volunteers. I have a couple chapters left, and we're going all the way through to the end of the series. So, like, if you're not in this section, you could be in the next one or the next. But it's all just an
Right.
audio recording. It's really easy, and there's so many different voices, and people have different feelings about the book. The way they read it, it's all different, and it's fascinating to me. It totally
Interesting.
is. It is.
Yeah.
But I agree. A different chapter of the book, everybody could write.
There you
Mm.
go. Yeah.
Oh yeah, Juju, you would have to. If we stay true to the course of the Murdaugh history, somebody has to write part of the book, and then one of us has to steal the proceeds from everybody else, or it's not a good Murdaugh book. I mean, come on, it would be true to the story. Like we need somebody to
Right.
backstab us, steal all the money, steal our deal, the whole bit. Like yeah.
Turtle, I'll do the voice of Bubba. I'll do it like this. Hi, I'm Bubba. I like to eat guineas and chickens.
Mandy, this is a great idea. What do you think? Juju, what do you think? A Bear and Bee mug. Yes. Oh, yes. I
You guys
see it. I
should.
see it. You guys send me ideas for merchandise. I'm working with somebody. That was the message that I got like just recently. I'm so excited about this. And anybody who has experience on their channel with setting up merchandise, could you please get in contact with me? Because I'm a noob. I'm a nerdy dweeb noob about these stuff.
Just
I'm
go
telling you.
to Teespring. Well, it's called Spring now. And they give you all the different options and you just put your logo, pictures, whatever on it. It's really easy. Like
All right, so
super
they do t-shirts, backpacks. You know what I really want to do?
Oh, they do
Stickers.
everything. Bags, they do
do
they do stickers, they do magnets, they do everything.
Because then I want to run a contest of like the wildest places Bear and Bee had been. Like, and then just put out the stickers. You all buy the stickers and you just put it somewhere and then send it to us.
There you go, Aaron Reese. He said do one that says Alex stole it.
Alex stole it. Exactly. Alex stole the sticker. Don't tell. Don't tell. Bubba's
Alex
wearing the
stole
sign
the
that says Alex stole it. Yeah. This is so good.
Alex stole my mug.
Mhm.
So I had to buy
You're-
another one.
You're right, Rocket Couch. That would be a mug full of nothing if it's a Bear and Bee mug. That would be freaking fantastic. That would be like freaking fantastic.
Well, you could do like a shot of that library book you use for your intro.
Oh yeah, yeah.
And and you could put that on there and put a bear and a bee on the cover.
Oh yeah, I could.
Yeah,
I really
see?
could.
Just
But
nice,
I'm
simple
working.
stuff.
I'm working with the graphic artist who is like top, like he's like one of my favorite people on the planet, and I just tossed it
Nice.
out there, and I'm like so happy. Yeah, they're going. So I'm gonna actually give them free reign. If I say Bear and B, he's pretty good at doing bear characters. He knows me since I'd say like 3 months into starting my channel. I think he knows me and my content pretty well by now.
Right.
He
Right.
pretty much has me nailed, you know.
You might not
Message
want to say that like
JL.
that on YouTube. No, I'm just kidding.
No, he don't. Well, he don't. No,
He nailed
he
me.
knows me well, like a friend. No. Well, he nailed my channel content and like the ideas that I want to
Okay.
present. Like he gets me personally with nobody but Boo's nailing me, and then like, they're not even nailing me. We're too far away. So there you go.
And they
Message.
also, I think some of those places also have flasks, and you could put on it,
Really?
oh God, it's Alex again. I need a drink or something.
Oh my God! You know what? That would even be good for Bear and B and nothing. Like like have a toast and nothing. True.
Right.
Oh, we could do etched champagne glasses and wine glasses, Juju, and coffee mugs. Like, come on, we need to talk. Yeah. Oh, this is good. I like this.
Hey, 401.
Oh. So how you
Did you
been,
guys,
Vic?
oh, I've been
Oh,
good.
I'm
I've just
sorry.
been working a lot. I got a job and it was supposed to be like 3 or 4 days a week, and it ended up being 5, and I bust my ass. And but no, I'm doing really good actually since the last trial that you and I did together for Murdaugh. I have lost 33 pounds.
Wow.
Yep.
I didn't really
Yep.
think you had 33 pounds to lose. Like, where did like
Oh, I
wow.
did. It was all around my middle. Yeah, it was all that belly fat from being a truck driver. But I found out last May that I have chronic kidney disease, so I am now a forced vegan. And since I have
Oh
been a
wow.
vegan, the weight has just fallen off of me. It's crazy how much
Wait,
better my diet is now.
I'm sorry about the diagnosis, but I'm glad you got
Thank
diagnosed
you.
because now you can take care of it. So
Yeah,
yeah.
I mean, there's no fixing kidneys once they get to a certain point, but you can try to prevent further damage, which is what we're doing.
Exactly. No, I get that because I'm a post CA sufferer of kidney, so I get what you're saying. You got to be careful.
Yeah.
You can't correct. It doesn't regenerate. Like it's not like your
Nope,
liver or
it's
anything
not your
else where
liver.
you can.
Yeah.
And so
See,
you
if
got
I
to
was an
just deal with
alcoholic,
it.
it would have been okay. Could have generated their liver, but
If they get it in time, yeah. If they get it in time, yeah.
so
But
yeah, so somewhere between 4 to 16 years, something like that. That's my intended lifespan. So we'll just see.
I would say it's
We'll
probably more
see.
than that because if you do the right diet and everything like that, and you keep it going, like
Well, they're
I would.
saying the damage that's done, that's how much time that people get out of it once the damage is done. So
Yeah, but
I'm gonna try
that's
to beat the
today.
record, of course.
I think you
But
will beat the record because that's today, and things are changing all the time. Like just 2 years ago, you would have had to been in dialysis every day. That's only
yeah,
that was only
it's
24
yeah.
months ago. Like, and now it's not like that because of the new treatments and the new ways that they do the infusions. And so,
Well, I'm just glad I got the new doctor because she's Indian, like not Native American, like from India, and
Okay.
she is brilliant, and she caught it right away. Like she caught it and did test after test and established what it was. And she said, you gotta quit all meats, no byproducts, no butter, no milk, no, none of that stuff. I cheat and do a little cheese and butter here and there, and that's about it.
Yep.
But otherwise, I'm fully vegan. But yeah, she caught it in time because if
But
she
it's
hadn't have
good
caught
you're
it
feeling
and it would have got to the next stage, then I would have been in dialysis. Yeah.
Well, that's
So
good. I mean, I'm glad that that's working out, that they found it and you can do something about it. I mean, I don't like the prognosis, nobody does, but at least you know why you were
yeah.
feeling so crappy, and it sounds like you're feeling a lot better.
Well, that was that whole period I went through for 8.5 months. I was on a medication that made me nuts. And I figured it out on my own and quit taking the medication, and the crazy was gone. So Yeah, it was a mess. I had a lot of apologizing to go back and do.
Yeah, well, it happens, don't we all? Like eventually, that's the important part is accountability. So, what's going on with your channel? Have you been doing some content? Like, what are you doing?
Yeah, I'm just doing
And I
Sunday
apologize that I
streams.
don't know that already, but I've been out of commission for about
No,
a
it's
month,
okay.
so
I
I
don't have
don't
time
know.
to watch your
Yeah.
stuff. Like I see that you've been doing like Hitchhiker's Guide and stuff. I just don't have the time to go and watch it. You know. So no, I've been doing Sunday streams at 4 p.m. Eastern, and I call them
Ah,
Sunday conversations because it goes into so many different topics. I don't know what else to call it.
isn't that great for Sunday? Because I do that at 7 o'clock. I do it after you. I do it with Juju. We do Bear and B, and that's what it is. It's about nothing. And it's like 2
Yeah,
hours
yeah,
of
it's just
whatever
talking.
comes
Yeah.
up. It's just talking about whatever. And we try not to be too serious, because like Juju and I get together, it's either really, really serious or it's not. Usually on YouTube,
It's
it's
totally
not.
goofy.
Like
Yeah.
in the Discord, we could get really serious about cases and stuff like that. But on YouTube, it's seriously, we're just not that serious. We just want to have a great conversation and talk to everybody
Yeah.
and just enjoy ourselves. And it really sets me up for the week. I love those streams.
Yeah,
I
I
do.
always
I just love getting
I've
set up for
become
the week.
so introverted that every Sunday I'm like, oh God, I don't want to do this. But then once I start streaming, everybody comes on and we're having fun. I love it. So it's a
The
lot of
thing with
fun.
that
Just
is
to,
that, like, I find it so hard to schedule panels. Like, I really like panels have been
yeah.
wearing me out because like I'm just not as quick. I guess it's because I'm doing more content and there's so much more going on with true crime. I'm like researched out that I'm not applying all that
Yeah.
effort to making the panels work the way that I used to, and putting all that effort into that content. It gets to be really hard for me. I just don't do well with the winging it thing. I'm just not a winging it girl. I mean, you can
Yeah.
hand me a mic and I can hold a conversation if I'm on somebody else's show. But if you put me like on my channel, winging it doesn't exist. Okay. It
Isn't
doesn't.
that weird how
Okay.
that works?
Yeah. But like, because people I panel with, they'll tell you, oh, you're great. Like we could toss anything at you and you take it. I'm like, yep. Like, I'm great with that. But it's because there's no pressure on me. I just have to give you an honest answer about what I think. And I'm fine with that. I'll talk about anything. But if I
Right.
have to actually prepare the content and I have to worry about like, the facts and misinformation and all of that, then oh, here we
There
go,
it
Vic.
is.
We're out. Here we
All
go.
right.
Thank
Please
you,
be
Beck,
seated.
for coming up.
Yep. No problem. She's doing some serious thinking right now.
Vote now
In the
before she
matter of
puts in
State of
her
South
opinion.
Carolina against Richard Alexander Murdaugh. 2022 GS 15-00592, 593, 594, and 595. The following constitutes my ruling on this matter from the bench. This order will be supplemented, as I will explain, after proposed formal orders are received from each side in this matter. This case is unique in my 20 years of experience as a lawyer and my 35 years of experience as an active justice of the Supreme Court and a senior active trial and appellate judge. Usually matters involving possible improper contact with or conduct of a juror arise during or shortly after the trial. The judge then puts the affected juror or jurors under oath, conducts an examination, and rules on the request for a new trial or a mistrial. In this case, I was appointed almost 9 months after the trial to replace the trial judge who was recused. It is now almost 10 months after the verdict was rendered and sentence imposed in this matter. It is now on appeal to the Court of Appeals. Several months after the appeal was filed, the defendant moved that his appeal be suspended and this matter be remanded to the trial court to consider his motion for a new trial on a charge that the clerk of court for Colleton County tampered with the jury by expressing her opinion to the jurors about what their verdict should be and about the credibility of the defendant who had elected to take the stand and testify on his own behalf. Since this matter has been remanded to me, I have set the matter for a pretrial and a final hearing, conducted a telephonic status conference with the attorneys for the parties on December the 21st, 2023. I have received briefs from the parties. I conducted a pretrial proceeding on January the 16th, 2024, in which I invited briefs and arguments by the parties and by the attorneys for certain of the jurors and for the clerk of court, Rebecca Hill. On Friday, January the 26th, 2024, I conducted a hearing on this matter in which I took testimony from one of the jurors. The conduct of the examination conducted solely by me. I received further argument from the attorneys for the state and for the defendant. Today, January the 29th, 2024, I have taken sworn testimony from the remaining 11 jurors who rendered a verdict in this case. This examination was conducted solely by me. I have found no case that provides otherwise in the many cases I have read on the subject of a motion for a new trial on the basis of after discovered evidence of jury tampering or misconduct. I have also received sworn testimony from the clerk of court, Rebecca Hill. Direct examination was conducted by Deputy Attorney General Creighton Waters. Cross-examination was conducted by Defendant Attorney Richard Harpootlian. I have also propounded questions myself to the clerk of court. I also received testimony from the clerk of court for Barnwell County, Rhonda McElveen, who attended most of the trial and assisted the clerk of court for Colleton County. I've also received testimony from the remaining alternate juror who was, when the matter was deliberated, dismissed from further service. The following is my ruling on the defendant's motion. The standard of proof. The state contends that in order to prevail, the defendant must show, one, that the clerk of court made an improper comment or propounded an improper question to the member of the jury, to a member of the jury who rendered the verdict. Two, defendant must further show that Ms. Hill's improper comment or question actually influenced the juror's verdict, citing State v. Green, State v. Aldrett, and other opinions of our Supreme Court and other authorities. Defendant contends that he must show only that an improper question or comment was propounded to any juror by clerk of court Hill. If so proved, the defendant contends that the motion for the new trial must be granted. Defendant relies on United States v. Rimmer and many other cases. My ruling is this. On the law, the defendant has the burden of proving both the fact of the improper comment or question by the clerk of court, Rebecca Hill, to a juror or jurors, and two, prejudice suffered by the defendant, specifically that the Hill improper comments to the juror or jurors influenced the juror to vote to convict defendant Murdaugh. The facts. Did clerk of court Hill make comments to any juror which expressed her opinion of what the verdict would be? Ms. Hill denies A, and so the question becomes, was her denial credible? I find that the clerk of court is not completely credible as a witness. Ms. Hill was attracted by the siren call of celebrity. She wanted to write a book about the trial and expressed that as early as November 2022, long before the trial began. She denies that this is so, but I find that she stated to the clerk of court, Rhonda McElveen, and others, her desire for a guilty verdict because it would sell books. She made comments about Murdaugh's demeanor as he testified, and she made some of those comments before he testified to at least one and maybe more jurors. Did Clerk of Court Hill's comments have any impact on the verdict of the jury? I find that the answer to this question is no. Each member of this jury took their involuntary assignment very seriously. They obeyed the instructions of the court. They obeyed their oath. These good and decent citizens of Colleton County stood to their duty and rendered their verdict without fear or favor. It was a difficult task. 11 of the jurors very unconditionally said they either heard no comment, or if they heard a comment, it had no effect. One juror was ambivalent in her testimony. She was then examined on her previous affidavit, in which she said the effect, if any, that she had was pressure she felt from other jurors. The cases are myriad that pressure from fellow jurors is a part of the normal give and take of jury deliberations. The court is not to inquire in any way about what is said in those deliberations. But the juror, who was somewhat ambivalent, said on her oath at the time of trial twice, and said on her oath before me in these proceedings that she stood to her oath. The clerk of court allowed public attention of the moment to overcome her duty. I have read the entire transcript of this lengthy trial, not an easy task. I have studied in detail all of the authorities cited. I have independently researched the case law, learned treatises, and scholarly articles on the subject. Although there is certainly a split in the federal circuits and in the states on the standard of review, I simply do not believe that the authority of our South Carolina Supreme Court requires a new trial in a very lengthy trial such as this on the strength of some fleeting and foolish comments by a publicity-influenced clerk of court. This is a matter within the discretion of the trial judge, and I am the trial judge at this moment. I do not feel that I abuse my discretion when I find the defendant's motion for a new trial on the factual record before me must be denied, and it is so ordered. I will file a fuller order which denies this motion on the grounds I have recited on the record before me as a trial judge and the authorities that have been cited by all parties in this matter. To that end, I will hold the record open. I direct that within 4 business days of receipt by the attorneys in this matter of a transcript of these proceedings, a proposed order by the state denying the defendant's motion for a new trial with citations be sent to me and to opposing counsel. I will allow the defendant 4 business days from receipt of the state's proposed order to lodge objections and or submit an alternative proposed order. Upon receipt by the court of all proposed orders, I will finalize this record, submit a written order, and I will at that time transmit the written order to the Court of Appeals, the court which has remanded this matter to me. This hearing is adjourned.
Thank you, Your Honor.
Thank you. Let me say this, and I should have said it before I began my order. Hey, members of the audience, would you just be patient with me for one more minute? Please keep your seats. I have probably had more experience with trial and appellate work than anyone else in this room for many years. And it has been an absolute pleasure to receive from these learned lawyers some of the best briefs I've ever received. I know they're a product not just of the attorneys who presented to me, but of the attorneys who sit with them and help compose the research and the writings that I received. I know that I put you on a very tight timeline, but my feeling is these matters are best disposed of by the trial judge in a very timely manner, so that you may then go to the authorities that really count more than I do. That is, the appellate authorities who will decide what the standard in this particular matter is. I've not seen a case such as this before. I doubt whether our appellate judges have seen a case such as this before. And they will take a lengthy time to study the record in this matter, the record in the part remanded to me. There are many issues in this case, issues over which I have absolutely no authority whatsoever. But I will say this about the record now that I have read it. And I will say this about the testimony that I heard on Friday and today. Judge Newman said it best in his sentencing when he discussed the weight and the measure of the case presented and testimony and evidence submitted in this case when it was tried. It is a very compelling case supporting the verdict that the jurors reached. He said it with a lot more detail than I do, but now that I've read the record, I say, as the successor trial judge, I agree that the evidence was overwhelming and the jury verdict not surprising. This matter is now adjourned.
Oh, I like her.
I am so impressed with her. I am so happy to be wrong. I've never been so happy to be wrong in my life.
Right? Yeah, I really thought they were going to give it to him.
I really did, because I thought it was a matter of point that one juror said. But you know what? She brought up a valid, fair point that I completely overlooked. The fact that, well, when she did mention that she was pressured by other jurors to change her verdict, that mattered more. And so basically what Becky Hill said had absolutely no influence on her, whatever. She was going to be influenced by the wind blowing, is exactly basically what the judge was saying. That she was influenced no matter what. And it wasn't really Becky Hill that did it, that she was a wishy-washy juror and she was getting pushed around anyway. And basically the testimony didn't stand up to the weight of being prejudicial. And that was the key word there.
Exactly. And like the judge said, there's always pressure from other jurors. That is part of the process. And so for her to say, well, I got pressured by the other jurors. So of course that's you're 12 people in a room that don't know each other trying to figure out what's right from wrong, and what really happened. Of course there's going to be some pressure here and there.
And I would like to see that most of us was wrong in both of the polls. I put up a poll after the first juror testified and actually admitted to being influenced. And I was like, okay, it's done there. Like, why are we even going on? She just said she was influenced, right? And I really stuck by that. But then we go through the whole thing and she's right. Although I was really disappointed in the state's argument. Waters really disappointed me,
Oh, really? I missed that.
Yeah, because he said 11-1. Like there were 11 said it was okay and 1 said it wasn't. Like we should go with the odds, basically. And I'm like, you don't go with the odds with law, dude. The law, it's black and white. Like he really disappointed me. I was like, no, anything but this argument, okay? How about pick on her credibility, which is what the judge did, the credibility of what the woman was saying, okay? And what she believed as the strength of her conviction as to being influenced. She just didn't believe it was there, But man, this was a long day, Oh my God.
Yeah, but I
Thank
like
you.
that judge though. She was really like, doing it by the book, and all the experience she has, she's amazing. Like
She is.
that is a
I have a
lot of
link.
55 years total in law.
Yeah, I
That's
have a
great.
link down there on Get to Know the Judge. I was so impressed when I heard who was going to actually be sitting this hearing. And actually, Dick, this is one of the, as antagonistic as Harpootlian was with her, this was his pick.
Yeah.
She was top runner on his list for judging, because they talked to them all like, who would you, let's get a pool of judges together and we'll pick from that pool, because she's retired Supreme Court for the state. Okay. And he's got a lot of experience with her. He's been around a long time. She was a trial judge at one time.
Oh, so Harpootlian chose her and she ruled against him. Well, good for her.
Well, he was
Good for her
recommending
for not
her.
being
He said
influenced.
he recommended her, and he said a lot of really nice things about her. He doesn't have anything bad to say about her judging, but they are
Nice.
like, and the fact that she actually addressed the issue that this is beyond my scope as a trial judge. Like right now, I'm not a Supreme Court judge. I'm a trial judge here with this hearing. Okay.
Right.
And I'm doing this hearing here for this. And I would say this is my ruling, but I definitely think that there's no precedent for this case. And you need to take this to the appellate court. She basically laid it out to them. Take it to the higher court. You've got every reason to take it to the higher court because this has never happened like this before. And this would be a very important case for the future to get the appellate court to settle it. Yeah.
Yeah, because it's going to lay out laws and points of view on this type of thing for the future. Absolutely.
Yeah. Like, no, this is just so fascinating. I can't tell you what today has done to energize me with true crime. Like I've been feeling under the weather, and this just maybe because I didn't have to talk too much, in between.
You got to hang out and listen all day.
Yeah, and hang out with everybody in the chat and just like talk back and forth. It was like the best of both worlds,
Right. Right.
But thank you so much for keeping me company for the last part of it, and thank you for Kelly from Justice for Marilyn Manson, and thank you for everybody in the chat who kept me company and gave us good opinion and talk and things to go back and forth about. I just love this part of it. I'm glad you all do too. Based on the polls, you all want us to do more hearings, not just trials. So if there is another one on this, we'll do it. But there won't be another trial so far. We got a bit of a wait.
Tell them I said to start at 4 p.m. Eastern so I can watch it.
Thank God for replay, Beck. Listen. The one thing I will say is my content. It survives the test of time. It does. Like you don't have to watch it in any particular time. Like I know people that watch me at like 2 a.m. in the morning and send me a message at 5 a.m. Like, what the hell was that, Claire? Like, don't wake me up and ask me what was that.
What the fuck?
I am not kidding. I am not kidding, Beck. I get more of the what was that, Claire? Like, what was that? Like, I get that message from somebody at least once a week, and it's always somebody different too. It's not always the same person, but like, I'm open for it.
Yeah,
it was.
same.
It was. Aaron says, "Okay, wait." It was telling that she said that there was an abundance of evidence to his guilt. Exactly. She said, like,
yes,
he's not exactly. It's not that he's innocent that he deserves a retrial. It's a matter of procedure, in a matter of law, in a matter of protecting others' rights. Like, we're not really so interested. Well, we should be interested in his rights as an individual, but not as the murderer. Like, I get it. It's kind of hard if you've gone through the trial and saw everything,
Well, yeah, and she's right. The evidence that was laid out in the original trial, it was just so damning for him. There's no one else that was around there. There's no one else that could have done it. There's no one else.
Hold on 1 second. I want to bring up Harpootlian because he's making an asinine statement, and we just like, why not, people? We heard all the rest.
Next level. Next, we go from here to the
Of course he's going to appeal.
And then
of course he is.
The Supreme Court, if necessary, or southbound Supreme Court, and then federal court.
I have to be honest with you. I didn't really believe the whole story with Becky Hill until today's testimony, and I have to tell you, it did sway me quite a bit, because I didn't believe it. Explain to us how you found out this information.
Go ahead, Jim.
You're being honest.
Oh, we could talk over them. I'll go through 8 hours a day just to be able to talk over Jim Griffin and Dick Harpootlian.
You know what I wonder though? I wonder why they're doing this because we all know that the Murdaugh family has no money because he had to pay everything back and he didn't have enough money to pay back half of it. So
Oh, I know why.
are they doing this pro bono? Or are
It's
they
as
doing
obvious
this
to me
because
as no. Right there, Dick Harpootlian is a senator. He's running for office in South Carolina. He has a presence legally
it.
and politically. Jim Griffin just started a podcast on true crime. Philip Barber is looking into technological law and starting a new law firm. This is all about the PR of a high-profile case. It ain't the
Okay.
money. It's the
Yeah,
visuals.
Liam just said the
That's
same
why
thing. It's political.
everything they
Yep.
do is in front of a camera. Everything they do is in front of a camera. Everything.
And that's what we did.
Yeah.
And that's how we proved.
Because he's trying to save the golden boy of the state so he looks good on the ballot. I get it.
She said for the siren call of
Publicity and money to
Publicity and
sell a
money.
book. I mean,
Right.
We were,
Just because Becky Hill was shady, and yes, she was self-serving shady. That's her name. I gave it to her. That right, Pete? Like that's just Becky Hill's name from now on.
Triple
She
S.
is Miss Self-Serving Shady. She was all sides of wrong, but was it prejudicial? I think the law is on Judge Toal's side. I'm going to believe her. She knows the law. Okay, from
Yeah.
everything that I've seen, and just from the law that she dictated to prove it in what she said, I do think she had every right. I do. But
Yeah, and she's been looking, like she said, she's been looking at this stuff for what, like 7 months now or something, and going over
Exactly.
it and asking all the right questions. She talked to everybody. I feel like she did a thorough job.
she really did, and she wasn't messing around in that courtroom. I got to tell you that. The whole Shady Hill thing is irrelevant to the final decision. Exactly, Liam. But you see, that's what they're talking about here too. All they have is the shady part of it with Becky Hill. But they didn't prove their case for prejudicial. But they're going to take it to the appellate court, and the appellate court will decide. But the appellate court isn't really going to care about Becky Hill that much either in her book deal. I can tell you that. We all care because we know that she probably had motive, and she probably did. And she probably was acting shady. Okay, but it's a matter of, was the jury process violated?
Affected, yeah, and I don't think it was affected by it.
Yeah.
Yep, I agree.
The judge says not enough. It was obvious there was something there, but it wasn't enough.
Yeah, and she read off the law saying, it has to be this and this, and it just wasn't.
And it is a standard of presumption. So it's either going to be decided, in my view, in our favor in our appellate courts, or 4 or 5 years down the road in the federal court, unless there's a change of federal law.
Yeah, but the point is, Alex Murdaugh is going to sit in jail that whole time, and you guys are going to work for nothing, and I'm fine with that.
Yes.
Yeah.
4 or 5
Yeah,
years.
you want to be idiots for free? I'll watch.
Absolutely. Yes.
Absolutely, because he's not going to get off on this murder, even if we have a retrial. Although I do have to say that the evidence was there. It was mostly circumstantial, and you know that, Beck, right? Besides that video.
Well,
we
yeah,
really
but
don't have
I
enough.
feel like the big clincher that really got him is that there was no one else around in the area, and there's no one else that could have done what he did. You know what I mean? And because he had to know where things were in the house, where the guns are, where this is stowed. The fact that things got put back and guns disappeared and all this stuff, that doesn't just happen by accident. And nobody's gonna drive all the way out in the middle of the country and steal your guns out of a house.
And it doesn't even matter. The only evidence that they had that he could not refute or argue away, which I think was the deciding factor, was the video. He was there within seconds of them getting killed.
Exactly
There's no
my
doubt
point,
about
and
that.
no one else was there.
Well,
There was
even
no
if there
other-
was anyone else here, he's not saying who it was, and he would obviously know who it was. And he's
Well,
not,
that's what I'm
so-
saying. If there was someone else, he would have said, "Well, Fred was there," or whatever the
And
person's
he
name
did
was.
it, right? Yeah, Fred did it.
Right.
I'm
So
too
there was no
scared to
one
tell
else
you.
there
Right.
to do it. It's just
Exactly.
yeah. And that makes all the circumstantial just not circumstantial anymore, really.
Yep. All right. Let me get back. Let me just get these guys back off now. All right. I just had to hear. I knew they were going to come out and say that. Like I knew it. I just
Yeah.
knew they were going to come out and say, we're going to take it to the higher court because we won our argument. No, you didn't. She said, take it to the appellate court because federal has a different standard. You did not win your argument here. And I agree with Aaron and Liam that Waters
I was
really
just gonna say that.
didn't
Yeah.
really get his argument across either. I did not like that 11-1 thing. I did not. Although it seemed away with the judge a little bit because she was like
Turtle.
the proponents of the jury. The jury, actually wasn't tainted, is her opinion.
Nah, Turtle, I'm pretty sure if Bubba would have shot somebody, he would have shot Alex and not Maggie. And
he liked
oh,
Maggie a
shit.
lot.
I just lost the other guy's name. What the fuck is his name?
Paul.
What's the Paul? Thank
Maggie
you.
and Paul.
Yeah, Paul.
Yeah. But Paul was
Yeah,
the younger
he
son.
liked them. He would have shot Alex, not those two.
He was very fond of Paul actually because Paul took him duck hunting and stuff like that. And Maggie always gave him a free pass for chasing the chickens, but Alex was mad at him for chasing the chicken. Remember? Because they corrected Maggie about whether it was a chicken or a pheasant or whatever it was.
Yeah, it's a guinea.
But anyway,
it's a guinea.
It was But anyway, who is this? Oh, don't tell me it's John. Hold on. Oh no.
Yes, there was one juror.
All right. We got another one.
Her veracity in whatsoever.
Oh no, it's Eric. No. We don't need to. No. Okay. No. All right. Sorry, guys. Not to be rude, but he is actually defending some of the jurors. All right. And I don't need to hear from him because he's just going to get up there and attack Harpoolian. And I don't want to get into that. Like those two have been attacking each other on Twitter and everywhere. Even in the courtroom. He was like, Your Honor, could you make Eric Brandt sit somewhere else? It was almost like he's looking at me.
What?
Mom, he's looking at me. Make him stop looking at me. I was just like, what the heck? I just found that part humorous. I did. And now I am really overtired, guys. So I'm going to call it. Beck, thanks for coming up.
Thanks for having me.
I'm gonna drop you now, and I'm gonna play my outro, my very much longer outro that used to be my intro that I love. Thank you, Mocking Media. I still love every second of it. I'm gonna
It
fight.
is awesome.
I'm gonna fight YouTube and the popular opinion that I need shorter intros. although we did compromise and make a shorter intro, like it's only 45 seconds, but we made it out of the original content. Mocking's a genius. I don't know how he did it, but he did it.
Well, peace out, everybody. Take care.
Yeah. Thanks so much, Beck. I'll talk to you soon. Okay.
Yep. Peace.
All right. So, anybody, I'm going to be back tomorrow. Now that we don't have to do the trial in the morning, I've got a Boone update for you. Like, buckle up, buttercups. Like, put on your waterproof panties. You're going to be laughing your butts off. All right. I will see you all tomorrow night. Barring any other things going, my voice is holding up. I'm really excited. I hope you enjoyed the chat. I certainly did. Okay. And yep, there you are. Sorry, Beck. I just went to push the button and there you went. All right. So everybody, I will see you tomorrow night. I'll be putting up the stream soon for that. And I hope everybody has a great night. Thank you all for hanging out. Don't forget to like, share, and comment. Please hit the back of the videos. That commenting really does help, especially if it's even just 5 words. That's all it needs to be. And it really does help with the algorithm, and it helps get more of this true crime out there. If you have ideas about merchandise, please send them my way. If you have ideas about cases or questions, send them my way. On that, thank you all for joining me, and I will see you tomorrow night.